Michael. I work with the Metro Codes Department, and today I'll be presenting each of the cases to the board for their consideration in the public hearings. At this time, we would ask, as a reminder for our board members and of course for all the audience members as well, please silence your phones, your tablets, or anything else that's going to make noise so that the board's proceedings are not interrupted, and the limited time available to the appellants and speakers in opposition will not be interrupted either. For today's public hearing, each of today's public hearings, the board reviews the correspondence that's been submitted in support and in opposition to each of the cases. The board also reviews correspondence and recommendations from other government agencies, and in some cases even the elected officials, with regard to the hearings. In each of today's hearings, staff will present the site plans, maps, photographs, and other documents that comprise the case record, each for the board's consideration. At the conclusion of the staff presentation, the appellant will present his or her case to the board. After the appellant's presentation, the board would hear from those wishing to speak in support of the appeal that's been filed. If, in fact, the appeal has opposition, the board would then hear from those who wish to speak in that manner. After the opposition presents their testimony, the appellant would have a period of time for rebuttal out of their originally allocated time. Under BZA rules of procedure, the appellant has 5 minutes for presentation if no opposition is present. Contested cases allow 10 minutes to each side. Of note, that is a shared 10 minutes for all who wish to speak, whether in support of or opposition to a case. At the conclusion of each hearing, the board will deliberate and then vote on the case in question. The board is vested with the power to act on these cases pursuant to the terms of the Metro Zoning Code, specifically Section 17.40.180. Each of the code section numbers that we refer to today come from the Metro Zoning Code, which applies to the entire jurisdiction of the metropolitan government. The Zoning Code was adopted by the Metro Council and then became effective on January the 1st of 1998. I'll introduce the entire Zoning Code and make it part of today's record for each of the cases. The Metro Code requires a record of these proceedings. Because BZA meetings are recorded for Metro Channel 3, it is imperative that anyone wishing to address the board come forward, step to the microphone, introduce yourself by name and address, and then make the desired presentation. Comments not made in that manner will not be part of the record and thus have no bearing on the case. The Metro Code requires 4 of our 7 board members in order to establish quorum. The code also requires at least 4 affirmative votes to grant an appeal. In the event that 5 or more members are present, and the appeal fails to receive 4 affirmative votes, then the case will remain on the board's agenda for the next 30 days. Applications that fail to receive 4 affirmative votes within 30 days of the public hearing shall be deemed denied by operation of law. In light of the fact that no one will remember that explanation, I'll repeat it again if it becomes relevant during today's proceedings. Pursuant to board rules, an aggrieved party may appeal board decisions to the Chancery Court of Davidson County within 60 days of the hearing date. Additionally, an aggrieved party may file a motion for rehearing under the terms of the BZA rules of procedure within 60 days of that same original hearing date. After that time elapses, the board's decision becomes final. No further action can be taken. For the appellants, if your appeal is in fact granted, it is imperative that you obtain the permit for which you applied. A board's granting of your appeal is good for 2 years. After that 2-year period, you will be required to come back to the board for the same approval that you previously obtained in order to obtain the permit that you seek. It should also be noted that if false or misleading testimony is presented to the board, then any board approval could be revoked at a later date by means of a show cause hearing before the BZA. Mr. Chairman, I would submit that all the cases have been filed in the proper order. All appellants have been notified by certified mail, and all legal notice requirements have been fulfilled. As preliminary announcements, we have 4 cases from today's final marked agenda that was posted earlier this week, items that will be deferred to a later date. The first such case is 2018-154. That is a case involving an appeal of a short-term rental matter for the property at 1616 Glen Ridge Drive. That matter will be deferred 1 meeting to May the 17th. The second case that has been deferred is 2018-158, also a short-term rental appeal involving the property at 4707 Nevada Avenue. That case will be deferred 1 meeting to May the 17th. The third case marked for deferral is case 2018-173, involving the property at 918 19th Avenue South, a request for a setback variance and a column height variance. That case has been deferred indefinitely while we continue to work with the appellants on what their appeal will in fact be. And finally, case 2018-183, involving the property at 455 Humphrey Street and its multiple variance requests, deferred 1 meeting to May the 17th. None of those cases will be heard today. So for the benefit of the members of the public who are in attendance, cases 154, 158, 173, and 183 will not be heard by the BZA today based upon the deferrals. Our board uses a consent agenda. One board member reviews the record for each case prior to the hearing and identifies those cases where appellants met the criteria for their requested action. If that reviewing member determines that testimony in the case would not alter the material facts of the case, then that one will be recommended to the board for its approval through this consent agenda process. We will enter into the record those cases that have been so recommended, and if anyone is here in the audience in opposition to one of the cases identified for the consent agenda, please raise your hand and the case will be removed from the consent agenda and heard in its regular order. Mr. Chairman, there are 3 cases identified for today's consent agenda, and they are as follows. First, case number 2018-172. Emily Johns, the appellant, on behalf of Aspen Development, the owner of the property at 917 and 919 South Street in Council District number 17. It's a variance request involving sidewalks. The parties have agreed to follow planning's recommendation with regard to this case. Is there anyone here in opposition to case number 172? Seeing none, that case will stay on the consent agenda. The second case for consent agenda is 2018-175. Peter Conrath, the appellant and owner of the property at 414A, 36th Avenue North, has a variance request for side setback variance. The parties involved in this case have worked extensively with the zoning administrator to reach an agreement on how best to proceed, and it has been determined that this case, too, is eligible for the consent agenda. Is there anyone here in opposition to case number 175? Seeing no one, that'll bring us to the third and final item for today's consent agenda, which is case 2018-182. Middle Tennessee Ford Collision, the appellant, on behalf of the property at 419 Spence Lane, a request for a variance from sidewalk requirements. This consent agenda item would in fact meet the Planning Department's recommendation for this case. Is there anyone here in opposition to case number 182? Seeing none, Mr. Chairman, we have those 3 cases, 172, 175, and 182 for the consent agenda. Staff would solicit a motion and vote with regard to that consent agenda.
Okay, those following cases have all been moved to the consent agenda. Is there a second? Motion's been made and properly seconded. Any discussion about the consent agenda? Seeing none, all those in favor signify by saying aye. Aye. Opposed? Passes unanimously. John Michael.
Mr. Chairman, we always love to use the opportunity to recognize elected officials who have taken their time to come and join us for BZA meetings. Unless you've got a keener eye than I have, this is the rare occasion where we are not joined by a Metro Council member.
Well, I would, as we start the meeting, let's start off by saying that the BZA normally meets on the first and third Thursday of the month. We lost a meeting last month because of the election. And as you know, there's an election for mayor in District 1 going on right now, so please go early vote. Howard School is where we normally, in the Sunny West room, so instead of us being there, voters hopefully are there casting their ballots. So would like to thank the staff for organizing this and bringing everything over here, and of course the Metro Nashville Network for televising us. It's very important that these meetings be open to the public and also broadcast live and repeated, and they also have a great Facebook Live too if you follow the Metro Nashville Network. And we need to be a place that's convenient and has parking too. So we appreciate all of you all coming here to this different location, and we'd like to thank the Metro School Board, Dr. Anna Shepard is the chair, and of course Dr. Sean Joseph is our school director. So thanks for being here, and let's get started.
And Mr. Chairman, with that, we'll remind everyone, those who were passed on the consent agenda, your case will not be heard. You have been approved. Please see code staff tomorrow at the earliest in order to pursue the permit for which you've applied. And for those who are here on cases that have been deferred, they will not be heard today. Feel free to stay if you wish. Feel free to depart if you wish. With that, we'll queue up the first case for public hearing, Mr. Chairman.
Okay.
Case 2018-144 is brought by James Webb, the appellant, on behalf of STD Properties, owner of the property located at 1016 13th Avenue South, not too far from here. The request is for a variance from sidewalk requirements in the R6A zoning district as shown on this zoning map. condition of the property shown here from the aerial photograph of the tax assessor's website gives you some idea of the layout of the property between one older developed lot and one newer developed lot. From my recent site visit, which is a polite phrase for yesterday afternoon, you see the face of the subject property, the stone wall that's in place, and the elevation leading into the property. The view up and down 13th Avenue South shown here in the two slides above. Again, James Webb is the appellant and will have the opportunity to make the desired presentation to the board with regard to their sidewalk variance request. In advance, we'll ask, is there anyone here in opposition to case number 144? Seeing none in the public, we will point to your case file. I believe you have feedback from the district council member as well. But with that, we'll invite Mr. Webb or the appellant on behalf of the owners of the property to make the case. Please come forward and introduce yourself by name and address.
And please sit over here in these chairs over here.
My name is James Webb. 160,
Your address, too.
my address, 162 Hickman Highway in Hickman, Tennessee.
Okay.
You saw the pictures. My hardship is that we have a 5-foot retaining wall built of rock, several years old. According to new sidewalk standards, I must tear this wall out and move the sidewalk and the wall back. The reason I'm seeking a variance is because removing and replacing the wall will result in, I believe it will hurt the visual integrity of the subdivision. It will create an offset in the sidewalk and the retaining wall that will never be straightened out because, as you can see, the two houses to the left of the property were built last year, so they beat the variance, so therefore the wall runs straight past their properties. And then thirdly, it could damage the structural integrity of the wall at both property lines to my left and to my right. It's not like tying into a block wall or a concrete wall where you can just drill, pin it, hold it very well. It's a little more tricky than that. So those are the three reasons that I'm seeking a variance, and I'm asking also to not have to contribute.
Okay, so we have a recommendation from Colby Sledge, who's the council person for the 17th District, and he is for this variance, but believes he will support it if you pay into the in lieu fund. So why not pay into the in lieu fund?
Have to then.
If you didn't pay into the fund, would you be willing to give the right of way for any future sidewalk that the city might put in if the city took that on themselves?
Sure.
Curious.
Okay. So any questions for the applicant? Okay, anything else to add? Okay, going to close the public hearing. Discussion. So we have the councilperson's recommendation who supports this if he pays into the in lieu fund. So discussion.
I agree with the councilman on that.
Okay. Anyone want to have a motion?
Okay, there's no other discussion. I'll move that we approve the variance request and allow the applicant to pay into the in lieu fund.
Yes. Okay, motion's been made. Is there a second? Motion's been made and properly seconded. Any more discussion? Seeing none, all those in favor of the motion signify by saying aye. Aye. Opposed? Passes. Good luck. John Michael.
The next case is 2018-145. This involves the property owned by the appellant, Gary Stump, located at 6114 Licton Pike. The request is an Item A appeal involving the denial of a short-term rental permit.
John Michael, before we get started on all this, and I know we have a lot of short-term rental cases in front of us today, could you give us the kind of 101 of why we hear these cases and kind of why they're in front of us?
The shortest version is that the short-term rental ordinance codifies that regulation under the zoning code, specifically at 17.16.250, subsection E as in Edward. So because items under the zoning code are eligible for appeal, and those appeals must go to the Board of Zoning Appeals, although it may seem a little bit not entirely intuitive or logical, this is where those appeals go. So when there is any action of the zoning staff, whether it be from the zoning administrator, myself, or any of our employees, that action or inaction is subject to appeal, in this case via Item A appeal under the zoning code, 174180A, 2, the Board of Zoning Appeals to determine whether or not the zoning administrator or his staff acted in error by denying or
okay.
approving something.
So, John Michael, for those of us who did not go to law school, or people that did not go to law school, these are cases that have been found in violation of the law, and then how did they wander to here?
Because if you want out of the problems that you got, this is where you come get out of them. That's the shortest version, Mr. Chairman.
So
basically, the appellate right brings you here to the BZA. Many of the cases that you see out of the next 18 cases, I believe all 18 of them are short-term rental cases to be presented to the board. The majority of those are scenarios where someone operated before they obtained the legally required permit. That, by law, requires a 12-month waiting period before you're allowed to apply again.
That's a violation of the council law on short-term rentals.
That's correct. Not any sort of internal guideline at codes, but in fact the city law as passed by the Metro Council. This is where you have the opportunity to have that 12-month wait period reduced. And the select few cases that we see from the short-term rental world that are not that fact pattern of prior operation, subsequent denial, maybe it's a change in ownership question or some other challenge to an application of the law. That still is an item A case that the board determines whether or not the zoning staff acted in error with regard to whatever action or inaction was brought forth with regard to that short-term rental project.
So all these cases have been found or most of them in violation of the law, and they have a year punishment in front of them.
That's correct.
And they're here to ask for less.
That's correct. Whether it be 0 months wait period before applying again or 11 months, something less, because the status quo for everyone in those scenarios is they're presently sitting on a 12-month wait period, counting back presumably to the date of application to go to the board, or at least to the date of the cessation of the violation.
Okay. Thank you. Please proceed.
Case 145 at 6114 Licton Pike is just one of those appeals. Prior operation yielded a denial of the permit application. The aerial photograph here shows you the layout along Licton Pike up in Council District Number 3. From the assessor's website, picture of the face of the property. As noted, Gary Stump is the appellant and owner of the property. Mr. Stump will is there anyone here in opposition, I should ask, to case number 145? Seeing none in the audience, Mr. Stump will have 5 minutes to make the desired presentation. Please come forward to the table to my right and address the board after identifying yourself by
I
name
think
and
we're going to hear
address.
from Mr. Osborne first about this. Mr. Osborne.
Mr. Stump, you can.
Oh, you could still stay there. So, how'd you hear about this? Is there any other violations besides not having a permit? And is there any other information that this board needs to know about this particular case that you know about?
So on October 27th, we sent a notice through host compliance because the property was operating without a permit. Whenever I rechecked it on January 5th of 2018, the advertisements were up, but at that point the calendars were all blocked. Purity had tried to come into compliance, he just didn't take the advertisements down. So we issued a warrant to make him remove the advertisements, and now we're here today. To my knowledge, there aren't any other complaints. There hasn't been any more operation.
So, Mr. Osborne, I'm sure we'll hear the name host compliance a lot today. Tell us about that, why we use it, and what they really do.
It's a third-party program that we kind of hired to help us go through.
The Metro Council passed a bill to kind of, allow us to have this software to kind of identify people that are advertising on short-term rentals.
Yes, sir.
And they don't have a permit. So there's a database of people who are posting on all these short-term websites, and then we have a database of people that actually have licenses. So they kind of match these.
Yeah, it's all one and the same. So they go through these websites and identify as many of them as they can, and then they put that in a database for us to go and look into.
And so we don't have, a huge staff of short-term rental investigators. So this has been a good help for you to find violators that you would not have found before?
Yes, sir. It definitely speeds up the research part of it on our end.
Okay. So any other questions for Mr. Osborne? Okay. Thank you. Let's hear from the applicant.
I'm Gary Stump, and I reside at 6114 Licton Pike. First of all, I just want to say I apologize for operating without a permit. That was not out of defiance, but just sheer ignorance. I was unaware that a permit was required. And I humbly request that you grant me permission to apply for a short-term rental as soon as possible. I'm retired now, living off Social Security in a very, very small pension, and this goes a long ways towards me being financially in financial good shape so I can pay property taxes and other expenses.
So, Mr. Stump, how many times did you rent this?
I started on February the 2nd, 2017, and I've got a sheet here if I can find it. A total of 90 days, and I would guess about 30. You want me to count them? It looks like
No,
it's
no,
about 30
Mr.
different rentals.
Mr. Osborne, does that sound about right for what you have in your records, how many times it was rented?
I'm showing it's 54, it goes back to 2016.
Okay. So, continue.
Okay, well, that was really all I had to say.
So, oh, go ahead.
Have you paid your back property taxes? I mean, your back hotel and sales tax?
No, sir, I didn't know that was a requirement, but I've got the sheet here.
Okay.
And
You don't have to do
how
that
much
for
that
today.
would
You'll have to
be.
do that before you get your permit.
Now, I'm showing that would be,
And this is owner occupied. This is your home.
yes, sir.
So, why didn't you know about these laws?
I don't know, sir.
How'd you hear about it? Short-term, it's Airbnb, right? What-
Yeah, that's
okay.
who I was operating. Yes,
So
sir.
how'd you hear about this?
How'd I hear about Airbnb? My wife had mentioned it to me as something I should look into and check out.
And so what did you proceed to check into or look out?
Well, I just went online to the Airbnb website and, made up all the descriptions for the property, photographs, and just proceeded to, make it as attractive as possible on Airbnb. We went out and purchased and bought additional furniture for it before we started. And I was just busy getting it up and operating. And again, I apologize for being.
I guess
good.
The code staff has said that the first they checked it, I guess, on January 5th, and everything was blocked. Have you rented it since January 5th?
No, sir.
Did you rent it? When was the last time you rented the property?
Let me get that out and keep it out. November 24th, 2007. No, excuse me, last day, November 26th, 2017.
Okay, great.
So you got this letter. So what did you think when you got this letter from the city?
Well, I was shocked. But when I got the letter, I immediately spoke with Tamara. I assume she works in codes. Shortly thereafter, I came down with pneumonia, was bedridden for 5 weeks, so I didn't do anything during that period. And then next, I went up thinking I was applying for a permit. I had all the neighbor notifications, the affidavit. I can't remember all the requirement, the layout of the property. I had all those, required requested information. Went up there to apply for a permit, and I was informed that. Well, later I got this warrant and found out I needed to go to the environmental court, which I appeared at and paid the fine for that.
Okay. Any other questions?
I have a question for Mr. Osborne. When you give us the number of stays, does that equal the number of appointments, weekends, or is it individual nights?
That is based off of the reviews that we see, so it may be more nights.
Okay.
54 different people, and some of those may actually be cancellations. So it's roughly 54.
Okay.
I'm sorry, I didn't hear the number.
It's roughly 54.
Mr. Osborne, I'm sure the people in the audience and also on Metro National Network, when you speak, I know you weren't trying to talk to us, but it's probably better to sit and so we could hear you on the mic. Okay? Thank you. Any other things to add?
No, sir.
Okay. Any other questions? We're going to close the public hearing. Discussion.
I mean, to me, if I had to categorize these into kind of minor, moderate, or severe offenses, that this would be kind of on the minor phase. Again, particularly since the applicant has not rented since he was told not to. So I'm, and the fact that, I think this is in one of those, 1 to 4 month time frames, and since it was last rented in November, he's already served 4 months, and so will move that we find that the zoning administrator did not err on this case and denying the short-term permit because it had been operated prior to obtaining the permit, the applicant, based on the specific circumstances on this case, is eligible to apply for a permit tomorrow and will receive his permit provided he pays his back hotel and sales tax.
Okay. Motion's been made. Is there a second?
Chairman, that's part of it, the sales tax? I'm sorry.
If I may, and feel free to go ahead and get a second, because I know you're going to go into discussion after that, but I heard something during the testimony that we need to circle back to, and that is that he indicated that the applicant indicated that he had been to environmental court. And that he had paid a fine. What's not clear is whether or not he truly paid a fine based on a guilty plea, or was there a trial, or what the circumstances were surrounding that. The reason that's important is because the ordinance requires a 3-year waiting period in the event that he was found guilty in environmental court, a court of competent jurisdiction that's referred to under the ordinance. So we just need to get clarity from someone on the record.
Mr. Osborne, what happened?
Because he had tried to come into compliance before the warrant was issued by blocking his calendar, it was recommended by legal to dismiss it with court costs.
Okay, so it did
no
not go
fine,
down
no
as a
trial.
guilty. Thank you. Thank
Okay,
you.
we still have a motion on the table. Is there a second?
Second.
Motion's been made and properly seconded. Discussion.
I have a discussion. I just want to throw this out. I think in looking at these and the minor, moderate to severe categories, I think we ought to consider setting these from the application date forward instead of from the last date of rental, because that's when the person actually comes down to try to get their permit. And just as a matter of course, I would suggest that.
Okay.
I agree.
If you're willing to amend your motion.
Well, I mean,
Or not.
I think that was just a comment. I mean, I still would say time served, because it has been such a substantive amount of time on this one. Unless you were thinking it should be something different than.
I just think the date that the person comes down to apply is a firm date that we can always look to as to when they actually stop. They took an affirmative step. And so to me, that's a better way to look at it going forward. That's just my thought.
That being said, Mr. Taylor, what do you think about your motion?
Well, no, I mean, I think that looking forward is fine, but I still think in this case it would even given the date of March 8th when the stop notice was signed, it's still in that range that I would consider time served acceptable. And so I'm happy to. And again, we have a lot to look at today, and I think that looking at the future ones, this is a little bit unusual in that we have codes. Codes has acknowledged 1/5 is the last time, and he said it was before that. But then the firm date that we all know we can agree on is 3/8. But even with 3/8, that was still 2 months ago, and given the circumstances and his willingness or his requirement that he's going to have to pay his taxes, then to me that's okay. So I'll stick with my motion, but know that I think that's really good advice going forward.
Any more discussion?
I was going to offer would you change it to 2 months from March 8th, which would be?
Oh, yeah, I think I just said time
Okay,
based on the
but
circumstances.
what she's saying, just to make it.
Yeah, sure. Then the motion would be amended to penalty is 2 months from March 8th.
Okay, and who seconded?
I did.
Okay, is that fine with you?
Acceptable.
Okay. Motion's been updated and properly seconded again. Any more discussion? Seeing none, all those in favor of the motion signify by saying aye. Aye. Opposed? Passes unanimously. Sir, what we did was you were eligible to apply for a permit tomorrow. Doesn't mean you get a permit. We cannot give anyone a permit. So if you take your paperwork down, last time they said you couldn't, so they should be able to talk to you about your permit when you go down there tomorrow.
Okay, thank you for granting my request in your time.
Thank you.
I appreciate it.
Good luck.
John Michael.
Mr. Chairman, case 2018-146 is brought by the appellant James Bolton, who's also the owner of the property located at 1812 Elliott, shown here on the zoning map, Council District Number 17. Once again, this is an item A appeal involving the denial of a short-term rental permit based upon priors. The aerial photograph here shows the neighborhood and the face of the property here from the tax assessor's website. Is there anyone here in opposition to case number 146? There is, Mr. Chairman. As a result, both sides will have 10 minutes to make the desired presentation. As a reminder for Mr. Bolton, if you want to save some portion of that time for rebuttal, save it out of your originally allocated 10 minutes. Mr. Chairman, I believe you'll want to hear from staff first.
Yes. Okay, Mr. Osborne, tell us about this case, how you heard about it. Is there any relevant information we need to know, and how many times it was rented, and what other information you have?
So it looks like that we found out about this one through host compliance. A notice was sent out on February 9th for not having a permit. It was removed shortly thereafter. He did try and apply for a permit back on October 24th of 2017, but it doesn't appear that that process was completed.
October 24, 2017. Okay, and any other non-permitted complaints that you have in this file?
Not that I'm aware of. It looks like from our records it was rented approximately 13 times.
13. And when was the last time it was rented?
Roughly February.
Okay.
And so you don't have any evidence that it was rented or that there were any ads since February 9th, or
That is
any came in the application is the 8th of March, right?
I
Well,
don't
that's
have
what-
that right in front
Well,
of
we
me.
got
But
it
that
in
sounds
front of us. Sorry, thanks.
Okay. Anything else? Any other questions for Mr. Osborne? Okay, thank you. We're going to hear from the applicant. Please identify yourself by name and address for the record.
James Bolton, 1812 Elliott Avenue.
Okay, Mr. Bolton, why are we here today? You rented without a permit.
Yes, I did. I'm a owner-occupied. I live there. Me and my family do. We rent our basement as part of income for our family. I did go and apply for a permit. They issued me a 90-day temporary permit.
Oh, wait a minute. There's no such thing as a temporary permit. You either have a permit or you don't.
No, they issued me a 90-day temporary permit.
John Michael.
Clarification, the 90 days is the amount of time that an application stays open before it is deemed canceled as an application by law. It is not permission to operate as a short-term rental. It is the amount of time you have to complete the application process. That's valuable for a lot of people because they have trouble getting scheduled a visit from the fire marshal to confirm the eligibility, maybe getting together the insurance documents, the notices, and whatever else, so that way you don't have a one-week window to get it all done because you probably couldn't in many instances, but instead 90 days. Again, sometimes that is confusing for people, but there is no such thing as a 90-day temporary permit for short-term rental.
Okay.
Well, I was confused on that because it was never reflected like that.
How'd you hear about Airbnb, and why didn't you get a permit when you first started this?
Just the laws just kept changing so fastly. You've seen it on the news, so I just got caught up. I went and applied for an application before I was ordered to shut down. And the last step of my process was for the fire marshal to come and look at my home, and then I go pay the $50 application fee. And when the fire marshal came, I was failed, and so
You failed the fire marshal? Then?
Yes.
Because you didn't have enough smoke detectors, or where you said they would be?
They were not all synced together. I have a old historic home, so. I had to install 16 new fire alarms in my home.
And so after that, did you get the fire marshal come back out there?
Well, when I was installing alarms, I got this letter because it was a big expense to have that many alarms put in my home, all wired together.
But it's a big upside for you if you get a short-term permit. So
exactly, yes, sir.
We're not looking at how much it costs you to make your home.
But that's the
available.
reason why I didn't comply with the 90 days. So I got a letter about 114 days after I applied for the short term. I have paid my taxes, my hotel taxes, any other taxes that are owed on it, and so.
And then what the last day you rented it? When was it? It was in February. When was the last day you rented?
I'm not exactly sure. I don't have that in front of me.
About?
Yeah, about like that. Yes, sir.
Okay. Thank you.
Any other questions for Mr. Bolton? Of course, we have opposition on this case, too.
So if I understand it correctly, you rented while you were in the 90-day window?
Yes, ma'am. We did. Yes, we had 2 rentals. Yes, ma'am.
2 rentals?
Yes, ma'am.
Mr. Osborne, how many rentals happened here?
Approximately 13.
13. So when were the other 11 done? You rented
Before then, yes.
Before then.
Yes, sir.
So, other questions?
Before I got the letter, so.
Other questions? So the way this works is, if you don't have anything else to add right now, you will have this time left for rebuttal, and we're going to hear from the opposition, okay? So please go back into the audience and please come forward. The person who is speaking in opposition to this case, come forward now. And please identify yourself by name and address and why you are here today in opposition.
Hey, my name is Bertha Beatty, and my address for this session is Post Office Box 331121, Nashville, Tennessee.
Do you live near this house? You live near this?
I have property there. I will be living there
Okay,
again.
but it's near. It's like within.
Yeah, I'm right up the street from them.
Okay, that's what.
Okay, I'm here because this is my area of growth, and we've seen this area, change, and it's not what we desire. We have on file from 1945 down that there should be no transit. This is the Edge Hill Urban Renewal, and I just pulled it and made a few notes here. We're to have a stable residential neighborhood environment that will be free from distracting and disturbing influences.
So what are you reading from?
I'm reading from my notes of the original Edge Hill Urban Renewal. You can find it. It is on file.
Yes, okay.
Okay. And we went through a lot. Mr. Douglas was the councilman and president of NAACP at the time when we started these things, and we do.
I remember Mansfield Douglas.
Okay.
So what does this have to do with opposition of this?
Opposition, did you hear? We want a stable residential area. No, and we specifically stated, documented in the original Edge Hill Urban Renewal, it will be no transit houses in this section.
Oh, transit houses, okay.
Well, transit living,
okay.
Coming in and out, moving.
Transient.
This is transient, yes.
Okay.
This would be family residential community. And we are seeing it, excuse me?
Oh, as you know, that this property is zoned, there's a lot of property in Nashville for this use. Or even
it may be zoned for that use, but we have on record what we expect the Edge Hill area, which is District 17, to be. And we expect everyone to comply with this. And because we're having our properties taken in various ways and methods and other things in the urban renewal, including the Nashville Next, of which I attended those meetings, Edge Hill was not mentioned until everything was decided. So now it's called a retro review to correct. We do expect for the generations come to have what we fought for then and going forward. Now, that's all I have to say, and we are prepared to go to the next level if we can't get it straightened out here.
Okay, questions for the applicant or the opposition? Okay, thank you. We're going to hear from the applicant again. Please come forward. This is rebuttal time, so any response you might have to the opposition, this is time to say it.
I don't have any for her. I mean, she's entitled to her opinion, and, I respect that.
Okay.
So.
Questions of the applicant? Anything else to add? Okay, we're going to close the public hearing. So, here's a case, very typical, that we have someone that says that they did not know that there was laws related to short-term rentals, and they rented it out a bunch of times before getting a letter from us saying, you don't have a permit, stop. So, he claims that he was under the impression that he had a temporary permit. As John Michael said, there was no such thing. You have 90 days to complete an application, and if the application is not complete, then you have to start over from square one. So, comments?
feels like it's in that minor category to me. The total rentals were 13. The applicant stopped, immediately when instructed to stop, didn't rent. I certainly have, and we have heard over, as long as we've heard these cases, we've had many people come to us and tell us that they don't like short-term rentals. I certainly have great respect for that opinion and understand it. But also, the reason we're here is that the Metro Council's given citizens a right to use their property in this way, and we don't really have any recourse to generic complaints that people don't like short-term rentals or want it in their neighborhood, although we certainly appreciate where they're coming from.
So what I'll ask the board, and we talked about this at the outset of the meeting, is the Metro Council has given this body the authority to give less than a year. And some members of the Metro Council will say, it's a year, and that's where most of these cases should be. So obviously, when we deliberate to decide, if it is going to be less than a year, I want us all to remember that that's what the council people have said originally. But, yes, we do have the authority to do less based on the facts of a case. So, discussion.
I agree with Mr. Taylor that I think it falls in the more minor category. However, he knew he needed a permit. He continued to rent during the permit time. He failed the fire marshal, and he didn't go back. So we don't know when this would have happened, but for host compliance, letting us know that it was rented. So, my thinking is, and I'm going back to this application.
I thought he testified that he got what he thought was a 90-day permit, but it wasn't, and we know that's clear. And he rented it twice after that, while he was getting the smoke detectors installed. And then I think we don't know if he just didn't come back because he didn't want to come back, or if
he got the letter.
Or if he got the letter came. So to me, there was a little bit of a timing issue that I wasn't quite sure. I see where you're going, but I wasn't quite sure there was ill intent.
But obviously,
what were you?
But I tend to agree with Ms. Chappell that, once you start the process, Metro's pretty clear about the process. This is what you need to do, and you don't get a permit until you do A through Z and send your $50 in, and then you're getting a permit. So I tend to think that this is a little bit different.
I got you off track. And
No.
What were you?
I think it's a little bit different than some of these others.
I do too. Not in a bad way. I don't think these are probably no ill intent. I think at the same time, he came down in March to get his application, and I think we ought to look at that date and looking at a period of time before which he can apply. And I say 4 months from date of application. If I were to make a motion, that would be a motion.
Is that a motion?
If you made it, I would second that.
I'll make that a motion.
Okay, motion's been made and properly seconded. Any more discussion? Seeing none, all those in favor of the motion signify by saying aye. Aye. Opposed? Passes. So he will be eligible to reapply 4 months from March 8th. Okay, John Michael.
Mr. Chairman, an adjustment to our docket schedule here. The next case in your sequence is 2018-147, a short-term rental case for Kim Eldridge involving the property at 852 First Avenue North. The appellant has been kind enough and gracious enough to back that up a few slots in the docket so that we can retrieve some of the files that are not on hand here at this remote location. We'll be able to pick those up shortly and pick up at that case as soon as we've got them back in hand. We expect it to be 4 or 5 slots down the docket, but we'll advise you as we go on that.
Okay, let us know.
With that, the next case set to be heard by the board is number 2018-150 involving the property at 604A Hume, shown here on the zoning map. Kyle Keene is the appellant and owner of the property at this location. The request is for an item A appeal involving a short-term rental permit denial. Is there opposition here for case number 150? Seeing none, the appellant will have 5 minutes to make the desired presentation involving this property in Council District number 19. We'll hear from staff, and then Mr. Keene will have the opportunity to present his case.
Good afternoon.
Good afternoon.
We came by this case through host, which identified and sent out a tax letter on October 30th. It was followed by a no short-term rental permit letter on December the 1st. We received a hotline tip on that was acted upon on the 19th of January. At that time, we had not reached the 1 month period following the host letter, and so we, upon reinspection, found that the advertisement was still active, and a warrant was issued. Host verified the removal of the advertisement on February the 15th. The pre-court inspection showed that the ad remained down in the interim period, and at that time, the court date, it was dismissed with court costs because prior to the reinspection date, they had come into compliance by removal of the ad and apparent cancellation of all bookings because there were no further stays. There were 3 documented stays between August of 2017 and October of 2017, none after October of 2017, and there were no other complaints against this address.
How many times was it rented?
It was rented for 3 documented stays.
Any other?
I'm sorry.
Oh, go ahead.
So they got the letter, and then you also got a hotline tip. Does that mean somebody called in?
Yes, ma'am.
Okay.
And how does someone contact you all if they feel that someone's in violation and they want to let you know so you can investigate?
Well, there are 2 ways that they can access the hotline. First, they can dial 435-STR-HELP, which is 435.
615?
No, 435.
Oh, so you just, okay.
435-787-4357. They can also go on to nashville.gov and in the search box type STRP hotline and access a plethora of information concerning it.
Is that on our website?
Yes, sir.
Okay, good. Any questions for Mr. McBroom? Okay, thank you. Let's hear from the applicant.
Good afternoon. My name's Kyle Keene, 604A Hume Street. My wife and I moved into and my daughter moved into the property last January. We had moved from out of the country and moved around a lot where we've used Airbnb many, many times without any issues. We put it up on Airbnb. We rented it out 4 times for a total of 10 days between late August and early October. Late October, I realized I needed a permit and I needed to pay taxes. In early November, without receiving anything from the city, I paid the taxes and then received this letter as of December 1st, asking saying that I was in violation. So I might have been found other ways, but it seemed to me that I was found by me paying the taxes. And because I called in to pay the taxes and they said, "What's your account number?" I said, "Well, I don't have one yet, but I wanted to pay." At which point I stopped renting.
When was that?
First weekend in October, October 6th,
Okay.
October 7th. So the whole rental period was from late August to early October. At which point I stopped. I did not take it off the website, which was obviously the mistake I made. Just wasn't trying to rent it out, just didn't take it down. At which point we got the court document. Didn't apply because I figured I had to go to court first, and honestly wasn't sure if I wanted to apply to deal with all of the stuff that comes along with getting a permit. And here we are. So
you changed your mind about dealing with all the stuff that requires a permit?
well, yes. I mean, it was a matter of going in a very busy time professionally for me and my wife, and so we didn't have the time to deal with it, and then so we stopped renting it. But then deciding in the spring or a few months ago in the winter, decided we wanted to apply again, and then also had to go to court and deal with taking it down and figuring out what we had done wrong.
So what happened in court?
Just court cost.
Okay, because you were probably coming here?
Because
Is that correct, Mr. McBroom? You came into compliance and so...
After the reinspection day.
Yeah, we've put up the sign, we've paid all the fees. I mean,
Okay, so what did you learn from this process?
to not put your home up, and by the way, this is owner occupied. This is my home. To not put your house up for short-term rental unless you read all the.
You duly have a permit issued to you.
Do I have a permit?
No,
issued?
duly. That's why you do not
Oh,
rent
yeah,
your
of course.
house
Yes,
on
sir.
short-term
Yes.
sites
Of
unless
course.
you.
I have not.
have
I've
a
done it in
permit.
previous places and not had to do it. But of course, now, no matter where I go and where I do it, a permit needs to be looked into.
Okay, questions for the applicant? Do you have anything else to add?
I don't believe so. Besides that, I'm sorry. This has cost me a bunch of time and money, and I know that's not the purpose, but I was nothing malicious or just oversight.
Okay, we're going to close the public hearing. Discussion.
I mean, again, I think this is minor. There's not, but there's been 3 documented from our side and 4 admitted rentals, and it looks like that the applicant attempted to make things right as we were finding out that he didn't, and so I'll make a motion and see what you think that the zoning administrator did not err in denying the permit given the unique circumstances about this case. This applicant will be eligible to apply for a permit 2 months after March 9th, 2018, when he came and applied for the permit.
Second.
Motion's been made and properly seconded. Any discussion? Seeing none. All in favor of the motion signify by saying aye. Aye. Opposed? Passes unanimously. John Michael.
Next case to be presented to the board is 2018-153.
So you're eligible to apply in 2 months from when?
March 9th.
Today.
Been 2 months.
Okay, so you're eligible to apply for your permit.
Thank you, guys.
And you still have to get a permit before you rent or advertise. John Michael.
2018-153 is an appeal brought by Agnieszka Gorska, the appellant and owner of the property at 433 Cedar Forest Drive. The request is an Item A appeal involving the denial of a short-term rental permit application. Mr. Osborne has this case. We'll make the presentation to the board. Is there anyone here in opposition to case number 153? As there is, both sides will have 10 minutes to make the desired presentation to the board. We'll hear from the appellant first after hearing from staff.
Okay, Mr. Osborne, tell us how you heard about this, any non-permitting violations, and anything else we need to know.
I haven't received any other complaints on this one. On March 4th, notice was sent through host compliance for not having a short-term rental permit. Looks like roughly a week and a half later, the advertisements were removed. Looks like there's about 34 stays.
34 stays. And when was the last one?
Early March.
Early March. Okay. And please identify yourself for the record, and address, and kind of what happened.
So my name is Agnes Gorska, and my address is 433 Cedar Forest Drive, Nashville, Tennessee. And this is my house, and I started to operate Airbnb, and at the beginning I really didn't know that you need to have a permit. I just opened the website and posted it, and it slowly started. And I did find out about half a year ago that the permit is actually required, and I was trying to find about it more, and I searched online Airbnb permit, but it kind of got me nowhere. I didn't know it was called a short-term rental permit. So, and this is not an excuse, but those were my reasons why I didn't have a permit. And I usually rent to people who come here for job transfers. They stay before they move to Nashville or visit, and it's in my house. It's usually 1 to 2 person. They don't cause any trouble as far as I know. I've never heard anybody complain, and my immediate neighbors knew always that I am doing that, and I was paying taxes on that, federal taxes all the way through, and it was helping me financially. It's a burden right now, and I am just kindly asking to allow me to apply for the permit sooner.
Okay, we have a letter addressed to this board from the presiding officer, acting vice mayor Sherry Weiner, who is very familiar with the Bellevue area as the district council person and then the acting vice mayor of the city. And she says, please accept my apologies for my absence at the scheduled meeting due to a previous obligation. The neighbors of this property in Cedar Forest have reached out to me in opposition of this request. As a member of the Metro Council, I've heard the testimony from hundreds of people frustrated by the use of neighborhoods for revenue-generating activities. I support the opposition of the neighborhood to this appeal and ask for your denial. Thanks for your time and consideration. Regards, Sherry Weiner, presiding officer, acting vice mayor, Metro Councilperson, District 22. So, what do you have to say in reaction to that?
Well, I hear a lot that people are opposite to Airbnb. However, I'm a big supporter of it. I've used it as a client. And really what I do helps people. When they transfer to Nashville, they look for the place to stay for a few days. And I believe...
So we get that, but there's a process that you have to have a permit to do that. You just can't open up your house without...
And of course,
because there's safety concerns. There's also revenue concerns from the city. If we're going to do that, the city expects to be paid like all the other short-term rentals that are licensed, and the hotel motel tax that is generated by hotels too.
Right, and I want to, of course, apply for it. Yes.
Okay. Questions?
I mean, I know that's a kind of a generic complaint from the council lady. The only specific complaint that was sent to us through a letter was that parking is an issue on your street, and that your guests sometimes kind of block the cul-de-sac or block the street. Where do your guests park, and do you know of any issues of your guests causing parking problems for your neighbors?
Well, I was never told that they do. Yes, there is very little parking place underneath of my house, and so they park on the street, so it's not like in anybody's really area, and they don't block anyone. And there are other cars parking there a lot, not just people from who come to me. So, I mean, of course, at this moment, it's easy to point on me, but everybody parks there.
But if they use the house for their just intended use, this is different. So we're here to look at, you're asking us to give you a less than a year, because right now you have a year before you could apply for a permit. So we take into considerations the complaints of your neighbor and your people that represent the area that are elected officials. And so Mr. Taylor talked about the parking issue from a neighbor, and then we have a letter from the acting vice mayor too.
Yeah, I can ask my guests to park a little farther out where there is...
But then they're parking in front of somebody else's house. Now, you said that they were parking underneath your house, so where are they parking? Are they just parking on the street?
They're parking on the street. Let's see.
So this is a tight cul-de-sac with not a lot of space in between these driveways.
Right. But there are places farther out where there is way more space between houses, and the street is much more... there is more space, but...
Okay. I think we have someone here in opposition, right? So we'll probably hear from somebody whose house is in that picture. So do you have anything else to add before we hear from the opposition, and then you will come back and address what they've said? Do you have anything else? No? Okay. Let's hear from the opposition. The opposition will have time to come forward, state your name, address, and why you're opposed to this case. Yes, please. Come over here. Over here, right here. And please state your name and address and why you are in opposition.
name is Kyle Stewart. I live at 404 Cedar Forest Drive. And my neighbor and I had noticed a couple years ago an increase in traffic, people that we had never seen before on our street. It's a dead end. Our street is a dead end cul-de-sac. It's a very small subdivision. We had noticed an increase in traffic and people that we had never seen before, kind of like a revolving door of people we had never seen before. And my neighbor had ordered some packages that were delivered to his house, and he had asked me, because I work from home quite often, his packages, a couple of them had come up missing. Like he had delivery confirmations, but they were just missing from his front porch. And we still don't know what happened to them. So apparently they had gone missing or something. We don't know what happened to them. So, and then we have a Bellevue Facebook page, and there's been an increase in crime in the area. So there are several concerns about this. We don't know. We have no way of telling who is coming into the area or not. So we just feel. I don't want to throw any names out there, but I've got text messages while I'm sitting here. If you'd like to see them, I'll tell you. But we feel like the people coming in and staying overnight is better suited in a hotel or a motel where those areas are designed for that type of activity. And on top of that, we have every day probably between 8 to 10 kids that get off the school bus. So there are kids that, because it is a cul-de-sac, they play in the cul-de-sac every day. So we feel like it's just a safer environment without people, strange people that we don't know coming in every day. So that's a big reason why we're opposed to this.
So let's talk about this particular property and what you have observed in particular and why you're in opposition to this particular use. You say that just these strangers, out-of-towners, whoever, right? What else?
It's not just that property. It's any of the properties in our cul-de-sac, because it is such a small cul-de-sac.
Yeah, but we're here to talk about this one short-term rental because they've applied to.
What are your questions about that?
So, why don't you want this to be used as a short-term rental?
For all those reasons I just gave you.
Okay, but that's, specific to this property, not just generically, we don't like
parking is an issue. You've talked about the parking. Everything that Ms. Weiner addressed in her letter, those are exactly true. Several of the people in our cul-de-sac have raised concerns about that.
Well, let me ask you this. Is there a place that's really sufficient for these guests to park, or she mentioned somewhere down the road?
There is parking on the street. When those people do come in to park, it does take up parking spots for other people. As you mentioned, they're parking in front of someone else's house where they park. Several of the people that live there have multiple vehicles. They work. They have spouses that work. So if someone comes and parks in front of their house, and it displaces a spot for the spouse to park. So just one of the points that you pointed out earlier, well, they're parking in front of someone else's house. So just like you pointed out earlier.
Okay. Questions for the opposition? Okay. Do you have anything else to add?
I think everything has already been addressed.
Yeah. Thank you. We're going to hear from the applicant again. Please come forward and respond to what the opposition has said.
Yes, I understand the opposition and I respect the opinion. And as far as the parking, yes, there is a lot of people who park on the streets, and actually I'm probably the only one on that street who never parks on the street. I'm always in my garage.
We're not talking about you, we're talking about your guests.
So it's only one car that is, other than that, at the bottom of my house, which is my guest, and sometimes they park farther out in the shade. So there are many other cars who park there too. So that's pretty much all.
Questions for the applicant?
Have you had more than one car at your property at one time as a result of short-term rentals?
No, never.
Never? How do you know?
All my guests never had more than one car.
But are you there when they come?
Yes, I live there.
Okay,
Yes, they are
but
my
sometimes
guests.
people
Yes.
leave
No.
when they have.
I have a question. It looks like you have a very short driveway, but is it is it long enough to have your guests park in your driveway?
My driveway is steep, so I don't want them to or don't suggest that. But yes.
But what you're saying is all your neighbors park in front of their yards, and you have sufficient yard frontage for a car to park in front of your house as well?
Well, they usually park right on the, it's too hard to point, it's on the street, kind of like between my next neighbor on the right, and that neighbor never complained on that. That's my friend, and he would have told me if that would be the case, yeah.
Which one of those homes is Mr. Yates? Do you know him, your neighbor, Mr. Yates? He's written a letter, and he says y'all get along very well, but he is opposed to us granting this because the parking, he says, infringes upon his ability to get deliveries and have his street cleaned. Is he the neighbor you're talking about?
No. No, he's not my immediate neighbor on the left or on the right. No, so that's right.
Any other questions for the applicant? Anything else to add?
Well, just that really I had a really great experience with Airbnb, and all my guests were the nicest people, and they very respectful of everything, and so yes, that's all I have to say.
Okay. We will close the public hearing and discussion. Well, I'll start off. This is a very tight place to kind of have cars, so if people kind of come and go, and as you know, there's probably this etiquette, unwritten etiquette for this area of town where people know where to park and know where not to park. Someone from out of town or particularly coming at night may not necessarily see driveways at the right place or kind of have the same kind of etiquette of someone that actually lives there. So, you know, these are the cases, and this is why we hear these cases. These cases, this person has been given a year, and they're asking for less. We have a neighbor in opposition, and then we have the duly elected representative, now acting vice mayor, who also is in opposition to this.
You know, I have a great respect for the vice mayor, but the letter sent said, folks in my neighborhood don't like Airbnb, but it was the council that said folks in that neighborhood have a right to have Airbnb. So, I mean, and this is the situation that we've been put in quite frequently, is we've been asked to be a legislative body when we're not, you know, because people come and say, well, we don't like Airbnb, we don't want it in our neighborhood. Well, it's like, well, I appreciate your opinion, but that's something for the council. The council has said you can have Airbnb in your neighborhood. And so I think to me, this case, and the parking's a hard one because it does impact the quality of life in the neighborhood. I get that. It doesn't keep the applicant from having the right to have an Airbnb. And so, you know, I look at it and say, you know, is there testimony that there's been, you know, frequent and disturbing and illegal and disrespectful parking versus, no, I don't like it because it's inconvenient and it's in my yard. And I don't get I don't get a sense that this is a bad behavior parking situation. I think it's just
well, as I said, it's not bad behavior, but it's these people that don't live here that come in at night that just don't necessarily know where the driveways start. They're not used to parking there, and that's kind of what we get.
Well, I mean, and I get that. I'm just saying that it may be that her property is less than ideal, but it doesn't do anything to her rights to have that Airbnb. And if you are looking at it in terms of,
I mean, right, she operated without a permit.
Well, as did all of the others that we're hearing before, and they each have at some point, whether it's a year from now or tomorrow, based on this board, they have a right to a permit. And even if she has to wait a year, she still in a year from now will have a right to a permit with no regard to what that person parks on the street. And so
legally, I disagree. I think you have a right to apply for a permit.
Well, a right to apply to a permit, and that's right. Yes, you have and again, I'm not trying to be argumentative, but the point is that a year from now, at minimum, she would have the right to apply for a permit, and situation of the parking would be irrelevant. And so to me, I think this case should be judged on the number of, the rentals, the behavior afterwards, and just because I don't see I see the parking is unfortunate, but it's not a bad behavior. It didn't do anything that would cause her, to me, to get a lengthier penalty. Now, what that is, I don't know, but I just have a tough time.
Well, I was interested in her saying that there are houses on down the street. We, of course, don't get a picture of that whole street that are farther apart, and there are more parking places. And if everyone else is doing it, so to speak, and parking in front of their homes, then why is it bad for someone to park in front of her home?
Well, yeah, I guess I just have difficulty having that impact our decision when, to me, it's important, and I get that I understand how it bothers folks, but to me, it's not, I don't see the relevance in our decision process in terms of what the penalty should be, because it's the physical characteristics of her property, not her behavior or what she did.
I agree with Mr. Taylor, and I think the council could have taken that into consideration in making the legislation and required a certain amount of parking if you were going to apply for a permit. And because that was not taken into consideration, it was not limited in that manner, I feel the same way as you do, probably on that issue.
Any other discussion?
Well, I agree with both of you. Could someone remind me, though, did she say she knew she needed a permit? And I thought I heard her say that.
I think she said that she had found out maybe said a half a year ago that that she may need a permit, and she tried to figure out where and couldn't do that. And then I think the process kind of caught up with her.
Or host compliance.
3 months ago, she got the letter, and so, but 6 months ago, she's like, oh, I think I need a permit, and
That's the only thing I think we can consider.
The only thing we can consider what? We can consider
The
anything.
parking, I agree that the parking is unfortunately not within our jurisdiction, but, because it's not a bad behavior.
so whatever time starts.
But it's also enforcement. So if let's assume she had a permit, you can enforce your own rules to be a good neighbor of people that live nearby and pay property taxes. And one of those good rules is park only over in my driveway or way over here.
I agree, but I think that can come up if she does apply for a permit and is granted, then the neighbors have the right to complain that her renters are parking, and then that can come before us if there are sufficient complaints. And in that situation, she can lose her permit entirely. So I do think if we allow her to reapply, it's incumbent on her to make sure that her renters are not infringing on other people's property rights.
I'm not sure if that would be deemed what we call a strike here, if someone came to us and said, unless they were literally blocking the driveway, that, I'm not sure if the neighbors have a real redress at that point.
You would think that. If somebody came in and said, look, I've got a short-term rental next door and they're continuing to park in my driveway. And
well, like I said, blocking the driveway, that's one thing, but just parking in front of the house,
that was not
that's
the testimony. We didn't hear testimony that driveways were being blocked.
Right. And so then.
Okay.
Wait. I'll move that the zoning administrator did not err in finding that this applicant rented prior to obtaining a permit based on the circumstances of this case. The applicant's eligible to apply for a permit 3 months after March 12th, 2018, which would make her eligible to apply on June 12th.
I second.
Would you consider amending it to 4 months? I really think.
Yeah, okay, that's fine. July 12th, 4 months, July 12th.
Okay.
I would accept that as my second.
Motion's been made and properly seconded and amended. Any more discussion? Seeing none, all those in favor signify by saying aye. Aye. Opposed? Passes unanimously. John Michael.
Mr. Chairman, the next case that the board will take up is item number 2018-155 involving the property at 2826 Mashburn Road. This is a short-term rental case brought as an item A appeal. Itron is the appellant, and owner of the property, shown here on the zoning map near the intersection of Mashburn and Thompson. The aerial here gives you a view of the property in the context of the neighborhood. Is there anyone here in opposition to case number 155? As a result, both sides will have minutes to make the desired presentation. We'll invite the appellant forward at this time and hear from staff to explain the case.
Okay, Mr. McBroom, tell us about this case. Have you heard about it? And non-permitting violations.
We became aware of this through a hotline tip, and it was inquiring as to whether or not there was a short-term rental permit at this property. After investigation, it was confirmed that they were operating and advertising. The first listing was on December the 30th. I show 6 documented stays in January, 5 in February, for a total of 11. Notification of violation was sent on February the 22nd. On March the 2nd, the ad remained up, so a stop work order was posted. On the 11th of March, host confirmed that the advertisement had been removed. The reinspection date of March 16th, the ad remained down and had not been reposted in the interim. As of yesterday, it again had not been reposted in the interim. There were no documented stays since February, and other than the complaint that initiated this investigation, there was one other hotline call inquiring again as to whether or not there was a permit at this property. Nothing in terms of nuisance.
Okay. Any questions for Mr. McBroom? Thank you. Please identify yourself for the record and your address.
Hello, how you doing? My name is Hai Tran, and I live in 2826 Mashburn Road, Nashville, Tennessee. And I wasn't aware that we have to apply for a permit, to do Airbnb. So I just want to come and just let you know.
Well, why weren't you aware?
I'm sorry?
Why didn't you know?
This is my first time ever do Airbnb, so I.
But you obviously knew about Airbnb. How'd you hear about Airbnb?
Well, just through word of mouth, like friends and stuff, about Airbnb,
So you just went online and just signed up?
online and just research Airbnb and just sign up.
Well, if you researched, you could have gone to Nashville.gov and seen what we require to operate legally an Airbnb here in Nashville. You didn't do that, did you?
Do that. I apologize. I didn't do that. And
so when did you hear that we actually had laws and permitting related to Airbnb?
Now I know, sir.
But when did you find out?
Well,
I'm sure you got a letter from.
Yes, I received a notice.
And what did you do once you received that notice?
Well, I called the number, on the notice, and he just guided me through what to do. He told me to cancel all my, guests.
And did
which
you?
I did.
Okay. What else did you do?
And then, just go to zoning, and talk to the people and just, find out what's going on and, just do what I had to do. And
okay. Questions for the applicant? Okay. Do you have anything else to add? We have opposition, so you'll get to come back. Okay. Let's hear from the opposition. Please come forward, state your name and address, and also why you are opposed to this particular case.
My name's John Worrell. I live at 2603 Mashburn Court. I've lived on that road since 1955, and not opposed to Airbnb. I know that's something the Metro Council has passed. I own other properties, long-term rental in the area. Mr. Tran owns 4 properties. Throughout our time there, we have tried to acquire other properties, and when they come up for sale and go look at them, and there've been all kind of renovations done, no building permits, anything from asbestos removal to just anything. people think, well, I'll just do it and then hopefully won't get caught. And so we do have a number of Airbnbs in the neighborhood, and only to find out that there was no permits. And I think there was one in the news where there was 2-bedroom home right down the street that was advertised could hold up to 22 people. So,
which is a blatant violation.
Yes. So I'm okay with whatever the board decides. Just want to bring it to your attention.
Wait a minute. I mean, you've come down here. You've spent about an hour and a half sitting through all these other cases. I mean, okay, what the board decides. Why are you here? You don't want this person to have the permit, right?
I don't care if he gets a permit. I just I find it hard to believe that people don't know that there's codes, that they don't know that there's taxes, that there's things that they don't have to do going into it.
Well, it's funny you say that. That's I hear from a lot of our people in the community. It's like, I don't understand how these people don't know. Laws, and including the sponsor of this bill, Council Lady Allen. It's like it's been years. How do you still not know we have these laws?
Well, I think people do know, and like I said, I own other properties and have had to do renovation, get permits, and so forth and so on. I think that,
Well, Mr. Neighbor of almost 60 years or so, what should we do?
That's your decision.
But you don't have any testimony that the 11 rentals that he had at that home were bad behavior folks? I mean, your complaint mainly is that you feel like he should have known and knew the process, but not that he's a bad Airbnb host. I mean,
that's yes.
Okay.
Yes.
Okay. Any other questions for the opposition? Okay, we're going to hear from the applicant again. Thank you. Your neighbor just spoke. What's your response to that?
Just want to say that, not everybody know all the law, and everything about, city law or whatever. And I just feel like that, Airbnb should be responsible, not even let us post it on their website if, law is not required.
Well, we've heard that before.
To, let us.
You said your neighbor said you had other homes in the area. You don't have any other Airbnb?
No, sir. This is my only first time that I do Airbnb.
How many other real estate pieces of property do you own in Nashville?
I have 2.
Okay. Any other questions for the applicant? Do you have anything else to add?
No, sir. That's it. Thank you.
Okay. We're going to close the public hearing discussion.
Well, let's say it's on the minor scale. And seems like he did everything he needed to do after he got the letter. And I don't know if anyone else has comments.
Make a motion.
Then I will move that the zoning administrator did not err and that we assess a 2-month penalty from the date of application, which was March 12th, 2018, making him eligible to apply for a permit on May 12th. Actually, I guess that would be May 13th would be Monday. The 14th.
14th. Okay. So that's your motion. Is there a second?
Second.
Motion's been made and properly seconded. Any discussion?
I just think we ought to consider our minor scale is more in the range of 4 months. Are you willing to amend it to 4 months from date of application, which would be an additional 2 months before he could apply?
I would agree with that. Mr. Taylor says 3, but
Can we meet in the middle at 3?
well, that's what Mr. Taylor says. But
Do you think 4 months?
I
is
think
the
4
minimum?
is more appropriate.
So I just feel like, when people continue to come down and they can apply tomorrow, I know they've had to go through a lot, and they've waited to rent. But that's part of it. I mean, that's part of what we're supposed to do, and we're
it's
hearing
less than
from
a year.
people. It's less than a year. We're exercising our discretion, but I think that period of time is a fair period for people to be able to apply. I mean, he would have about 60 days before he can actually apply, which is plenty of time to learn the law and make sure he's doing everything he's supposed to do. That's my thought.
And I don't have I guess where we're maybe a little difference of opinion is that it seems like on some of these the time between the notice and the stopping of bad behavior and the application is long, and it's not as much this time. It's about 20 days, and I tend to be, to think, well, when did you stop doing what you were not supposed to be doing? Is the point, and we talked about it earlier in the meeting, and so, so that's kind of where I got, I know I agreed with you, but I'm adjusting my, I haven't changed my thinking. And my 3 came, because I think the date makes sense. But the 3 basically came from, well, they stopped in mid-February, and so that's when the bad behavior stopped. And so that's kind of where I'm. So again, the 4 months, I'm with you on the 4 months. It's just not the start date necessarily. And so what it is, again, it's up to the board. I don't know, but I do think that's a good way to look at it.
So, Ms. Chappell, it appears that we are on the minority view of this, and so do you go for 3 months, or do you take your chances on getting another motion?
I mean, we've got a motion on the table. We can
Amend or vote? Is there any amending of the motion's discussion time?
I'll amend to 3 months if that.
Okay, is that fine with
I
this?
felt that it was very minor because there were no other rentals or anything that seemed to have gone wrong since the time.
But the authors of this legislation would point out that they wrote in their violations are a year, and then that we get discretion, and that many people see any violation of the Short-Term Rental Act as being something that should be taken harshly.
Well, and that's the tough thing, because we got a lot of folks that view it as if it were the sticker on your license plate, where you couldn't conceive not being able to drive for a year if you didn't get your sticker on time. And then you have other folks that say, well, boy, you're 2 days or 2 hours late on that sticker, and you can't rent for a year. And so, I mean, there's no variety. I mean, you're right. There's strong opinions all across the board, which makes it hard for us.
So who seconded the motion? Is the person willing to 3 months?
Sure.
Okay.
Well, would you go with the 4 or the 3?
I would prefer the original motion, but I'll go with 3.
So we're trying to meet in the middle.
Okay. Motion's been made, amended, and properly seconded. Any more discussion? Seeing none, all those in favor of the motion signify by saying aye. Aye. Opposed? Passes. John Michael, the board would like a short break.
That means you can apply June 12th.
The board will reconvene with case number 2018-156 after this short break.
Well, thank you very much, ladies and gentlemen.
very much. Again, case 2018-156 is a short-term rental appeal involving the property at 1011 West Grove Street. Nokomis Brown is the appellant and owner of the property. We'll invite him or her forward at this time. Is there anyone here in opposition to case number 156? It appears to be none. You have 5 minutes to make the desired presentation after the staff's presentation. The aerial photograph of the subject property here in Council District number 17. And the face of the property from the assessor's website, though dated, at least we've got the aerial here. You have a late filed written letter of opposition from the neighborhood resident who had spoken previously in opposition to a short-term rental case in Council District number 17. That's being passed around. As she was unable to stay on her way to another meeting, she asked to at least be able to write that down and submit it to the board to be considered along with the remainder of your packet. We'll hear from staff first, then from Mr. Brown with regard to the appeal.
And board members, you also have a email from Councilman Sledge, who says about this particular case, my position denies it appears the appellant has been operating as an STR during the appeal period. So we're going to hear from Mr. Osborne. Tell us about this case. How'd you hear about it? What violations? And are there any non-permitting violations that you know of?
So we found out about this one through host compliance. A notice was sent out on.
There's some talking going on in the gallery. Could we please?
The notice was sent out on February 9th, 2018. It looks like they had applied for a permit previously in September of 2016, but that process was never completed. I don't have any other complaints that I know about on this property.
How many times was it rented?
Approximately 43.
Okay.
I am concerned that the letter went to a different address than the property address. It went to 613 K Street.
Why did it go to K Street?
That's where the property assessor shows that they're.
Is there a K Street, a K-A-Y-E?
K Court.
Okay. So was it returned? So tell us about this. So it wasn't returned?
No, sir.
Because that was a real address?
Yes, sir.
So who's at K Street? Why would they even get that? Okay, we'll find out.
I don't know.
Please identify yourself for the record, your address, and why you're here.
My name's Tommy Anderson. Address is 1011 West Grove Avenue. I'm here because between the two of us, we know about it. We knew what we were supposed to do.
Okay, so let's back up. Between the two of us, who owns this property? And
Technically, my mother owns it, but I live there. I've lived there my entire life. My family, it's been in my family forever.
Okay, so who are you?
Not his mother.
Okay.
I'm Jessica Black, address 444 Elmington Avenue, Nashville, Tennessee. I'm his fiance.
Okay.
And I've been helping him and his mom with this venture.
Is your mom Ms. Brown?
Yes, sir.
Okay. Just want to make sure we have all the names.
Who lives on K Street?
My mother.
Mother lives on K Street. Okay.
Yes, sir.
So why isn't your mother here today?
I worked.
Okay, but did she apply? Who applied back in September 2016 for a permit?
She did, but when I went to the appeal, I asked specifically if she needed to be here, and he said that I could represent her essentially.
Okay,
That's why I'm here.
But so why did she applied back then? Why didn't she get a permit, and then why did she continue to operate as an Airbnb or short-term rental?
So we went through the application process. We're both pretty busy.
Pretty busy.
Between us both.
Pretty busy. John Michael, how many short-term rental permits have been issued roughly in Nashville?
As of today, Mr. Chairman, there are over 3,700 short-term rental permits active in this city, well over 1,500 illegal operations in this city. Since the inception of the law in 2015, we estimate that there have been more than 5,000 properly legally issued permits in this city. It seems that some word has gotten around, at least, despite the overwhelming evidence from all of today's appellants that they had no idea there was such a law.
3,700 people figured out that we had laws.
Oh, we're not ignorant. We're not ignorant of the laws. We were ignorant of certain things. Like I was asking him about the taxes when we needed to file the taxes. He said we do it with our regular taxes. I learned that was wrong when we got the letter. So just before Easter, we were making plans with his mom, and she's like, oh, I got a letter from the codes department that's when we physically got the letter and immediately started taking action to correct things.
And like I stated earlier, we started the process, and what happened was when we got to the fire inspection, I thought that she was going to handle it, and she thought that I was going to handle it. We both had work like between here and out of town, so we whiffed on it. That's our fault, and yeah, that's not an excuse. It's a reason. That is what happened.
I mean, it was only $50. We're not trying to get over on $50.
Right.
Like, we are
But
so sorry.
the $50 is separate from the fire marshal inspection, though.
Oh, I know. I'm just saying, like, we both thought the other one did it, and
I doubt few of the
There was a lot going on.
3,700 duly licensed short-term rentals, probably most of those cost more than $50. So yes, we realize that $50 is not very much. So
I apologize. Just to let you know, the stress that we were under, I was helping him run a business with his partner. I was their secretary and accountant, and he stole $20,000 from the business. And we just got the judge to grant our settlement. So we had a lot going on, and it's not, like I said, not an excuse. It's just when we say we were busy and the other one thought the other one handled it.
That's exactly what happened.
When was the last time y'all rented this?
End of March. We canceled as soon as we knew.
End of March. Because, I mean, we have a letter that says that there was a bachelorette party there this past weekend, which was April 28th and 29th, and they had pictures of people taking things, coming and going.
I mean, I had girlfriends over. I've got one getting married, but
So it was
it wasn't a bachelorette party.
Did the
I had
girlfriends?
girlfriends over.
Did they stay overnight?
Yeah, we all slept over there together. It was a slumber party.
How many?
There were 9 of us all together. I could get the invite list.
And what and what date was that?
I'd have to look at the invitation, but that
What
sounds
month
right.
was
The
what
wedding
month
is
what
July
month
21st in
what month
Pittsburgh.
was that?
It was in
March?
no, it was in April.
April?
The bachelorette was in April.
She knows more than I do.
Yeah, it was my friend Mbika. She's getting married in Pittsburgh, July 21st. I've got the save the date on my fridge.
But did they pay to stay there?
Oh no. It's an old girlfriend. We all just
So all the people invited to your party all decided to stay overnight just spontaneously, or is
like
that?
I said, the wedding's in Pittsburgh, so everyone came into Nashville.
Oh, out of town people.
Yeah.
Okay. And you.
Even was in the process of moving from New Orleans home to Pittsburgh.
Okay. So, other questions?
So I'm confused about who's applying for this, and is owner occupied that we're?
It is.
But your mother's the applicant.
It's because it's in her name. We just had It's.
But she owns it, but she doesn't occupy it.
I do. So you're saying that I need to start this over and have her?
Well, I'm just trying to clarify with legal counsel.
Yeah. Let's ask our lawyer, who is eligible to apply for an Airbnb?
That's a very good question. If you give me just a minute, I'll find it in the code for you. Give me just a minute on that.
If it's owner occupied, it has to be.
So I guess the only other, there are a handful of opposition letters, more than we normally get. A couple of them are generic, as you've heard us talk about earlier. They don't like Airbnbs. They say the streets kind of turned into having a lot more Airbnbs than it used to. There is one letter, though, that says, from somebody that looks like they live 2 doors down. It says, this house in particular has had barbecues, including a barbecue trailer with tents and flags with 20-plus out-of-town hockey fans in the front yard. And so I kind of wrote down in my notes, looks like it could be a party house. So tell us, is this a party house or?
No, it's not a party house, and it's not even set up to be a party house. We've had parties, we've had people over.
Well, you've had bachelorettes over. Is that not partying? No, seriously. You have 9 bachelorettes here. The stereotype of bachelorettes in the city of Nashville welcomes everybody, and we're happy that people want to enjoy our city. But neighbors classify these people as people that are here to drink and go out and.
Now, I know across the street from us, there are 2 investment properties that frequently have large groups, and they park even in front of our house, and we can't park there when we want to be there. But we don't, like, we have 4 bedrooms and very little, like, our water heater is small, so we tell everybody, like, it's not a hotel. It's got to be family style. You got to rotate your shower schedules because there's not, like, there's just, the house isn't
It's
built.
not set up for that.
So what's the largest
large
number of
groups.
people you've had at your house from one of these rentals?
10, and it included kids.
Okay. So you found out, you got this most recent letter, you don't own the property, so let me ask John Michael. John Michael, if I want to apply for an Airbnb, who can get one of these? Who's eligible?
I feel like the spirit of your question may be specific to type 1 questions.
Yes.
The permittee in a type 1 scenario is going to be the owner of the property. The owner-occupied scenario requires that the permittee be the owner. It doesn't mean they can't have a representative make the application for them. Plenty of people use management companies or an immediate family member to handle that for them, which sounded like that's where this discussion was going at one point. But as far as who the permittee is, that's going to be in an owner-occupied scenario, the person who owns the property and lives in that property, not a person who owns the property and whose other family member lives in the property, whereas owner lives elsewhere. I hope that's responsive to your question.
Yes, it is.
Okay.
And we would concur. We have found some language in there that we would concur with Mr. Michael has already
Okay.
said.
Questions?
So are we saying that this applicant is, that, I mean, not Ms.
So
Brown,
it was
but-
your testimony that your mother lives in this property and you live in the property too as well?
Yes.
Okay.
I thought your mother lived somewhere else.
Yeah, she's got 2 properties. I mean, she works at Vanderbilt. She'll stay there when she wants to. Her stuff is there. So I mean,
The stuff is there in which place?
both. She's got things at both places. Like
Why does she shuttle back and forth?
because Vanderbilt is closer to the house on 1011 than it is to the house on Cape Court.
So what does her driver's license say?
It should say 1011 West Grove.
Huh?
We were
And-
there the day that she. Yeah.
Why does does this other house get rented at all?
The
Her
Cape Court.
other family members live in the Cape Court. Her brother and older sister and younger brother, who's 50-something, but recently was let. It,
Doesn't matter.
Sorry.
But,
And she
yeah.
owns
Extra information.
and she owns both of these houses.
She owns both properties.
yeah, we're.
Okay. Questions?
The code specifies that the property owner, the owner of the property, shall permanently reside in the STRP. So that's the only additional information I think that
Permanently reside.
helpful to the board.
Okay. Questions? So we have opposition for this particular case, John Michael? Do we? No? Okay. No opposition. Okay. Just saying. Okay. Go ahead.
Oh, before we started, I turned into Miss Jessica right here a petition that I did from all of my immediate neighbors, my front side of the street, or my side of the street, the other side of the street, and directly behind my house. I've got about 20 people to say that they have no problem with it. I did it before we did before we started the the approval the approval process, and I did it after. So I guess the one person that, or the many other people that are in opposition, I don't know, because I've got 20 people. I don't know where these people are coming from. They didn't tell me anything. So I guess they're trying to play both sides. I have no idea.
Who's trying to play both sides?
Whoever is who. I believe Mr. Taylor said that he's looking at many letters of opposition. I only have one guy that said that he
Well, they
wouldn't sign
submit
mine.
them to codes, and then they give them to us.
Okay.
They don't.
Get a packet of information and it just has that.
Give them the letter from the immediate.
Oh
neighbor?
yes, I have a letter from my immediate neighbor that was it's actually a signed affidavit from Mr. Scott Sutton. He is my immediate neighbor to my left. I do believe that note is notarized, so I don't know if that makes a difference, but
So you never had a barbecue with a trailer, tents, and flags, and 20-plus out-of-town hockey guests in your front yard?
Not that I'm aware of.
Wait a minute, not that you're aware of?
I didn't.
I didn't.
Was there a time in the
we've had
last
guests,
year
but
where
I think
that
our
happened?
neighbors would have.
Right, we've obviously had guests, but yeah, like.
But have you had
again,
guests that were in the front yard, 20 people at a time with tents and?
I feel like our immediate neighbors would have called us.
Our
No,
immediate.
that's not the answer. My question is, did you? Not that.
Not to my knowledge. To my knowledge, no.
To my knowledge, not that I'm aware of.
Not that I'm aware of. This is the first we're hearing about it.
And he grew up in the neighborhood, like his immediate
I've been
neighbor,
there
Mary
I've been in that
Frances.
house for 36 years. My neighbors know me. If there were any problems, they would call me and let me know. They all have my phone number. I've thrown parties.
That's not the most resounding denial.
I'm sorry, but I can't prove a negative.
Right.
No, I asked you, did that happen? And you say, not that I know of, I'm not aware of.
I don't know.
I can't say it didn't. I've just never heard of it before.
I guess what I hear you say is that there are times when you've rented the place where you were not there.
Sure.
And if it happened when you weren't there, no one made you aware of it.
Exactly. Yes.
That
is completely accurate.
Okay. I mean, so.
And as you saw from the aerial, our yard cannot fit 20 people, so I don't know where that came from. Definitely can't fit a tent.
Well, 10. Other questions?
Or a trailer with a barbecue, for that matter.
Okay, any other questions?
Still trying to gather the facts here. So the date of your application was March 13th, and did you rent to anyone after that date?
We did. Once I was made aware of the letter, I did everything I was supposed. I shut it down.
So
Shut down.
So yes, past that date, but we didn't know about it until my birthday, March 25th. That's when his mom passed the letter to us, because it was at the other location. And when we follow up with all of this, we'll be certain to make sure that the letters come directly to them.
So when was your bachelorette party?
That was just at the end of April, but we didn't rent it out. That was just my girlfriends all coming in
So
town.
what dates? The last weekend of April, second to last weekend of April?
May I ask a question, Mr. Chair? Is it the testimony that the applicant is the mom, but the person operating the STRP is the son? Am I understanding the testimony correct on that?
Who's operating this?
Yes, that would be me.
Okay.
That would be you?
Okay. And so just for benefit of the board on that, kind of just as we're exploring the ownership issue, and this is a little bit different than what we typically see, this violation is not before the board, but the board needs to be aware that the law requires that an STRP shall not be transferred or assigned to an individual, person, entity, or address, nor shall a permit authorize any person other than the person named therein to operate the STRP on the permit. And I think that's kind of what you guys were trying to get to in asking questions about that ownership. So whomever has the STR permit has to be the operator under what has been adopted. Again, that violation is not before you, but I think it's pertinent to your discussion.
Okay, so what's...
I have a question for our council. Is there any problem if we were to defer this? I know it is on appeal for them to speak with the zoning administrator to determine if it's properly here even, because
I don't think that there is, but I'll yield to John Michael in terms of any time constraints or anything like that. Okay.
What was the date of the bachelorette party?
It was the 27th through the 29th.
Okay. So board members, what do you want to do here? Oh, yes. Do you have anything else to add?
we don't have opposition here, right?
No, just, if we are granted the opportunity to reapply before the 12 months is up, that we'll follow up and find out if we need to add his name to the deed, because we just paid off the house in November. We're more than happy to comply with that.
And I apologize for operating without a permit, sincerely.
Okay, so we're going to close the public hearing, so discussion. There was a suggestion that they might be wise to defer this case and talk more to the zoning administrator.
That's what I think should happen. I'm not troubled at all by his mother having another place. I happen to be friends with a medical doctor who is often overnight at the hospital and got a condo there, but his legal residence is in another county. So I'm not bothered by that, nor am I bothered by him because he's lived there all of his life. It's what if he were her husband? You would expect your husband to have some involvement in something you were doing. But I do realize that he's not an owner of that property.
I tell you what I'm bothered with. They really couldn't tell me, what kind of activities go over there. There's a very specific complaint from a neighbor about a party, and they didn't say it unequivocally didn't happen. And it gets back to who's running this place. Is it the mother or is it them? And if I had 20 people and staying in my house, I should know about it. And
I mean, I guess, maybe it's a personality type difference or something, because if you'd asked me that question, I had some friends that stayed in my house when I was out of town, and if you'd said, well, did they have a party? I was like, well, I would have probably given the same answer. Not that I know about, and I know my neighbors would have told me, but I don't have a video. I may not have a camera system, so I couldn't swear to it. But I don't think so because there was no warning. So, I guess I don't know. It didn't bother me like it bothered you because I thought, well, that's probably how I would have answered it because I just don't know.
And so, board members, Ms. Sanford, how should we proceed with this case? Should we?
On the deferral, I guess to me, they have to sort out, we say, is there a finding that we can have that basically lets them sort it out? And, like I said, I understand too from, you live in a house all your life, it's your house, you may have actually bought it, but, you haven't signed off on it. And it sounds like there's some hoops to jump through. I'd prefer not to have to hear it again if there's a path to say, based on this evidence, you need to wait a certain amount of time. And yet you've got to get your permitting right when you go get a permit, because right now there's no permit at all. It's not like it was mispermitted. There's not even a permit by anybody.
And the other thing that's troubling to me is someone attempted, I think they said it was their mother, to apply in September 2016, never completed the application. So we've been going down this road of 43 rentals for a while. And we obviously know that there are rules about short-term rentals.
And I don't think we heard any testimony about whether taxes have been paid.
Obviously, if they're going to get a permit, they're going to have to do that.
Right, of course.
So, therefore.
Well, our decision today just allows this, I guess, the appellant, Ms. Brown, to apply for the permit. She's still got to demonstrate, I suppose, all the right administrative
ownership, insurance,
steps,
fire marshal.
right, that occurred. So I think, but you raise a good point in terms of what we heard today. They've been trying to get a permit for a year. Somebody knew they were supposed to have one.
A year and a half.
And so I certainly think that falls into the mid-range of what we've heard.
Well, and I think that's fair. I guess to me the question is if this is Mr. Anderson's house, let's say he gets his name on the deed and goes to apply for a permit with everything down, he might be able to go ahead and get his permit, even though he was, that?
Yeah, we're only determining when the clock starts and when you can do it.
Well, or I guess to me it's like who are we determining for, Mr. Anderson or Ms. Brown?
Well, we're just determining whether or not the zoning administrator
Aired as it relates to Ms. Brown, whose name is on this proposal. That's what's in front of us.
Did you have?
Okay. So, I think that this is troubling. We've got letters from neighbors complaining. We've got, the council person.
We also had a lot of people in support, too, though. He did, all from that zip code, have several signatures.
Yeah. But here we have, once again, a house operating 43 times without a permit, and at least going back to September 2016, them applying for a permit, so they've at least been knowledgeable about our zoning laws since then.
I'm willing to make a motion if y'all want to think about it.
Okay.
But I would move that the zoning administrator did not err and that the appellant may apply 6 months from the date of application, which was March 13th of 2018. And they work it out from there.
Okay, motion's been made. Is there a second?
I'll second.
Okay, motion's been made and properly seconded. Let's discussion. I think 6 months is too light, personally. Do what?
I said it might be too much.
Well, okay. Anyone else? What
Oh, I thought maybe 8 months, actually.
would you be willing to change to 8?
I would
Okay.
amend my motion to 8.
Would you second that, or would your?
That's a bit much.
Okay. Well, do you want to second 8?
I can second 8. Sure.
Okay. Motion's been made and properly seconded. Any more discussion? Seeing none, all those in favor of the motion signify by saying aye and raise hands. Aye. Opposed? Okay, passes 4-2. They'll be eligible to reapply 8 months from which date?
Application date, March 13 of 18.
March 13th of 18, and comply with all rules about ownership and everything else. John Michael.
The next case is 2018-157 involving Ken Wade as the appellant on behalf of the owner of the property located at 1719 6th Avenue North. Again, this is an item A appeal involving a short-term rental permit application. The zoning map here shows you the subject property. The aerial photograph shows the residence in question. Is there anyone here in opposition to case number 157? Seeing none, the appellant, if present, will have 5 minutes to make the desired presentation. Mr. Wade is not present, which favors judicial economy in this instance, and we will move forward to the next case, putting 157 at the heel of the docket just on the off chance that Mr. Wade were to show up.
And if he doesn't show up at the end, what happens to the case? Do we just automatically defer?
The board has the ability to kill that case immediately by its own motion. However, in many instances, the board chooses to defer to a later date.
Let's just decide right now that let's June the 1st or 2nd.
I think June the 21st is the docket where we actually have some space.
The second meeting in June if they don't show up by the end of the meeting.
Duly noted.
Okay.
I don't know that.
Right. As mentioned at the beginning of the board meeting, 2018-158 has been deferred at the request of the appellant, bringing us to case 2018-161 involving the property at 6013B California Avenue. Courtney Kuzma is the appellant and owner of that property. This, too, is an item A appeal involving the denial of a short-term rental permit. Is there anyone here in opposition to case number 161 involving the property at 6013 California? Seeing none, the appellant will have 5 minutes to make the desired presentation to the board after staff makes its presentation. Mr. Osborne.
All right, so we found out about this one through host compliance. It looks like they did have a permit, but it expired on February 3rd, 2018. So we sent a notice on March 2nd of 2018. Looks like the last documented stay we can tell is from March of 2018.
Okay, so were there any other listings after the permit had expired?
There was just that one stay in March that happened after it expired.
One stay?
Yes, sir.
Okay. Any other questions for Mr. Osborne? Okay, thank you. Please identify yourself for the record, your name and address, and what happened.
Okay. My name is Courtney Kuzma, and my address is 6013 B as in Boy, California Avenue. And to just kind of run you through what happened, I became a host in March 2017, and everything has been great. I'm up to date on my taxes. I didn't take it offline, but I travel a lot, so I just didn't book up in January and February. Just kind of enjoyed the holidays at home and had been traveling a lot for work. So my own mistake, missed my renewal date for my short-term rental permit. They mailed me the letter on March 2nd. I did not get it, meaning I actually didn't get home to open my mail. I'd been out of town until Sunday, March 11th. Saw it that Sunday. I immediately emailed David, who, I don't want to butcher his last name, but from Codes, that said to contact him once the letter was stated. So he told me to come down and set a meeting at Codes. I saw him that Wednesday, the 13th, and he explained this process to me. At that time, he told me I needed to quit advertising and cancel the bookings. I had 8 bookings, one of which started that next Thursday, so 3/14. I canceled 7 of the bookings, all the ones after that, but I asked him what to do about that weekend, and he said it was up to me and he could not advise me as to what to do. But it was NCAA weekend in Nashville. These people have been booked for a while, and so I chose to go ahead and let them stay.
And how much did you charge them per night?
I got $970 off of their stay that weekend. There were 3 nights.
For 3 nights, so is that total?
That's $300 a night plus $100 cleaning.
Did that have something to do if you're not canceling this?
No, and I'll tell you why. Because of the other 7 that I did cancel, I lost $6,470 from the ones that I did cancel. I'm happy to pay what I made that weekend in fines. That was just me. I'd like to go stay in Airbnbs. I'm very active with my friend groups. We like to go run races and do all kinds of things. And I would hate to be going to a big city such as Nashville or Chicago or New York, a fun place, and be told the night before, when I'd had plans solidified months ahead of time, that I could no longer stay where I was going to stay. So that was just my personal decision. Again, I'm happy to pay that money back to y'all on a fine if you.
Well, we don't have that authority, but.
Well, it wasn't about the money, is what I'm trying to tell you.
Okay, so why didn't the little check for $50 get addressed to Metro?
Again,
and put
that
in
was
the mail?
just a clerical error. I don't want to sit up here and say I was busy. It was just, we're all busy, right? So it was just a mistake I made, and now I know to be looking for that 1-year renewal. But everything else, I abided by the guidelines. Like I said, I'm up to date on my taxes. I received an email from Jessica Shepard telling me what to do to get to this point, and I mailed out 144 letters. I've had the sign in my yard. I have not been advertising. I paid the fine to be here, and I'd very much like to continue to operate as an owner-occupied Airbnb.
Okay, questions of the applicant? Do you have anything else to add?
This is obviously brought this on myself. I'm very sorry that I'm even here to do this, and I'd very much appreciate to continue to my business.
Okay, let's close the public hearing. Discussion. So this was somebody that went through all the process, was licensed, no complaints, and then the renewal process comes forward. You basically have to send us $50 and get it to Code's office, and she didn't do it. And so therefore, you, if you don't do that after a certain period of time, you lose your permit. So that's why it's here in front of us.
Well, it feels pretty minor to me, with the exception of the one stay, and I'm sympathetic to the reason. So I don't know. I mean, looks like a 4-month to me.
Like a what?
Like a 4-month penalty to me.
I'm not sure if we have that authority. So John Michael, so we are here to either say the person can get their permit or not. We cannot put any additional time to wait on this. Is that?
Right, this is not operated, well, I guess very technically it is an operated without a permit with regard to what is now before the board, the one documented or admitted stay during a period where there was no active permit. But technically when you have an expired permit and an appeal comes in, the request is, did the staff err by deeming the permit expired? It doesn't seem like there's any testimony in the record to that question. So obviously it's not an error in that regard, at least just based on the testimony presented. Instead, the board may view this, again, based upon the documentation here today of the one stay, as operation without a permit that would trigger a 12-month wait based upon that. Didn't really expect the case to change midstream, but it did. So I think in this unique instance, you do have a case where you're determining whether or not you want to reduce a 12-month waiting period.
And you really have, if I might add to what Mr. Michael has said, you really have two issues. You have operating without a permit and you have an expired permit. To the extent that you want to issue a time period within which that person can apply, I don't read in the code where you have anything with regard to the expiration piece. So you can say she can apply in 4 months if that's the pleasure of the board, but she will at that point take her place in line to get a permit within that, after that 4-month period expires. I don't see where the board has authority to say we're going to waive the fact that you didn't reapply. I think she can reapply if you so choose, but she takes her place in line in applying for those permits.
So regardless, she'll have to apply again,
Correct.
even if it was purely expired.
Unless
We just ruled that they erred in
Unless you
the
rule that they erred.
expiration and all that.
That's correct, as John Michael has explained, right?
So can we bring, I guess in a sense, since like John was saying that the case changed course, are we allowed to bring the charge or the violation as such?
At how it's listed on the agenda, because that'll tell us what our.
It's on the agenda as a denial of a short term.
Okay.
So is that what governs the decision we make?
Right.
So we don't have to decide on the expiration. We can look at it solely as an operation without a license.
Well, because it's not clear from, I don't guess we have any additional facts on the agenda, how it's listed. It's just listed as a denial, case number 6.
So then if we find that the zoning administrator did not err and we allow her less than a year, is what you just said, she has to get in line.
That's right.
So based on the agenda, that's the only thing we can rule on.
Yeah.
Okay.
Okay.
So, okay.
And based on not only on the agenda, but based on what the code says, because the code is contemplating your review as an item A appeal, and it's also contemplating your review as to reduce the amount of time. Those are the only two ways that you can take action.
So I'm still confused on whether or not so what is the punishment for not renewing? If we didn't have the situation with the stay without the use without a permit, what were our options?
And Mr. Michael might be able to assist me on this. I don't read that this board has any punishments that it can enforce with regard to that. It's its own punishment by virtue of the fact that it is expired by operation of law. If you don't go ahead and get your permit, you'll have to get back in line. But Mr. Michael may have some additional information to share with you.
That's the right answer. As to your question, which I understand to be what action can we take, it becomes a yes-no question. Did the staff err? If yes, then it's deemed that we were in error in deeming it expired, and somehow it should thus be reinstated as not expired. Or in the alternative, if no, the staff did not err in deeming the permit expired after 365 days and a subsequent grace period if eligible, then the answer is no, and it cannot be reinstated. Now, in that scenario, the appellant could walk in tomorrow and file a new application.
So the point is moot on that.
If, in fact, you deem that there was no error,
either
then
way.
yes.
So then my question, I guess, I don't see that there's any action to be taken on that in the first place. I mean, I know there's an appeal. I mean, she's got due process, but what's the point in appealing if there's no action that can be taken? There's no punishment and there's no relief. So,
other than if we said that based on testimony that, just for her to cover her basis to say that
I was never in violation.
That we find that.
Well, this is why it was relevant. It's why she's here today. So she goes down and applies tomorrow, and they say, "Hey, you were operating without a permit. Come back here."
Right, but we can't adjudicate that now anyway until someone makes that determination.
But it's on the agenda that we can. I mean,
yes, so we can.
On the docket it says.
Yes.
So I mean, I'm based on all of this. I mean, I'll move that the zoning administrator did not err in finding that the applicant operated prior to obtaining a permit, and the applicant is eligible to apply for the permit 2 months after the application date, which is March 14th, 2018, which would effectively make it today, which is the, I mean, it's not today, it's 4 days from now, but that.
I'll second.
That's your motion.
I'll second that.
A motion's been made, properly seconded. Any discussion?
I think it's more like a 4-month penalty because there was operation that one stay after the letter was issued.
I mean, I think based on everything I've heard, I'm happy with that, with keeping it 2. I mean,
You're going to keep it as 2?
I'd like to keep it that way and see how it goes.
So anybody else? Time to vote. All those in favor of the motion signify by saying aye. Aye. Opposed?
I'll go with it. 6-0.
Okay, then passes unanimously. Okay, John Michael.
Mr. Chairman, previously we had called case, or were set to call case 2018-147. And after a brief administrative correction on that one, we're ready to take that case up now. Case number 2018-147 involves a property at 852 First Avenue North. The appellant is Kim Eldridge, represented by counsel today, Mr. Murphy, who will present his client's case for case number 147. Sorry for the moment to pull this up. As you see here, this is a condo along the riverfront on just on the north end of downtown. It's a short-term rental case. Is there anyone here in opposition to case number 147? Seeing none, Mr. Murphy and his client will have 5 minutes to make the desired presentation to the board.
Okay, we're going to hear from
staff.
Yep.
Back on 147.
Okay, tell us about this case, any non-permitted violations, how'd you hear about it, and anything else we need to know.
So this one was brought to our attention by Host Compliance. It was originally sent a tax notice on October 30th of 2017. On 11/17/2017, I received a call from Ms. Eldridge saying that she did not operate a short-term rental and did not owe any taxes. I looked into it, saw that her permit was erroneously showing issued, it should have been expired, and notified her that. At the same time, I notified Clint Harper of in zoning to look into the permit and make sure that if it needed to be canceled, it needed to be canceled, and Piper of the tax violations. On 12/1, we sent a short-term rental and tax notice, and on February 6th of 2018, a warrant was issued for continued violation.
Okay.
What was the continued violation? Was it listing or stays?
Both. To date, there have been more reviews that have showed up. The advertisements were removed. However, we can still see those reviews through her host profile.
So when was the last review?
Looks like it's from April. So I'm requesting it be deferred to be heard in court next week.
Okay. Any questions of Mr. Osborne?
I just didn't hear the end. He's requesting it be
It
deferred.
deferred so it could go to environmental court.
Okay.
And your communication with the applicant is that you were told that they don't operate an Airbnb?
That was the initial, yes.
Do we want to hear from counsel on?
Yes, because we
deferring it?
object to the deferral.
Okay. Mr. Murphy, please.
So this case has...
Please identify yourself for the record.
I'll be happy to, Mr. Chairman. I'm Jim Murphy, 1600 Division Street. I represent Ms. Eldridge. This case was previously before the Metro Court and was deferred so that the board could take it up first.
Okay.
So that's why we're here. As far as the...
Are you ready to proceed today?
Yes, absolutely. And I wanted to respond first to the issue of the rentals in April. That's not Ms. Eldridge's unit. It's not her unit. She doesn't have an ad up. There is an ad that has her address on it that is not her unit. And she's contacted the owner of that actual unit, and it's not
But
this
what's the
unit.
confusion then?
I'm not sure. I mean, the facts on this case are different than have been described by staff. Ms. Eldridge had a permit in January of 2016. When the time for renewal came up in January of 2017, she sent in the check and the affidavit. She kept a copy of the check. We've submitted that to the board. For some reason, that check wasn't processed. And the application was never, apparently, for some reason, it got lost in the mail. That's all I know. That's all we know. Ms. Eldridge didn't know that. And in fact, in October, she received a notice from Metro saying that she needed to renew that permit. And she came in January of this year to renew it. And when she met with staff took her application, took her permit, took her check. We've submitted that affidavit and check. And at that point, she thought that she had been renewed. A few weeks later, she got a letter from Mr. Michael saying that her permit was not renewed because her permit from 2000, that had never been renewed in 2017. That was the first time she knew that the permit had not been renewed was not renewed in 2017. So this was a situation where this is not a person who was acting without a permit. She had a permit. She thought she had renewed it and received no notification that it hadn't been renewed.
But she obviously did receive a letter saying something at one time from codes that she didn't have a permit.
In January of 2018, she received a notice that she didn't have a permit, and she quit renting. She quit advertising and renting the unit at that point.
I have a question for staff. When a permit is issued, what happens? Are they handed a piece of paper, or does it come in the mail? What happens?
No, when you pay for the permit that you've been approved, all approvals are set. You go over, you pay for it, you're handed a piece of paper. Here's your permit. So nothing in the mail, nothing much beyond that, really. It's a pretty straightforward transaction.
But when you send in your check to renew, do you get a new permit that has the new expiration date?
You do not. The canceled check, which is the manner of payment for 90% of the renewals that come in, is treated as the de facto receipt, an indication. So the original permit that you received is still considered active and valid at that time. However, there's no new piece of paper mailed out.
So I've got a question. What this is an owner-occupied?
No, non-owner-occupied.
This is a non-owner-occupied.
Correct.
And it's eligible for a non-owner-occupied.
Based on the downtown code being the base zoning district there, that's not problematic with regard to type 2 permits.
So why would codes be told that the applicant didn't operate an Airbnb?
I'm not, again, the only thing we know is the correspondence and the communications we've received. My client has checked her phone record. She has a single phone. She didn't have the conversation with code staff that was reflected in the presentation because she never talked to anyone at codes during that time period. She didn't receive a letter saying that she wasn't in compliance until January of 2018 when she stopped renting the unit. So she thought up until the time she tried to renew her permit in 2018 that she was operating under the valid permit that she had renewed in 2017. And she had got a notice from code, which we submitted to this board, dated October 23rd, 2017, that said, it's time to renew your permit, which expires on 1/8/2018. So the notices from codes are telling her, I've got my permit and it's in place.
Did the check cash, the 1/5/17, did it clear the bank?
No, it did not. And my client was in the process of getting ready to have foot surgery when she sent the check in 2017, and basically was recovering from that foot surgery for several months. And she said, I just didn't think about it. So in this case, we have a person who didn't think she was operating illegally. She didn't have any notice that she was operating illegally until she got the letter in late January of this year. And at that point, she quit renting it. I've seen it. There is an ad like on Red Awning and on Hotels.com that says it's for this address. But when you look at the pictures, it's not her unit, and she has no connection or relationship with those people. That's not who she's advertised with. So we don't know how that occurred. We just know it's not hers. She's not rented anything since.
So which sites did she use when she did rent it?
VRBO, Airbnb. Mostly VRBO, but not Hotel.com, not Red Awning. Like I say, I've seen that ad, and we ask her, is this your unit? And it's got pictures in the ad, and it's not her unit.
The pictures are not her unit?
Not. They're another unit in that building, but they're not hers.
Mr. Osborne, there's a famous country song that says, "That ain't my truck." They're saying that's not their unit.
March 5th, I responded to an email that Kim had sent me. And basically at the end of it, I had mentioned also the listings below are not in compliance. The hotel's listing has your address listed, so you may want to look into this. I knew it wasn't the same unit, didn't have the same pictures of the same unit. The other one, however, does fit her profile, which is a different unit that has a permit displayed, but you can't read the permit number, which is why it's not in compliance. Now, the continued rentals, I can show you through her profile page, are from the same name that was listed on the 852 advertisement.
The 852, what is that?
The advertisement for 852 First
okay,
Avenue?
the unit number, okay. So, what is this?
So, yeah, help it feels muddy. Help us clarify.
I'm
Based on
saying
what
that
you've heard and what you know, tell us what your position is on this.
I'm inclined to go to court and get a 3-year injunction.
Because tell me again, and the evidence that you have that, she's continued to operate after
Yes.
being told not to. Give us a summary of that. I know you've told us from my dense head. Tell me again.
Okay. So there have been at least, looks like 6 reviews that popped up on her Airbnb profile for the same unit that we issued a warrant for.
And how are you convinced that it's her unit and not, as they testified, someone else's unit, someone using her address but a different unit?
Okay. It is on her profile page. It has the same description for that unit.
When you say that unit, you're saying the 852, her unit.
The name of that advertisement is Perfect Location, Walk to the Action, Broadway Bars. That's the same one that's mentioned in these reviews.
I have a question about the telephone call.
Yes.
Is that typical that you would call the person attempting to renew? Tell me about that.
I didn't contact her to renew. She was sent a tax violation notice and somehow got my number. I don't know how. Because my name's not on that letter. It says Piper.
So a person contacted you?
Yes.
And tell me about that conversation.
She told me that she didn't know any back taxes because she wasn't operating a short-term rental. When I looked into it, the permit was erroneously showing issued. There was no payment for renewal, so it was expired.
Well, did that person identify herself as the applicant in that phone call?
Yes.
And what did you do as a result of that?
I notified her that the permit was showing that it needed to be canceled, contacted Clint Harper to have it canceled, and then contacted Piper to let her know about the tax violations. Also, we have received, so far through court, but it's been continued several times, that the taxes were finally paid on February 20th, but that was only until December of 2017.
Okay, so she's current through December of 17 on this particular unit
As far as
for
I know.
taxes, as far as we know. Okay.
Any other questions of Mr. Osborne? Thank you.
Mr. Chair, just in response, Ms. Eldridge has a brother who has a unit in that same building.
That has units in the same building?
It's a unit in the same
Oh, a
building.
unit, okay.
And has the same profile description of his unit because she created the profile for both units.
Now tell me about these units. Are they basically the same size and the same whatever?
Yeah.
Exactly the
Yes.
same.
They're-
Same
they're-
couch, same floor, same rug, same everything. Same pictures.
So she has 2 short-term rental permits?
She has 2, and he has 1.
He who?
Her brother.
Oh, I thought you said mother. Okay.
No, brother. Excuse me, brother. I'm sorry.
So when you all were talking a little bit ago about somebody else using
There's
this,
a third ad out there that's not using the same profile on Hotels.com and Red Awning.
Did your client call Mr. Osborne?
No, she says she did not.
Did she receive the tax letter?
She says she doesn't recall and doesn't have one in her file.
But she was behind on her taxes because they've
When she
now been
came
paid
in,
up.
when she came in to reapply, she found out she was behind on her taxes and she went and paid them.
and how far back did she pay taxes? I mean, as she said, you're current through December, but how far back were the taxes paid?
I know they were paid through 2017. I'm not sure about before that.
I have an, how do we have this check for $50? I'm a little confused on that part.
I thought there were 2.
There are 2 checks.
There's one that they say that Metro never got and
right
or didn't deposit.
One is
and
the
then
copy
other
she
one-
kept of the one she sent in 2017.
But this check I'm looking at is dated January 5th of 17 for Unit 852 to renew.
That's the copy she kept.
Okay, so this is a copy. So
Yes.
she only has a copy. She doesn't have the actual
She
check.
doesn't have the actual
Okay.
check. She didn't get it.
Okay.
It didn't come through the bank. When she figured out they were claiming it didn't renew, she then started looking for it and didn't find it.
So then how do we have the second check?
Well, she came in to renew at the end of 2018, or at the beginning of 2018, and she kept a copy of what she brought in at that point.
So
So she got a, I guess did you change bank accounts in that year?
Got 2 different accounts. That's correct.
But these checks are from the same account, no?
No, they're not. They're different accounts. They're the same bank, but they're different accounts. I had the same confusion. When you look at them, they look like they're the same account, but if you'll look, the older check is on a checking account with a smaller account number than the 2018 check. They're 2 different account numbers.
Do you have to check?
And she doesn't write many checks anyway, so it's, she doesn't use checks that often.
I'd feel better if we had her bank statement showing that the check didn't clear.
But it wouldn't because
It didn't clear.
It
But
didn't
it'd
clear.
show the mark. I mean, it would show that it didn't come through. I mean, this is a copy of a check.
It would in theory, but the problem is that on that account, she's only written that check. And so, I mean, she's got the checkbook here, and the 2501 check is still in the checkbook. So I tried to accomplish exactly what you suggested, looking at what did we have that would show the sequence. And unfortunately, because she writes so few checks, there isn't a sequence.
Other questions for the applicant?
So what exactly did the other court tell you? Was it your request for us to adjudicate this first, or was it
Sure.
the judge?
The court doesn't have the jurisdiction to consider whether her permit was denied in error. Only you have that power. And that's our position, is that she thought she tried to renew. She sent the check in and was operating under that permit until she found out that apparently that Metro had never received that check.
And if you remember at the beginning of his testimony, Mr. Osborne expressed an interest of having this go to court instead of to our body.
And Metro raised that issue in court when it was deferred the last time, and the court seemed very interested in having you hear it first.
Is that?
I actually was not the attorney handling that case at that time, but it would be our position that one is not necessarily contingent on the other, that this is an administrative remedy and you can give your ruling on that case as well as the environmental court. That's a different case. So I don't know, Mr. Murphy, if you would disagree with that.
Well,
but
I mean, I think there's an argument we have to exhaust our administrative remedies before we're in court, and you're the administrative remedy. So
I would agree. I would agree with that as it relates to the administrative track, but that's an enforcement track in environmental court for operating without a permit. I presume I haven't seen the warrant, but I'm guessing that that's what is on there. And the code doesn't limit Metro to just proceeding through this administrative process, but also gives Metro the opportunity to go before a court of competent jurisdiction. So certainly this board can render a decision that doesn't necessarily prevent Metro from proceeding in court, although certainly the court could take into consideration what has been done at this board if he finds it relevant to the case, or if it moots the case, to some degree.
Or we can defer it also if we choose to do that.
Also defer.
Okay.
I guess I'm maybe discussing.
So, Mr. Murphy, what else do you have to add?
Your Honor, Mr. Ewing, I think that covers our position. I mean, basically, it's our position that she did everything she was supposed to do. She didn't realize that the permit had not been renewed, so she didn't operate knowingly without a permit, and that the permit shouldn't have been denied. If it was denied properly, then this is clearly a case of a minor situation, because she did stop renting it as soon as she got the notice. And there is this confusion by these other ads, but they're not her unit.
And I know I've asked a lot of questions, but so this applicant has 2 short-term rental permits.
Correct.
In this same unit.
In this same building.
Or in this same building, that's what I mean.
That's correct.
And are they on the same track? Do they both come up in January?
No, I don't think so.
I'm sorry?
No, they don't. They're not on the same renewal cycle.
And is the other one in effect?
You got a permit on the other one?
yeah.
Yes.
And it's effective now?
Yes.
And how does she know it's effective?
Because
she came to the BZA to get it effective just a couple of months back. I think, if I'm remembering that correctly, Mr. McMullen represented her on that matter. Same building. The second permit that's now in question was before you in a similar day where you had an avalanche of short-term rental cases, thus making it perhaps not as memorable as some others. But that's how we know for sure that there is one out there, because it was before you recently.
Okay, so but I just want to clarify that. So but that didn't come before us as a potentially expired permit.
No.
It just came before us because
because there was no permit and there had been operation.
Operating
so
without
it was
a
the
permit.
classic operating without a permit case.
And in that case, the problem was she thought the permit she had covered both. And
Okay.
I'm remembering this now.
Yep. She thought
Okay.
the permit covered both. And when she found out again that it didn't, she stopped renting it and came to the board.
Okay.
Unfortunately, we couldn't hear them all at the same time.
Yep. Okay, anything else for Mr. Murphy?
I'm asking. It doesn't get better for me the more questions I ask.
Okay. Anything else? Okay, anything else to add, Mr. Murphy? Going to close the public hearing. Discussion.
Well, I didn't ask this, and I wasn't sure how, but the thing that I'm kind of bugged by is if you go to environmental court and Metro really wants to have the case heard in court, and you kind of know what the case is. I mean, I was expecting more evidence from the applicant to say, well, here's, like I said, here, I mean, I do think that maybe they only have one check in the thing, but here are the bank statements, here are the three, here, I mean, we didn't learn about the brother for a long time, and I was like, the first thing I might say is, I can see why they're confused. Mr. Osborne says, well, this is the situation, and to me, the next statement is, oh, well, here is exactly, there are three, here are the ads, here are the, and I get it, but to me, I'm inclined to let somebody else figure this one out and send it back to environmental. There's something about it that, as you said, the more I heard, the muddier it got, and
there's something, I don't know, that well, there's a lot of things I can't put my finger on in this case, but can we open the public hearing for a second? So I'm gonna,
sure.
When was this other bank account opened, and was the other one closed?
She has multiple accounts. So
they're both still active?
Yes, that's correct.
Yet she's only written one check out of one of the accounts?
That's correct.
I do everything electronically. I don't write checks. I don't even hardly know how to write a check. I mean, and the only reason I wrote the check for the 2017 is because I think 5 days later I was going in for a major foot surgery and I was out for 3 months. And I never even looked at the account. I mean, my job, it's automatically, deposited, and I don't, everything I do is electronic. I don't write checks.
And Mr. Taylor, in response to your comment, until I heard what staff was saying, it was hard for me to respond. We knew about the red awning, the other ones that are her brothers, that's news to me. So I'm trying, I wish we could figure it out as well, but I mean, there is this problem of someone using her address for ads that are on hers.
And I guess what I'm looking for, I mean, and I'm trying to figure out where the burden is, but I mean, I've certainly heard testimony, but with all the muddiness of it, I don't have proof. So I'm saying, and saying that we did, I mean, and again, I'm not, that's just kind of where it is. So what is the proof that there are three exact same units that are, three units, two to your client, one to her brother, that are listed exactly the same, that look the same, that may or may not have the same address. And I mean, like, that's what I'm saying is that, and whether it's your, whose burden, I don't know, but that's what's missing at this point for me is what is, we've heard from codes that there's an awful lot of activity going on at that piece of property. And we've had testimony from you all that says it wasn't us, but it feels like the burden's on you all to say, especially given the situation of this. Now, don't get me wrong. I think the renewal letter you got, certainly is something I would bring to you, bring to this body too, and say, well, it looks like I did everything right.
And our problem is we don't know who's doing, we don't know who's putting up the ads. So part of this is we're being put to a test for information we don't have. The only thing I've got is my clients saying she took the ad down as soon as she got the notice from Metro, and she hadn't rented it since. And so, that is all we have. We don't have the resources that Metro has to, troll the internet to find all the ads.
But you have the resources to print out the two ads that you all have and the ad to your brother.
Well, we don't have it. I mean, that's it. Right now, we don't have an ad. She's taking it down.
Right.
I'm afraid to take my check that day. Why didn't you know it was expired?
Anything else to add before we, okay, we're going to close the public hearing again.
Thank you, Chairman. I don't know. And from a legal standpoint, I really don't know the answer to this, but Mr. Taylor alluded to the who is the burden upon, when the line is, it must have gotten lost in the mail. Obviously, I think the burden is on the person writing the check, but since there is no receipt other than the canceled check, and I couldn't tell you if one of my checks didn't go through. I write so few, and I don't even bother looking at them. I'm very sympathetic to that argument.
Even if it was the only check you ever wrote out of that one account.
Well, I don't think she said that was the only check she wrote out of the account. I think she said she had two accounts. It's the only one she wrote out of that checkbook.
Well, it was testified that was the only check she'd ever written out of that account, and that check number 2,501 was still in the checkbook.
Well, that does raise my more suspicious thoughts about why there's only one check written out of a checkbook and out of an account. But
any other discussion?
I would just throw out there that, Mr. Osborne comes in front of us every time we meet, and he's saying a couple of things. He got a phone call from somebody saying, as to this unit, saying it wasn't a short-term rental. And he's seeing ads. He believes strongly that there's the same person on the profile. That gets a lot of weight with me. On the other hand, we have an applicant who, as of January 2016, knew she had to have a short-term rental permit for short-term rentals. Yet she was before us recently for operating another unit without a permit, and we granted a permit. Now, I don't think we can't consider those cases, but we can certainly look at her knowledge. We now know that there was she did know. On that second one, she did know because she already had one. She knew you had to have a permit. And so I got to consider that in light of what Mr. Osborne is saying. Even though I would prefer it if there was some kind of receipt. You ought to get a permit. How hard is it to send a piece of paper to say you have a short-term rental permit that expires on a such and such date? The permit she had doesn't even show an expiration date. So I do think that is a problem procedurally with people trying to keep these in line. I really, on this occasion, I tend to think, based on Mr. Osborne's request, that we let it go to environmental court. We've heard it. We can close the proof. But I feel like, based on that request, we should let it go. And I would tend to grant that request. That would be my thought.
Other discussion?
So are you saying that we should vote on something or defer it?
Well, it's convoluted, and I'm not sure how I would rule. And because Mr. Osborne has requested that it continue to environmental court because he wants to pursue that investigation, I'm inclined to let him do that over the objection of the applicant.
We took up the case today, and we heard everything. This is deliberation time, so.
Well, to that, that we've heard all this, I lean to deferring action until it goes through court, because I think that might bring some clarity, might bring us some information that we're missing.
Well, I think the testimony of Mr. Murphy was the court deferred it for us to take action. And here we are.
Yeah,
But our investigator wants to do.
I know.
I'm just saying that's my
But
thinking.
according to Mr. Murphy, it was going to go to environmental court, and then they said, hey, we'll go to the BZA, and, And according to our lawyer, even if we rule, that doesn't mean that Metro cannot still ask to go to environmental court.
There's a lot of circumstantial stuff here, and it's all piling up, and I feel like it's, in my view, it's unfavorable to the applicant, and I want to be as fair as possible to the applicant, but I'm also afraid that, and I'm speaking for myself, that I might be missing something here that that is critical, and I'm sort of hoping that at a level of the court, which is much higher than we are, some information might be gleaned that would clarify all this. That's me saying I'm okay with punting it.
Ms. Sanford.
How do we punt it, so to speak? What is the process? I'm not clear.
Defer it.
I guess
Mr. Chairman, the board does have the option if, in fact, they wanted to consider keeping the matter open until the court heard the matter and had whatever ruling they have, of deferring the case to a date definite. It's our understanding that the matter is set to go forward next Wednesday in environmental court, which is May the 16th. Mr. Murphy or his colleagues may be able to correct me if I've got that date wrong, but that's our understanding, barring any other scheduling changes from the court or the parties. Toward that end, although we are jam-packed on both May 17th and June 7th, we are able to put one on for the board's consideration, but you do have the ability to defer this case, keeping the hearing closed and just take up the vote at a later date based upon whatever information comes in from the court, or you have the ability to reopen the public hearing should you deem it appropriate at that later date.
And is there, that I had just asked, and I'll ask it to all the lawyers on this side of me, is there another option where we could vote on whether or not we believe the zoning administrator erred or did not err, and if we said the zoning administrator did not err, then leave the penalty part open until the environmental court case is heard? Because if the environmental court comes out and says, we find something and your penalty's longer than a year, then we've got, then this deliberation is moot. But if they come back and are cleared in environmental court, then that would be the additional information that we need. And that way, at least we're sending a signal to the environmental court that, yeah, no, they rented without a permit or didn't, depending upon what we decided. And then yet, with the clear understanding, we'd like for environmental court to continue this case.
Or to continue hearing that case?
Yes.
So to answer to your question, can the board take that approach? Does the ordinance that governs the short-term rentals does not contemplate that, but does not speak against it either. Ultimately, you're merely required to reach a ruling with regard to the original yes-no question, did the zoning administrator err? And then secondarily, do we see fit to reduce the 12-month period at all? I think that you probably can do it that way because you don't have to be authorized through that ordinance to come down with your final order in any specific manner. I recognize from what you're laying out the potential pragmatism in that approach. Yeah, counsel from Metro Legal may view it differently, but I don't think the ordinance speaks to it one way or the other.
No, I agree with you, Mr. Michael. The only thing that I would caution the board about is that there was a request initially to defer the case, and the board at this point has opened the public hearing and heard the case. So I think at this point, the board has to take some action within the next 30 days,
Yeah.
or it's going to be a denial. So you can't just.
I agree with our lawyer. I mean,
Yeah.
We were specifically asked at the beginning of this to defer, and Mr. Murphy responded to that, and then we proceeded with the case. You know, when we heard everything, closed the public hearing. You know, I understand the strategy or the logic behind us versus environmental court first, but I think since we undertook this case and there wasn't, I mean, people say that they're confusing facts, but that's what we do. And absent of, no one, I think, has said, bring me some information outside of just what the applicant claims they don't have. So I think we have everything in front of us to make a ruling.
Do you have a motion?
Do I have a motion? Yes. I move that we find the zoning administrator did not err in case number 147, and that the applicant be eligible to apply for or to obtain the or apply for the short-term permit 3 months from today. Is my motion. Is there a second? Okay.
Are you willing to increase it?
I'm willing to increase it.
'Cause I really-
Okay, what's?
I'd say no
Okay.
less, I'd say 6 to 8. I've heard a lot of things.
Okay,
that are
6 to 8,
problematic.
okay.
I mean, I I mean, I'm kind of stuck on finding that the zoning administrator didn't err and putting off the penalty till after environmental court, because I don't, there's something about it that it's.
But I understand that part, and I would, let's say, I'll just accept, I will accept 7 months. So is there a second to 7 months?
I'll second it.
Okay, motion's been made and seconded. Discussion. Now, what I was going to say related to that, and I understand that. I think at the time for us to have done that is at the beginning of this hearing, that we heard the case, Mr. Osborne made that request at the top of this case, and we had Mr. Murphy respond, and, you know, we didn't say, wait a minute, hold up. And it's interesting, as you know, we have 15 more cases to go. So it would have been nice to defer this case, but we didn't, and we heard it. And like I said, I don't feel that deferring this gives us any more information if it came back. You know, the applicant says whatever we asked for, they just don't have.
Yeah, I mean, and you know, and I guess that's fine to me. If you feel like it should be longer, then it has, you know, then it just, if 4 agree, that's fine. If 4 don't agree, then it's held up in votes, and then it's the equivalent of a year, which is the most we can do. So.
Okay. So motion's been made, properly seconded. Any more discussion? Seeing none, all those in favor of the motion signify by saying aye and raise hands. Aye. Opposed? Okay, 3-2. John Michael, what does that mean?
Board can take up a different motion if they wish, whether with regard to the yes/no question on behalf of the zoning administrator or the punitive measure with regard to reduction of the 12 months. However, if there is no vote that obtains, no motion that obtains 4 affirmative votes, then the case stays on the board's agenda for 30 days, comes up on the next available docket, which in our case is 1 week from today, May the 17th of 2018, at which time any absent board members, in this case Ms. Karpenek, would have the opportunity to review the case file and the entire proceedings and place a vote in that matter. Even if then any case fails to get 4 affirmative votes in the allotted amount of time, then the matter is denied by operation of law.
Yep.
That pursuant to statute, or rather to ordinance.
Okay. Does anyone have another motion? Seeing none, looks like we're done. John Michael.
The next case to be heard by the board is case number 2018-162, and to put a bow on that final matter, it will be on our May 17 agenda for the BZA meeting, 1 p.m. on that day. Case 2018-162 involves Carla Lee, the appellant, for the property at 301 Rosa L. Parks Avenue, unit number 200. We will note that case number 163 is also a case for Carla Lee, same address, 301 Rosa L. Parks Avenue, just unit number 318. The board might wish to take these matters together, vote separately on the cases, but hear them together, given that it is the same appellant for the same structure, the same street address, just a different unit number in the 2 cases. Here we go. This is an item A case in both instances regarding short-term rental permits. The zoning map shows you where this is along Rosa L. Parks Boulevard near the cross with Union. The aerial photograph here shows you where you are in that portion of downtown. Obviously, this is Council District number 19, Councilman O'Connell's district. Is there anyone here in opposition to cases number 162 or 163? Seeing no one, the appellant will have 5 minutes to make the desired presentation after we hear from staff with regard to the violations.
Okay, please. Oh, Mr. Osborne, yes, tell us how you heard about this case, any non-permit violations, and any other, how many times it was rented, and why do we have 2 separate ones?
There's 2 separate ones because it's 2 separate units applying for permits.
And what kind of permits? These are both?
These are in an apartment complex or condos, something of the sort. Host compliant?
Neither is owner occupied. Is that correct?
That's my understanding.
Non-owner occupied. Okay. So how'd you hear about these, and how many times have these been rented, if at all?
So we sent a letter through Host Compliance on February 10th of 2018 to both of these properties. One was rented approximately 11 times, the other 19 times.
Which one was which?
200 was about 11, and then 318 is 19 according to our records. It may be more.
Okay.
Looks like the advertisements were removed shortly thereafter. I don't have any other records of complaints.
Any other questions? Okay. Please identify yourself for the record and address.
My name is Carla Lee. I reside at 922 Montrose Avenue.
So why are you here, and why don't you have, you have 2 units and 0 permits?
Correct.
So how'd that happen?
I'm here to represent the owner of the property.
And who is that?
Well, it's Lofts at the Reserve LLC, but the principal's name is Ben Willingham. I'm the property manager.
So John Michael, I have a question for you. This is owned by an LLC. How does that affect us?
It doesn't in this instance because they're non-owner occupied. As you know, Council Bill number 2017-608, specifically amendment, I think, number 8 from Councilman Mendez, the Natural Persons Amendment, required that owner-occupied permits be held by an actual human being, not a trust, an LLC, or any other corporate structure. In the instance of Type 2 permits or non-owner occupied, I guess is the more technically accurate phrase at this point, post 608, not as much of an issue.
Okay. Please continue.
So this is a 62-unit apartment property. The owner of the building has these 2 units that he had on VRBO, not Airbnb.
This is the former Federal Reserve building for those.
Correct, yes. So we're right across the street from the Tennessee State Tower.
Yep.
If you've gone by there recently, you might have seen where an MTA bus hit the building, but that has nothing to do with today, but it's comical. The owner of the building has been paying taxes since 2015. But we received the notice in February 2018 that we
So
were
the
not
owner of the entire building is really the applicant here?
correct.
So how much, I mean, roughly, do you know how much they bought that building for?
I do not know, no.
Well, I imagine it's in the millions of dollars. Is that safe to say?
Correct, yes.
Okay. So someone that buys real estate in the millions of dollars, how come they were not aware of our laws?
I am only going to say what I know. I can't speak behalf on the owner in this regard, but I know that it's an apartment building. They were under the assumption, which we now know is a wrong assumption, that with it being an apartment building and that everyone who lives there is a renter, they sign a lease, that it was, I guess they were thinking that it didn't apply to them.
So you said that this 301 8th Avenue LLC owns the whole building?
It has 2 owners. Well, it's the way that the property is structured. There's 2 ownerships part of it. There's the principal owner of Lofts at the Reserve LLC, and then there's the 301 8th. Let's see if I get it right. The number 301 8th Avenue LLC. So there's
How many
2.
units do they own in the building?
He owns every unit in the building.
Why isn't this like a type 3?
Because that no longer exists. It did at one time. However, there are instances where technically people met the definition of both 2 or 3. However, it was easier to categorize them as 3 in multifamily structures. For purposes of our analysis under the current iteration of the law, namely 2017-608, which has been in effect since January, they're merely considered non-owner occupied.
Okay.
A question was asked earlier about purchase price. The last we could tell was that in 2013 there was a transaction for $4.25 million. However, the subsequent transactions appear to be for portions of the building or perhaps even individual units of much smaller numbers.
So this is the first case we've heard of type 2 since the law changed that I remember, or at least of this matter, where somebody owned multiple units. So it's good to know.
And yet not the last, Mr. Taylor.
Again, why would someone that puts together a couple real estate LLCs that buys a $4 million piece of property not hire a lawyer or figure out what our laws are in the city of Nashville?
He has a lawyer, an accountant.
And nobody advised him, if you're going to do this, there's laws related to that?
Not that I'm aware of.
Are there other units that you?
These are the
Are we
only
going to see
2.
more units from this
These are the
building, or are
only
these the
2.
only 2 that you?
These are the only 2 units that the Lofts at the Reserve. Many these units are typically used by investors who come into town and stay. They invest in the building or other buildings, and they stay here because hotels are hard to find. Why not stay in a building that you've invested in? And then we have residents who have family and friends that come to visit, and they want to, you have a studio or a 1-bedroom apartment that aren't feasible for housing multiple individuals. So we offered that as an option for our residents as well.
And so because you rent it for under 30 days, it's technically a
Yes,
short-term
that's
rental.
correct. But we've had folks who stay longer than 30.
Do you advertise it on VRBO?
That's the only one that is advertised on. No longer, it was on VRBO, but not Airbnb.
And why is that?
No idea why, just not acquainted with Airbnb. Never used it, just VRBO, personal use.
Okay.
It's long-standing, it's been around for years.
So,
Very reputable.
when did you all find out that you were in violation of our short-term ordinance?
When we received the letter in the mail in February of 2018, and then I called Mr. Osborne because it was requested of me to reach out to him to see what we needed to do to get in compliance.
What did your party that owns this building, as far as the LLC, have to say about this?
Well, obviously they're disappointed and frustrated themselves that they didn't understand that they were not in compliance as they thought they were. I mean, they've been paying taxes. They thought they were doing everything correctly. They do understand now that they're not. They're accepting of whatever is received today, but they would hoping for leniency.
Okay. Questions for the applicant? Do you have anything else to add?
No, I just want, if anyone, I just know that when I reached out to the county's collection for taxes to ask if I needed to do anything, they had it on record that we'd been paying taxes, hotel taxes, for over 3 years.
Okay. We're going to close the public hearing. Discussion. So they have been paying their taxes for 3 years. But once again, I mean, this isn't the person that has a little house out in somewhere in Davidson County that's just kind of renting it extra money. This is a sophisticated operation that has 2 LLCs, has bought a prime piece of downtown real estate, has lawyers and accountants, and obviously no permits. So, how do we handle this?
Yeah, I mean, but, you know, and also a multi-unit building where they just reserved, it looks like 2 units.
For this.
For folks, and so, you know, I mean, I think it's the 4 month.
I say let's
They pay
get
their
them in
taxes.
compliance.
Or whatever, I mean,
Okay.
so if y'all want to make. or
Who wants to make a motion?
less.
Who wants to make a motion?
How many were you thinking?
I mean, I would make a motion that we find the zoning administrator did not err and they can apply for their permits 4 months from the date of application.
Okay. Motion's been made. Is there a second? Motion's been made, properly seconded. Any discussion? We're going to vote separately these 2 cases. So that's for case 162? Your
Yes,
motion
I'll
is
make that motion for
162, and that's fine for you? Okay. All those in favor of the motion signify by saying aye. Aye. Oppose? Passes. Next motion.
With regard to case 2018163, I make a motion that we find the zoning administrator did not err and that the applicant can apply for the short-term rental permit 4 months from the date of this application.
Okay, motion's been made, properly seconded. Any discussion? Seeing none, all those in favor of the motion signify by saying aye. Aye. Opposed? Passes. John Michael. Good
Thank you
luck.
very much.
Case number 2018-164 involves the appellants Jonathan and Jovelyn Quilton and the property at 5204 Ryan Allen Circle. Shown here on the zoning map, shown here in aerial photography. It's an item A appeal involving a denial of a short-term rental permit. If the appellants would come forward at this time, is there anyone here in opposition to case number 164? Seeing none, the appellants will have 5 minutes to make the desired presentation after hearing from staff.
Applicant?
Do we have an applicant, John Michael?
Have a seat here at the front.
Okay. Mr. Osborne, tell us about this case, anything we need to know, how many times it was rented, and any non-permitting violations.
So this one did have a permit at one point. Looks like it was permitted on January 18th of 2017. We did receive a complaint about it advertising over occupancy in bedrooms.
Over occupancy?
Yes, sir.
How many?
They were advertising for 3 bedrooms and 11 people. Their permit was for 2 bedrooms and 8 people. Did take a little while to come into compliance on that. Notice was sent on August 4th. They came into compliance on September 19th. My understanding that the permit was expired on January 18th, and they had tried to reapply.
How many times was it rented, and was it rented any time after the permit had expired?
It looks like there were 2 reviews from February.
Okay. Any questions for Mr. Osborne?
I thought they didn't get a permit until January of 2017.
Yes. So it expired in January of 18. They were late on their renewal.
Okay. So since it expired, you're saying it was, since January, it rented how many times?
At least 2.
Okay. Any other questions for Mr. Osborne? Okay. Please identify yourself for the record and your name and address.
Good afternoon. My name is Jovelyn Keaton, and this is Jonathan Keaton. Our address is 5204 Ryan Allen Circle. So we actually applied for a 3-bedroom permit. The house is a 3-bedroom, as you can see from the assessors. It's registered with the assessors as a 3-bedroom, and even with the applications, documentations, it is a 3-bedroom house. And we didn't really expected, or actually we didn't see that the permit is for a 2-bedroom because the house is a 3-bedroom house. So it came to our attention only in August that, hey, your permit is for a 2-bedroom. Why are you advertising it for a 3-bedroom? And so I was confused at first. I didn't get it. And so we tried to figure it out and said, oh my goodness, the permit is for a 2-bedroom, but our house is a 3-bedroom. And we applied for a 3-bedroom. But nonetheless, when we got that notice, we immediately called our advertisers to correct the advertisements for a 2-bedroom. And so come January for the renewal, they said that we are in violation the previous year. They cannot renew our permit. And so during that process of communicating, I immediately contacted Mr. Harper of the zoning department to see what we can do, and only to find out that I have to come to an appeal over here.
Okay. Why didn't you renew?
We did, but it was denied in January. Before January, yes, we did. There was a follow-up, but it was denied, so I was trying to argue with them, or at least present my case that this is a 3-bedroom house, so you should, they deny us because of that violation, that they're saying it's a 2-bedroom, but it's not. It's a 3-bedroom house.
Who is Jack Thomason?
He's our property management that applied for the original permit on our behalf.
Any questions? Well, so, okay.
Chairman, very noteworthy to Ms. Chappell's question. This is a company that manages a lot of short-term rental properties around Davidson County. So to the extent the applicant is listed as this individual, that would have been the individual who stated that this was a 2-bed, 8 max occupancy rental, not the property owners in that instance. Although they may have communicated in the front end, this is where we would have gotten that information. I've mentioned that in an abundance of fairness to our applicants
Now,
today.
does the expiration of this have it? I guess it feels like this 2-bedroom, 3-bedroom thing's kind of a muddiness of the issue, whether they.
It represents a violation of the ordinance to advertise for more than you're permitted for. The permit said 2, you advertise for 3, it's a violation. So with the open violation at that point, that was a basis whereby the renewal was denied. This is the appropriate forum for the property owners then to come forward and ask for that action to be changed.
If they've written down 3-bedroom and 10 people and had the proper fire,
Smooth
smoke
sailing.
detectors, yeah, okay. Any other questions for the?
Sorry, to clarify, you asked about the number of bedrooms. Number of bedrooms and max number of occupants both have to be correct. Just
Right.
I know that's.
But
a
if they had
technicality,
asked
but they
for
have
a
to have
higher
that.
number within the law,
Right.
it would have been, and complied with the safety regulations, that's what. Any other questions for the applicant? Anything else to add?
No, it's our first year, so we're learning to look at details. But really, in the floor plan, because we're required to submit the floor plan, it's clearly seen there that this is a 3-bedroom.
Is that the floor plan you submitted?
Yes.
Can we see that?
Yes, sir.
Okay. But you relied on your management company to actually fill out the application?
Yes.
Any other questions? So we submitted a 3-bedroom with smoke detectors in every
Everything in place.
potential space. The X with the circle, the red circle is the smoke detectors, okay. Any other questions for the applicant? Okay, do you have anything else to add?
No, thank you for this opportunity to come before
Okay.
you guys.
We'll close the public hearing. Discussion. So this is one that I'm not sure we've had before. We had somebody that basically, I was just under the assumption that most people asked for the maximum amount of bedrooms and people, and they didn't. And when they tried to reapply, or when they listed something within the law but not in their permit, then they got dinged for renewal. So,
But meanwhile, they expired.
well, they expired because they didn't allow them to renew them when they sent out the, you're in violation. So it's like you rented without a permit if you're renting not under the terms of the permit. That's my understanding. So, board members, discussion.
This is the nicest floor plan I've ever seen.
Yeah.
We've seen a lot of handwritten.
Well, I mean, they had a company submit it for them, and that rents a lot that should know what they're doing. But it sounds like somebody just made a typo, but.
Not a typo, but they asked for the wrong thing.
They typed in the wrong, yeah. Whoever.
I'm not sure if it was a typo. They should have asked for the maximum, and they didn't. So, does anyone have a motion?
I mean, I guess, I should have asked Mr. Osborne if there was any reason to think that, I mean, this feels like it's an administrative issue with the original permit. Is there any reason to think that this is anything other than a kind of an honest mistake there?
I don't know. Even if it was permitted for 3 bedrooms, you still can't advertise 11 with 3 bedrooms.
Can't have what?
Advertise 11 with 3 bedrooms. Who did your advertising? Your same rental company that you entrusted?
Yes, sir.
Figured as much. Okay. Motions, discussions. And Mr. Osborne, that was advertised for how long? Did you actually have, not that this matters, because the advertisement is a violation, did you have reviews that said that there were like 11 people there?
I'll have to check real quick.
So people watching at home, it is the advertising that's a violation, not the rental. It's a perfect example.
Not that I'm seeing.
Okay. Discussion. Anyone have a motion? We've got plenty more left, so let's.
Okay, but
I'll move that the zoning administrator did not err, and that the applicant be allowed to apply for a permit 3 months from the date of the application, which is 3/15/18.
Okay, motion's been made. Is there a second?
I just thought because it was expired, we had to determine if it would be reinstated or not. But maybe I'm reading that wrong.
John Michael?
The expiration stemmed from the fact that we denied the renewal opportunity. The renewal being denied was predicated on the violations for too many things. So that's where you're kind of in the business of not just being in a yes/no, but determining whether or not there can be a reduction of the weight.
Twice. I'm sorry.
It's
I
okay.
just get confused between the agenda. and
Understandably.
what we talk about.
Second the motion then.
Okay, motion's been seconded, or made and properly seconded. Any discussion? Seeing none, all those in favor of the motion signify by saying aye.
Aye.
Opposed? Passes unanimously. John Michael.
Thank you.
Mr. Chairman, the next case is the Border case 2018-165 and 2018-166. These are brought by the same appellant through the same ownership entity, and I would recommend hearing them both and then providing separate votes. Chris Gerbig is the appellant, JT Real Estate LLC, the owner of the property at 1105 Archer Street, shown here on the zoning map, and then 1113 Archer Street, just a couple of units up in this same development. The request is for short-term rental appeal. These permits were canceled based upon a change in ownership from Mr. Gerbig's individual name up to the LLC identified in your docket. Is there anyone here in opposition to cases 165 or 166? Seeing none, Mr. Gerb will have 5 minutes to make the desired presentation to the board. Again, to be clear, this was not operating without a permit. This is somebody that got a proper permit, but because no transfers are allowed, a change in ownership cannot transfer the permit back into a new entity. So that's the cases before you today.
And then are these eligible for type 2 permits?
That's what was originally issued. Let me double check the zoning from my case file. Okay, these properties are zoned RM20, which is one of the properties that's eligible for type 2 or non-owner occupied permits, as opposed to R and RS type properties, which of course are not eligible. So in this case, they would be eligible if in fact the board deems them so.
Okay, so it wouldn't have that. There's not that weightiness of. Okay.
Begin.
I bought 2 properties in Nashville.
State your name and address for the record.
My name's Chris Gerbig. I live at 206 Grand Teton in Bowling Green, Kentucky. I own the properties at 1105 and 1113 Archer Street.
Okay. How'd this confusion happen? Why'd you change the ownership of this?
I bought 2 houses in the Gulch. I applied for permits, got the permits, paid my fees, did everything the right way, paid taxes, all that. I was having really good success. My accountant advised me, hey, you should probably put this into an LLC instead of your own name. So I did that.
Was that just for liability reasons?
Just for liability and just at the advice of my accountant and my lawyer.
And I take it your accountant is in Kentucky.
He is, correct.
Oh, bad move.
So who is the LLC just you? It is, yeah. That's what confused me is because I was still the owner regardless. Now I know that even though I still own the LLC, it's still a change of ownership, and it was my mistake. I didn't understand, and it was my fault. So I take full responsibility of that. I switched the house into an LLC in June of last year. I didn't hear anything. I sent in my renewal for both properties in January of this year, so about 7-8 months after the switch. I still didn't hear anything. I sent some emails to a few people in zoning. I think I sent one to Mr. Michael, and I've talked to you a couple times. And I got the letter back saying due to change of ownership, your permit's denied, it's canceled, you can't change ownership.
John Michael, I think I asked you this question earlier. So these types of short-term rentals are eligible to be owned by an LLC, but the change of ownership is the issue that kind of messed it up.
Right.
And I guess in terms of remedy, I mean, if you change ownership, you can reapply, right?
So why wasn't?
But then if we,
it was I guess he rented after all this, and that was the violation.
Upon receiving the letter that says your permit was canceled, that's when I tried to communicate with some people to figure out what happened, because at that point I didn't know. And that took maybe a couple weeks. And at that point I received a letter saying, hey, we have your listing still up. Now you're operating without a permit. So at that point I shut everything down, canceled bookings, did everything short of selling the properties so I could try and renew my permit. And then when I came to apply, I was told, no, you can't get one because you've operated.
Yep. Okay.
So
does that answer your question?
I apologize. It's my fault, but I do feel like it was a minor issue. So.
We have.
But so, okay, so even if we find that everything, if we find the administrator did not err, he still has to apply.
well, but I think that the fact that it changed to an LLC said that he didn't have a permit then, and then therefore, I think the remedy needs to be for the LLC renting prior, because.
We at the staff level have never pursued action against entities for the change in ownership. For example, and I'll make up dates here. If Mr. Gerbig had gotten his permit on January 1, changed ownership structure on June 1, as that permit approached the end of its 365-day permit period, as all permits are by law explicitly, very clearly to everyone, one-year permits and one-year permits only, and they should not ever be surprised by the expiration of a permit at the end of 1 year. Not applicable here, but in every other case we seem to hear. We don't go after Mr. Gerbic or his LLC for the action between June 1 and the end of the calendar year. However, if after cancellation of the permit, which say takes place the next January 10, if there is still a listing after that letter has gone out or rentals after that letter has gone out, those represent violations for operating without a permit, which is how someone comes in, makes a new application, is denied by staff when they see that there's been this action after the cancellation, expiration, or other termination of the permit.
So the
Hope that cleans
LLC
that
is really making this appeal.
Beg your pardon?
Would the LLC not be making this appeal since they're the ones applying for the permit?
I think Mr. Gerbig's identified himself as the representative for the LLC.
I would just like to
Oh,
have the
okay,
ability to
I'm sorry, I see.
reapply
Yes, all
at
right.
some point in the near future.
Okay.
Okay, so any questions for the applicant? We will close the public hearing then. Or you have anything else to add?
No, sir.
Okay, we'll close the public hearing. Discussion.
Well, it feels more like a clerical oversight on the appellant side, and feels very minor to me.
Yeah.
Anyone want to make a motion?
All right, so for case 218-165, I move that the zoning administrator did not err and that the applicant be eligible to apply 2 months from the date of application, which was 3/15/18.
Okay, motion's been made and properly seconded. Any discussion? Seeing none, all those in favor signify by saying aye. Aye, oppose, passes unanimously.
And
Next motion.
I would move the same for case 218, or 2018-166.
We'll repeat the motion again then.
We find that the zoning administrator did not err and that the applicant is eligible to apply for a permit 2 months from the application date, which is 3/15/18.
Okay, motion's been made. Is there a second?
Second.
Motion's been made and properly seconded. Any discussion? Seeing none, all those in favor signify by saying aye. Aye, oppose, passes unanimously. We have good lawyers in the state of Tennessee.
I have a lawyer in Tennessee. My accountant's in Kentucky.
We
So
also
maybe I'll
have
switch
good
it up.
accountants here too that are familiar with our laws, so
Okay,
good luck.
appreciate it. Thank you all.
The next case to be presented to the board is 2018-176. The appellant is Samil Shah. He's both the appellant and owner of the property at 1809A Allison Place. The request, of course, is an item A appeal involving a short-term rental permit. The property shown here in the aerial photograph, and here, photograph from the tax assessor's website gives you an idea of where we're talking about. Is there anyone here in opposition to case number 167? Seeing none, the appellant will have 5 minutes to make the desired presentation to the board after staff makes its presentation.
All right. So we found out about this one through host compliance, sent a letter on March 4th, 2018. To my knowledge, we don't have any other complaints about it. And looks like there's been about 15 stays.
15, okay. And we have any questions from Mr. Osborne?
Any stays post notice?
No, it looks like it came down. Looks like the notice was sent March 4th, and it looks like it was removed on or before March 11th.
Okay, we have an email from Councilman Colby Sledge, the duly elected councilperson for the 17th District, and he says about this case, his position to approve. The appellant has reached out and ceased renting during the appeal process. I have no complaints on file for this property. So please identify yourself for the record and address.
Good afternoon. My name is Samil Shah. I live at 1809A Allison Place.
Hey, why are we here? What happened?
I wasn't aware I needed a permit to rent out on Airbnb, and once I found out, I received a letter on March 11th or 10th, I believe, and immediately took the listing down, contacted all my existing reservations, canceled them, and back paid all taxes.
How'd you hear about Airbnb?
I've used it before on trips out in other cities.
And why didn't you do a little bit more research than you obviously did?
I wasn't aware that this was even a thing. I didn't do my research.
You pay any taxes?
I pay all my taxes.
When did you pay your taxes?
I think I was all paid up about 3 weeks ago.
When you got the letter?
Yes. A little bit after I got the letter, once I could reach out to collections and figure out how to pay them.
Okay. Any questions for the applicant? Anything else to add?
I think that's it.
Okay, thank you. We're going to close the public hearing. Discussion.
I mean, I'll move the zoning administrator didn't err, and that the applicant is eligible to receive his permit. Apply for the permit. I mean, I'm leaning 2 months from the application date.
Is that your motion?
That's the motion.
I'll second that motion.
Motion's been made and properly seconded. Any discussion?
The motion is leaning 2 months.
All those in favor of the motion signify by saying aye. Aye. Opposed? Passes unanimously. John Michael.
Next case is 2018-168 involving the property at 929 Gale Lane in Council District Number 17. Andrew Steffens is the appellant and owner of the property. This is an item A appeal involving the denial of a short-term rental permit for the property shown here in the aerial, here from the face in the 2016 photograph. Is there anyone here in opposition to case number 168? Obviously, you already have the commentary from the district council member from 17 on the file. I believe the appellant has indicated he has at least one individual with him who wishes to speak in support of the application. Because there's no one here in opposition, the appellant and anyone else he wishes to have speak will have 5 shared minutes to address the board after the staff presentation. Mr. Osborne.
Okay, Mr. Osborne, how did we hear about this? Is there any other non-permitting violations, or how many times was this rented?
So I don't have any records of any other complaints. It looks like we sent a notice on March 4th through host compliance for not having a permit. Looks like there's about 55 stays at this one.
Okay. Any questions for Mr. Osborne? Okay, thank you. Please identify yourself for the record and address.
Andrew Steffens, 929 Gale Lane, the subject property.
Okay, why are we here and why didn't you have a permit?
We're here because same reasons everybody else didn't know that I was required to have a permit. It's a owner-occupied short-term rental. I've been using the back house as a short-term rental since June of 2016. My wife and I count on that additional income to help pay our bills. Apologetically, I was not aware that we were required to have that kind of permit. I opened the letter on March 14th, went down and met with Dave Frabot on March 16th. Immediately went back to my office and took the listing down and canceled 19 upcoming reservations. Since then, I've confirmed with my neighbors to make sure that no one has an issue with short-term rentals, and I've received letters of confirmation from the adjacent property owners. Additionally, the neighbor across the street from that back house rental, Joe Van, who's right behind me, is here kindly to support. I have no excuse other than ignorance and not understanding the requirements. Humbly, my ask would be that I'm able to start the permitting process after the 2 months time served from the time that I went to down to codes and met with Dave. That's all.
Okay. Any questions for the applicant? Anything else to add?
No, sir.
Okay. We're going to close the public hearing. Discussion.
I mean, it's very similar to what we've heard many times before. I still am going to go with my motion in this case. He did not rent it after he got the notification. He canceled all that he had. I think I would make a motion, if anybody wants to entertain it, that the zoning administrator did not err, but he should be allowed to apply 4 months after his application, which was March 16th.
Motion's been made. Is there a second?
I'll second.
Motion's been made, properly seconded. Any more discussion? Seeing none, all those in favor of the motion signify by saying aye. Aye. Opposed? Passes unanimously. He'll be eligible 4 months after what date?
3/16.
3/16. Okay, to apply. Okay, John Michael.
Mr. Chairman, the next case is 2018-169. Fran Patton is the appellant and owner of the property located at 1300 Gartland Avenue. The challenge is an item A appeal involving a short-term rental permit. The aerial photograph here shows the subject property and the face of the property, also from the photography of the Monroe Assessor's website. Is there anyone here in opposition to case number 169? Seeing none, the appellant will have the opportunity to make the 5-minute presentation of the board after staff's presentation. Mr. Osborne.
All right, so we got word of this one through host compliance. We sent a notice on December 1st, 2017. It looks like they did start the permit process back in January of 2016, but never completed it
When you say that, how do you know that?
because there's record of it in City Works.
Okay. And so they just started, didn't complete it, and then how many times has this been rented?
About 100 times.
100 times, okay. And after they got the letter, what happened?
It looks like it was sent, like I said, December 1st, and it looks like it came down around December 16th. And then the home away looked like it was taken down and put back up and taken down again.
But rented ever?
Not after the notice, from what I'm seeing.
Okay. Any questions for Mr. Osborne? Thank you. Please identify yourself for the record and your address.
Fran Patton, and I live at the property at 1300 Garland Avenue.
Okay, so what happened here? It looks, according to our records, you applied January 2016. Is that true?
Yes, and during that time, excuse me.
Well, you didn't apply, you started to apply.
Yeah, I have some breathing problems, but I went in 5 different times, and every time I went in, the rules had changed, and it's my fault. I'm here.
What do you mean the rules have? I mean,
Well,
so
at
even
the
if we,
time, they would say, this is what you need, and then at that time, there would be a lot of changes of what you could do and couldn't do.
I know, but everything is online on the web for you to see.
I was going in, and they were telling me in person, this is what you need, so come back. So that's what I was doing. It doesn't matter, it was my fault. I'm here because of my own actions. But I just neglected to go back the final time and get the
Okay,
permit.
so that being said, why did you continue to rent knowing we had this permitting process?
I'm stupid. It was a decision I really regret. And when I was notified December 1st, I took it down and I canceled everything. That's been, 5 or 6 months. I really, really deeply regretted it, but I really need the money, and I thought I would go back and reapply. I did pay my taxes, all of my taxes.
Okay.
So that was paid prior to me applying again. And I'm just hoping that you'll give me some leniency. It's not a case that I didn't know. I just gave up on the application process. And like I said, I do regret that.
Okay. Questions for the applicant? Anything else to add?
No, I needed the money, and I overlooked
The
going back.
duly passed laws of the Metro Council.
You didn't overlook it. You just didn't do it, and you rented
I
it
didn't go
100
back.
times.
And then I stopped doing Airbnb.
After the letter,
The
yep.
VRBO, by the way, I didn't realize was even up there. I hadn't used it in so long, so I didn't cancel that until after, I think 2 weeks after. But as soon as I got the notice, I canceled everything and haven't had anything since December 1st.
Okay. Anything else? We're going to close the public hearing. Discussion.
No, except my apologies, and I appreciate that you're hearing my case.
Okay. Discussion. Well, I mean, this is just a perfect example of why host compliance and also regulation of the laws that the council passed. You could pass laws all day long. This is a big county, over 525 square miles, and it's just really hard to keep track of who's doing what unless the public tells us, or now we use technology to find out.
We paid money for that technology, and staff is having to spend time with that technology. And, it's not that hard to get a permit.
John Michael earlier said today that over 3,700 people have figured out and applied for permits successfully here in Nashville.
Well, one of the challenges we have, and we certainly all have, close but differing opinions on what these things are. But, if you look at the previous case that, who didn't know, the next day went down, within a week paid all their, his taxes, and, still, got 4 months from the board, that I think a case where someone attempted 5 times and never corrected it. And, I appreciate, once the letter comes that you go into compliance, but it's just.
I'd be inclined to go with 8 months at a minimum. I can make that a motion if y'all are ready.
Okay, anyone want a motion?
I move that the administrator did not err and that the applicant, because of blatant, ignoring the law, even though she was aware of it, that she not be allowed to apply for a permit again for a period of 8 months from the date that she applied. And, well, she applied in January 2016, but she got this notice in December of 17. So
Application date, I think, is
2016.
yeah, that was the first date.
2016.
So at least in 8 months from today is what I would be inclined to say.
8 months from today?
Or the application date, 3/16.
Application date. Application date.
Oh, yeah, from January 20, but
Okay.
2016 would be.
No, this application is March 16.
Oh, March 16, yeah, from March 16, that's fine, to 18.
Okay, motion's been made. Is there a second? Motion's been made, properly seconded. Any discussion? Seeing none, all those in favor of the motion signify by saying aye. Aye. Opposed? So they're eligible to apply 8 months from which date?
March 16.
March
From
16.
March 16th. Okay, thanks. John Michael.
Case number 2018-170 involves Jerry Pentecost, the appellant and owner of the property located at 918A Allen Road, shown here on the zoning map, shown here on the aerial, shown here on the face of the property from the assessor's website. Is there anyone here in opposition to case number 170, a short-term rental case? Seeing none, the appellant will have 5 minutes to make the desired presentation after the staff presentation begins. Mr. Osborne.
So this one was brought to our attention again by Host Compliance. We sent a notice on February 10th, 2018, and it looks like that was removed early March. No other complaints. There was about 77 stays or so.
Okay, any questions for Mr. Osborne?
No stays after the
Not that
notice
I'm
was
aware of.
received. But you would be, Host Compliance didn't pick them up.
Well, just because the advertisement's down doesn't mean that people don't stop going.
But you didn't.
The advertisement's been removed, so I have reason to believe he's in compliance.
Okay.
But you don't. But you've seen, and others you've seen reviews or things.
Yes.
So none of those signs. Okay.
Okay, please identify yourself for the record and address and why you're here.
Jerry Pentecost, and I live at 918A Allen Road, Nashville, Tennessee, 37214.
So why were you operating a short-term rental without a permit?
I can see by the look on all of your faces that I know you get tired of hearing it, but I honestly didn't know. When I first bought my house, a friend of mine told me about Airbnb, and she said that you didn't need a permit as long as you lived there. So I don't know if that was an actual thing at some point, but that's just kind of what I went by. And honestly, like I'm kind of old school, so I just assumed that somebody would let me know if I was doing something wrong, you know.
Well,
you have all my
eventually you
information.
got that letter,
so,
didn't you?
And they did.
yeah, so, you know, so like that's what I got the letter. I called, I don't know who exactly, I think it's like a Kenneth on the thing, but I travel for a living. I'm a musician like most people in Nashville. So the letter came on February the 10th. I didn't get in town until March the 4th. And I called March the 5th, which would be that Monday, and instantly took it down. Instantly canceled all the reservations and figured out what I needed to do. I just called Airbnb and I told them take me off and cancel everything, and so that's what they did. So.
Okay.
And for the record, like I've hired an accountant, and we're working to pay
A
the
Nashville
taxes.
accountant, I'm sure.
Yes.
Not
Hey,
a Kentucky accountant.
I was born in Baptist Hospital, which is now St. Thomas Midtown. So I have a lot of pride in the city, and like I'm just asking for some leniency because I'm a musician and this is what I do. I'm a 33-year-old drummer. Nobody wants to live with me. Nobody wants to hear all that. I'm just trying my best to, do everything I can. So, but because it's tax season, he's a little bit behind, but like we're working to get that taken care of. So.
Okay. Questions for the applicant? Anything else to add?
I was on the fence about this, but I'll do it because I'm here and I paid the money. This is 2018. Nashville Scene People issue. If you turn to page 18, you'll find me on there.
Well, publicity.
I mean, not bragging on me at all. I'm just saying I love the city, and I follow all the rules and regulations. So
very good.
But that came out in March.
Good luck with your career. Okay, we're going to close the public hearing. So.
Well, that raises the bar.
Yeah. I didn't mean that at all.
Okay.
Well, I mean, again, the person that when they found out, tried to do everything right. I'll make a motion. It may not be enough for some, but it may reflect that little kind of back and forth of where we are. But I will make a motion that the applicant, that the zoning administrator did not err, and based on the circumstances of this case, the applicant is eligible 3 months from the application date, which is 3/16/18.
Motion's been made, properly seconded. Any discussion? Seeing none, all those in favor of the motion signify by saying aye. Aye. Opposed? So he will be eligible to apply 3 months from
March 16th.
March
So
16th.
June 16th,
Thank you very
you're
much for your
eligible to
time.
apply.
Yep. Okay. Good luck. John Michael.
Mr. Chairman, I have exciting news for our board. You're about to hear a zoning case.
Oh, what? Huh?
Case number 2018-174, I believe is the next case to be presented to the board.
Wow.
Jump into 70?
This involves the zoning code. The appellant is Development Management Group, the appellant on behalf of Broadband Nashville 1 LLC, owner of their property located at 592 Hicks Road. The request is for a variance from sidewalk and front setback requirements in the RS10 district in order to install new and communications equipment at the subject location. For the unfamiliar, this is out in Bellevue, just I guess east or inbound from the One Nashville Place property and development. The property shown here on the aerial map's a bit fuzzy, but does give you an idea of the relative proximity to residential uses all around, but the non-residential use of this specific property. The site plan submitted gives an indication of the layout of the proposed expansion of the telecommunications equipment at that location. From my recent site visit, the property shown in the lower right-hand corner gives you an indication of the condition of the property presently, the thin nature of the lot as previously shown from the zoning map. And I believe I saw the estimate of a little over 470 feet of linear frontage on this subject property. The view up and down this portion of Hicks Road shows the absence of a sidewalk on either side of the street at this location. Now, with well wishes for the appellant who is here hobbling up to the stage, I will remind the board we take violations of the zoning code very seriously, as you can see from the appellant. So give him a break at this point. With that said, I take it there is no opposition present for case number 174. Seeing none, the appellants will have 5 minutes to make the desired presentation with regard to the variance request from sidewalk and setback requirements.
Okay, please identify yourself for the record and state your name and address.
David Abbey with Development Management Group, 4209 Gallatin Pike here in Nashville.
Okay, so why are we here? We have Planning Commission recommendations that basically they recommended approval if you paid into the in lieu fund. What's wrong with that?
Well, at the time, I couldn't make that decision, and I told Mr. Michael I would get with the contractor on the project so he could get with Broadband and verify that, and we didn't get an answer prior to today's meeting. And so what we found out, actually, since we have been here, we did try and reach back out to them, and the paying the in lieu fee is basically 1/4 to 1/3 of the total cost of the work that they're going to be doing when all they're doing is upgrading mechanical and electrical equipment.
And so who is they?
That would be Comcast, who is the owner of that property.
And so this is not a cost of doing business for Comcast, that we have laws, a sidewalk law?
The reasoning, or part of the reasoning that we got from them, is not necessarily just cost as well, but we also know that there are issues out there that are illegal issues that have taken place in the vicinity, and their concern is also by having the sidewalk out there, which would be the only piece of sidewalk, could potentially warrant some other people standing over there and doing things that they shouldn't do.
You explain to them what the in lieu fund is. It's like you don't have to build a sidewalk and you pay into the fund instead. So there would be
Yes,
no
we
people-
understand that, and the cost is very large for the fee in lieu versus potentially what it would be to build it in the first place.
Well, that would be your client's
I know.
choice. So, but if they were concerned about people walking and illegal activities, they have the in lieu fund option.
And that has been presented to them.
Okay.
Mr. Chairman.
There's a sidewalk already there.
Is there a sidewalk already there?
There's not a sidewalk out there.
Doesn't,
There's not one in either side of the road right there.
yeah, on South Street.
Okay. So, what is your argument for Comcast not to pay into the in lieu fund?
Basically because they do not want to have a sidewalk in there that may invite other issues.
I know. I mean, I get that part, but then if they don't want to build a sidewalk, here's the in lieu fund.
It's basically because that cost is probably 4 times the amount of what it should be.
Is Comcast, or is the property owner willing to give the right-of-way for a future sidewalk if we waive the in lieu fee?
Yes, I do believe that's potentially the case. However, the other thing is due to the change in over the past few years with the classification of the roadway, that's what's caused also the 40-foot setback, which actually now encroaches into the existing building that's there. So if you obviously take additional right-of-way, then that setback moves back even further. And I don't know if that's going to create another issue potentially as well.
Okay, so you're asking for 2 things. You're asking from not having to build a sidewalk or pay into the in lieu fund, and also a front setback from this. It's not a house, it's just like a little technology structure for.
Yes, it's an unmanned electrical building for their equipment. That's correct.
Any questions for the applicant?
I guess I want to know what is the required setback and what is a request for the setback?
Currently, the required setback is 40 feet, and the closest piece of equipment would be at about 16 and a half feet. And that is what we're also doing as a part of this is with the install of all the equipment, we're actually putting a wood fence to secure everything around it as well. We're adding, at the request of the council member, we've also talked about adding some shrubs and some plant materials around there to, again, make it more aesthetically pleasing because it does encroach in there. And we had a very good meeting with her not long ago to kind of discuss the project, and she was very pleased at the direction we were headed.
So what's the fallback if you don't get the setback? What's plan B?
Then they won't potentially be able to upgrade the facilities for all the service in the area. Because there's really nowhere else on site that allows them to complete that work. Because the setback eats into the property so far that the corner where the building is basically the only place on site where any work can take place.
So that's your hardship?
Correct.
Any other questions for the applicant? Anything else to add?
I don't believe so, sir.
Okay, we're going to close the public hearing. Discussion. So this is one of the cases where the recently passed sidewalk ordinance triggers, and we had a case, about a month or so ago about gas company building a non-residential structure that also triggered the ordinance. So, discussion.
You know, these are the cases where, I mean, to me, the lot is such an unusual shape. The actual use of the property is maybe 50 feet, and yet it's a 470-foot piece of property. And to me, the narrowness of that and the topography of the road suggests that a variance is needed, and I would lean toward not paying. Because now, I'm sorry, I have to look and see what planning said.
Planning said pay into the in lieu fund.
But not bill.
Yep, not build, pay into.
And that's where I guess-
And we asked the applicant, who
That's
didn't
where
want to
we
build the
did.
sidewalk, that,
I would say pay in lieu.
yeah,
Yeah, it just,
Person hasn't come saying they shouldn't pay.
right. I just think that the nature of the lot is one that would say not pay because the frontage is extremely unique. I mean, you look at the map and no other piece of property there has that type of frontage or that type of shape.
The gas company property was long and narrow too, and their bill was, I think, about $400,000 into the in lieu fund.
I wasn't on that case. I would not have.
But to me, the sidewalk ordinance was duly passed. They knew things like this would trigger it, and there are no exceptions for this part. They could come to us and ask not to pay into the in lieu fund, but this would have been on consent if they had agreed to and paid to the in lieu fund. But as the applicant described, he couldn't get the folks from Comcast to agree to that. So.
Yeah, I don't want to drag this out any longer than we have to, but I am curious. I mean, to me, on deciding whether or not someone can build the sidewalk and the setback, it's a variance, and therefore there's a hardship that we have to decide. And I think I'm a little unclear on what our standard is for determining whether it's okay to get out of the in lieu here. I mean, how do we analyze that?
Well, we have a planning commission recommendation, which we give weight to.
Sure.
We look at the elected officials who was silent on this, and then we just kind of look at what other people have done in the area or the needs for sidewalks in general. I think we're pretty strict about.
I think what I'm getting to is it's like I'm trying to decide what a good argument for not paying into the in lieu fee is. I mean, it's because we've already gotten over one hurdle by the time we get to the in lieu fee.
Right, and everyone's different. I mean, the gas company agreed on the front end to pay into the in lieu fund. This client does not. But their bill was about 4 times what they would have to pay into the in lieu.
If you have a thought on that, I mean, like, what should we be considering?
I
other than
think
what David said. I mean, I agree. I agree. I just can't. I'm trying to think of a mitigating circumstances where we would say, the in lieu fee really isn't appropriate for this project.
We had one about 2 meetings ago, and there was some evidence from, I believe it was the council member, that, do you remember the property was way up, not close to, it was like a mud pile instead of a grass lot that was close to it, and there were new sidewalks going to be built very near there. There were, literally were extenuating circumstances.
I guess my thing I'm trying to think through is, and I just had asked, and I think that, the gas company agreed to pay it. They didn't ask us to consider not paying. They just agreed to do what the Planning Commission recommended. But I really do have a lot of concern about residential homeowners who are in similar situations to this coming before us. I know we look at everything uniquely and separately, but there are plenty of lots that are 200 and 300 feet wide because they're on a corner, or they just have a 150-foot lot because they're in Bellevue or Hillwood or some of these places that have really long lots. And, you end up with and strangely shaped, and you end up with a fee that's many, many times their annual property tax assessment. And so that seems to go against the intent. So to me, I really worry about setting
But if
that
it goes
precedent.
against the intent, the council can fix this. They know that these cases exist. If they didn't want these entities to be eligible to have to pay into the in lieu fund or pay for sidewalks, but they have taken the opposite, that basically everything triggers the sidewalk ordinance in this kind of case.
May I make an additional comment if you don't mind?
No, our public hearing is closed.
Okay.
So,
I'm inclined to not let them out of the in lieu fee, and then if they decide that suddenly building the sidewalk's not such a bad idea, that's up to them.
Yep. Do you want to make a motion?
We'll second it if you do.
So, but should I do this in one motion or?
You could do 2 separate motions if you want on the setback.
On case 174, 2018, 174, regarding the sidewalk that we do grant a variance allowing the applicant not to build the sidewalk with the condition that they pay into the in lieu fee.
Okay. Motion's been made. Is there a second? Motion's been made and properly seconded. Any discussion? Seeing none, all those in favor of the motion signify by saying aye. Aye. Opposed? 4-1, it passes. Next motion.
So the next motion on the setback, I'll move that we grant the setback variance citing the topography as the hardship.
Okay. Motion's been made, properly seconded. Any discussion? Seeing none, all those in favor of the motion signify by saying aye. Aye. Passes unanimously. John Michael, next case.
Mr. Chairman, the next case is 2018-176. This involves the property at 1943 Dabbs Avenue. Paula Hepp is the appellant on behalf of St. Mary Coptic Orthodox Church in Nashville. This is in Council District number 13, not too far from the airport, as shown on the zoning aerial map here and the actual aerial map here of the existing church lot. The site plan submitted shows the proposal for construction of an addition to the church property. From my recent site visit, the condition of the property, and I've just kind of shot these photos all around the property, the entrance in the upper left-hand corner from Dabbs, when you first come onto the property in the lower left-hand corner, and a closer picture of the existing sanctuary chapel or church building there toward the rear of the property, closer to the west. Small facility there in the tree line just beyond the main chapel, and an addition that was made in the lower left-hand corner in recent years. The exit further up on Dabbs in the lower right-hand corner. And then these shots also from the interior of the property back into the main parking area in the upper left, and a little bit closer of the main church building there in the lower right. The address will be familiar to the board, as the St. Mary Coptic Orthodox Church at this location has had other cases at the board in the past. Obviously, any construction on the subject property in an R zone, R or RS zone, in this case RS10. Sorry, that's not right. Yeah, it is. RS10, cool. In residential property requires a special exception from the Board of Zoning Appeals. That's not something that can be handled administratively and must come to the board. Thus, churches in those residential zoning areas frequently come to the board for any construction projects of this nature. Ms. Hepp will have the opportunity to make the presentation on behalf of the appellant shortly. Is there anyone here today in opposition to case number 176? There is. And I know that the file is complete with other letters and input from other interested citizens as well. Because this is an opposed case, both sides will have 10 minutes to make the desired presentation. For the appellants, we'll remind you that any time you wish to save back for rebuttal should be kept out of this original 10 minutes. With that, I'll have the appellants introduce themselves by name and address.
And the same property was before us a year or two ago?
Forgive me for not remembering the last date. I do think it was about a year and a half ago. It's actually been before the board 3 or 4 times in this decade with regard to various projects that they've taken on, some of which they've been able to pursue and complete, others that they were not able to.
And it was a Korean church preceding this.
Okay, please identify yourself for the record and address and why we're here.
Good afternoon. I'm Paula Hepp with OHM Advisors representing St. Mary Coptic Orthodox Church. My address is 209 10th Avenue South in
Okay,
Nashville.
so before we get started, the council person from your district is?
I don't think I'm going to say it correctly.
Holly
Juarez.
Huso.
Juarez.
Okay, Holly, yes. Did you have your public meeting?
Yes, we had a neighborhood meeting on April 25th.
And you sent out notices and all that? Okay, so what was the outcome of that?
The outcome of the meeting, we had one couple show up in support of the addition or the multi-use building that we want to reestablish on this property. And we did not have anyone else come out against the project or even to come and discuss their views.
Okay, so John Michael alluded to in the past that you've been in front of this board and asked for things. So what happened to the last proposal that you were trying to get?
I was not part of any of those original or those past presentations, but St. Mary's has contracted with OHM to work on this addition for them. Prior 2013, there was a fire in the multi-use building and it burned completely down. They came back to rebuild that multi-use building, and they doubled the square footage size of it, came through, got special exception uses, and were almost to the point of getting building permits, and was determined that the building was too costly for them. They could not finance it and get the building constructed, so they had to come back to reality, so to speak. And they are basically coming back with a similar size building to the one that was there prior to the fire. And it will be a multi-use Sunday school classrooms, fellowship hall, gymnasium for them.
Okay. Questions, anything? So why is this going to happen this time and the other times it didn't?
They've had more time to collect the funds that they need and to raise funds in order to do what they need to do here. There are several things on this list. The special exceptions and then the sidewalk variances and fee in lieu of are all within the packet for discussion tonight, and I'm happy to answer any of the questions that you guys might have on it. But they are basically the building itself, the setback from the road. They're trying to establish the same setback line that the current church sanctuary has to maintain that same edge along the street. They are requesting the building height variance similar to what was prior requested for to be able to establish the multi-use. The gymnasium area needs to be a higher height to accomplish the gymnasium. The use is obviously a church in a residential district. The sidewalk requirement, unfortunately, from the time that the building burned to the ground to now being able to establish that building back again, the sidewalk ordinance came into play. The frontage along Dabbs Avenue has some slope issues. If the sidewalk was to be constructed, there would be some issues with retaining walls and of that nature.
So
to compound, I'm sorry.
This remodeling would have triggered the sidewalk ordinance anyway outside of the fire. You're saying no. Please identify yourself for the record.
I'm sorry. I'm Doug Wilkening, the architect with OHM Advisors.
And your address?
3703 Brush Hill Road.
So this renovation aren't you building more outside of just what burned down?
No, the project that we're talking about here today is very similar to the structure that burned down. It's
very similar. So tell me how it's not similar. Is it the exact same footprint?
Not the exact same. It's a couple thousand square feet larger than the original.
That's a little different.
A little different, yes, sir.
So if you had expanded a couple thousand feet, John Michael, this was a couple thousand feet renovation, would that have triggered the sidewalk bill under this?
It'd take a little more careful analysis than that to get to the answer, and I don't want to speculate given the sensitivity of the topic.
Okay.
Sir, if I may, the part of the reason that the footprint is expanding slightly is code requirements from the church, the building that was there previous to now requires different bathroom configuration and family restroom, different code compliances like that have kind of pushed it a little bit larger than the original.
I'm actually, I don't want to testify. I'm actually familiar with the previous church, and it was tiny.
Okay.
Very tiny church.
So, any other parts about this that's essential to what you are trying to do here? I mean, obviously, you're trying to rebuild back.
Right. We're trying to rebuild back to basically what was there, so that they have a fully functioning church, not just a sanctuary. They have the classrooms and they have the fellowship activities. The opportunity to push the building a little bit forward will help us be able to get the parking behind the building and off the street. We had deficient parking prior. The code requires 105 spaces and 90 were existing when the original building burned down, and now we'll be adding back, and I think right now we have 114 spaces on the site plan as it is right now preliminarily. So doing all that, we hope to make it better out there for this residential area. Also, we talked about fee in lieu of. In part of the packet, I included an exhibit, Exhibit 9, that shows the pedestrian benefit zone for Area 5C and where our site is located. The subdivision that St. Mary's Church sits in is a well-established community of open ditch and swale subdivision with no sidewalks anywhere in that enclave community. Putting the sidewalk there and having to do the curb and gutter would be out of place in that area from what is established. The gain into the fee in lieu of fund would not benefit this area. When you look at the benefit zone of 5C, the funds would typically go to benefit the area close proximity to this site, and it being a well-established community without sidewalks and no sidewalks present within 3,000 feet, and the large, vast area of 5C, it's unlikely that any monies paid in would directly benefit this community at all.
Okay, questions for the applicant? Do you have anything else to add?
Not at this time.
We're going to hear from the opposition, so please go back, and opposition, please come forward and state your name, address, and why you're opposed to this.
Good afternoon. My name is Helen Schultz, and I live at 1909 Dabbs Court and have for almost 48 years. I'm here because the church has the same problem now that they've had for the past 6 years. They're too large for their property. When all this began, I seem to recall they stated they had 130 plus or minus parking spaces. And now I read in this request that, quote, current parking is at 90 spaces available and proposed parking will bring the total to 135 plus or minus. This is not consistent with what they have said at every meeting that I have been to in the past. Regardless, how can the 135 plus or minus spaces adequately account for the sanctuary seating of 316? That's a quote. Where are they going to park? On September the 10th, 2013, an appeal was submitted for approval to replace their burned portion and a gym. Their request was approved subject to 2 conditions. Entrance on Dabbs Court, which was illegal, will be permanently closed with an opaque fence at least 8 feet in height prior to issuance of a UNO. 2, remove the ramp cut and replace with the landscaping strip. If I understand correctly, opaque means solid. You cannot see through it. What they installed was a cheap, flimsy metal fence with a gate. After the next appeal occurred, the church was instructed to weld the gate shut. However, the fence is so cheap that the children could and did tear off the metal bars. The fence is still used for pedestrian access to the church. Cars will pull into our very short cul-de-sac. The passenger will exit. They will go through that iron gate, through the spaces that have been torn away, and enter in onto the church property. I also understand at this meeting that the church was to install shrubbery around that permanent opaque fence. This has been very frustrating to those of us who live there. There are only two that own property on that street now, and that's Mr. Salmaron and I. Mr. Helton died last year. Anyhow, shortly after that metal fence was installed, we received another appeal letter for June the 19th, 2014. I've got the case numbers if you want them, which was a request to add an additional parking lot. Unfortunately, this too was approved with the following conditions. Move the trash enclosure to the southeast area of the parking lot to the east of the building. As long as they've had a dumpster on this property, it's been two different sizes, but it's been in the very same place, sitting in front of Mr. Salmaron's home. It should be moved. It's still there. Mr. Salmaron endures the stench, the rodents, the overflow, the loose paper, etc., blowing onto his property. They're now using the green recycling receptacles from their rental properties for the overflow from the smaller dumpster. And the parking lot, I haven't seen a parking lot. What I have seen is a parking lot that is just not large enough. They continue to park up and down Dabbs Avenue, and they tried to come into our short street, Dabbs Court, and park there. I worked really hard to get 5 signs put up. They just ignore those signs, and they still come in there and try to park. The same day of that case, the request for a special exception and variance is to allow the church for a daycare center for 75 children. It was granted. There were 4 exceptions, one being the playground to be fenced and attached to the structure. That hasn't happened as far as I know, and there's no fence attached to anything. I will say that there are children that play at the end of our cul-de-sac in the street and with little or no supervision. Unfortunately, my concern here is that the children are going to be hurt because there are people that come in to this very short street at full blast as fast as their car can go, and they leave the same way. As I said, Mr. Helton is now deceased, and Mr. Salmaron and I did not stay for this case. Mr. Salmaron had to leave for work. I was undergoing chemo during this time and had become ill. Before we left, we spoke with Mr. George Hanna, who was very apologetic and contrite, and he assured us that our concerns would be handled. We discussed the excessive noise, the continued speeding, the garbage, and the fence issues. We should not have left. We should have stayed because his assurances did not hold water. Then on September the 1st, 2016, another request was submitted to construct a detached modular building on the property. I had been in touch with my councilwoman. She sent a letter to this board saying that she did not approve of this. She had gone out and visited. She had seen the way the traffic was on the weekend, on Sundays. But this appeal case was granted. It was 6 p.m. before this appeal was heard. I was tired and cold and did a very poor job of expressing my views. I've made some of the above statements to point out that the church seems not to have complied with most of the condition of each of their appeals. I am voicing my opposition because of the parking and driving situation that is in our neighborhood. Also, I would like to express my concern about this newly erected modular building that they put up at the end of the cul-de-sac. I read over and over on the land use policy, and from what I understand, it does not meet the guidelines set forth by the Suburban Neighborhood and Maintenance Policy. Again, for the 4th time, they do not have enough parking for their church membership. Every Sunday and a few times a year, they search for parking spaces, and every Sunday, Dabbs Avenue is lined on both sides, sometimes with double parking. They continue to try to park on Dabbs Court using the openings in the cheap metal fence and a new opening in a chain link fence near their metal building that they have put up. I called the police. When the police arrived, the parishioners say they didn't know they couldn't park there. Ladies, gentlemen, there are 5 huge signs. There are only 2 of us left on Dabbs Court that own property there. There are 7 buildings, 7 houses on that very short street. There is no need for 68 vehicles to come and go in and out of this very short street almost every single day. Again, 7 houses on Dabbs Court. I don't know what the solution to this problem is, but they do not have enough parking. I really wish that you all would consider our request. If something can be done, I have absolutely no problem with what they want to do. But they just don't seem to want to do what they should do for the people that live in that neighborhood. Not just us, the owners of the property, but the tenants that live there too. I spoke with some of them. Some of them were very reluctant to come down here because they are just renters. Did I go over? I hope not.
No. Okay, questions for the applicant? I mean, the opposition, sorry. Anything else to add, sir, that you've wanted to say?
We're very, very, very frustrated. I have pictures of everything that I've talked about.
That would be great if you would.
Technologically stupid. I don't have them because I don't know how to get them. I wished I knew. I was able to print one off, just one, showing the parking on Dabbs Court. I'm just not very good when it comes to computers and things like that. But I have pictures of everything. I have pictures of the garbage cans that they have. They took the containers that are used for recycling from their tenants' houses. The church owns 5 of the houses on Dabbs Court. And they put them in the parking lot with that other garbage container they have to try to catch the overflow. But that container should not be sitting in front of his house. I don't know where it should sit, but there's a lot of places down behind that church that are not near property where it could sit. But they have it sitting up there in front of Mr. Salmeron's home.
Who's your contact person at the church?
I'm sorry?
Have you had a discussion with the church?
Yes. I had a lady that I had been talking with at that church, yes.
And who is that?
Give me a minute. I have chemo brain.
I mean, is it the pastor or it's just a...
Miss Nardine.
Yes, Nardine Shalby, NardeenShalby. Thanks, honey.
And so you've voiced these complaints to her directly?
Yes. She came onto my property one time last year. I've got water in I can't hear very well. I've got water in my ears. And told me to stop calling codes and stop calling police, that it was none of my business. She came and told us last Sunday a car parked at the end of the cul-de-sac, exited, went into the church property. This was on Sunday. And she came out there and she told her that was not her business, that car parked there was not her business. Well, it was their parishioners that had parked there. So she's been fairly rude. I have tried to be nice, but I'm so frustrated at this point that my niceness is wearing very thin.
Thank you.
Okay. Any other questions for the opposition? Okay. Thank you.
Thank you for allowing us to speak.
Yes, and let's hear from the applicant again. This is rebuttal time, so please respond to what you just heard.
Thank you. I thank the residents for coming out and indicating the issues they've been having. We obviously didn't have them at the neighborhood meeting, so we didn't know that any of these things were pressing on their mind. We have come into this as a new consultant for the church, so this is
I understand
new information
that,
for
but
us
can you
too.
address their parking concerns?
Right. We know that parking has been an issue. We know that the parking spaces were deficient. The 316 sanctuary spaces, or seats, indicate through zoning that 105 spaces are required. We know that parking is deficient right now as it sits, and when we are able to reconfigure this property and put the building on it, we hope to have at least 115 spaces. The sanctuary seating is the seating that goes with the zoning, and we've been told by the church that if they're not in a sanctuary, they would be in the fellowship hall and the Sunday school classrooms, that they would not be used at the same time, one versus the other. The entrance on Dabbs Court, I do know has a fence and has a fence up. I didn't realize that the requirement was for an opaque fence, and we can certainly work that into our schematics. The landscaping strip and shrubbery, obviously, we can work that into our schematics. We are working right now on the trash enclosure to find a good spot for it closer to the building of the church, because it's not good to have to walk a far distance to get rid of the trash in the church anyway. So we're working at a good replacement for the trash enclosure. I've been out to St. Mary's Church several times, not during services, but just during the weekday for meetings. And there are always several cars parked along Dabbs Avenue in the street and the court, Dabbs Court, that don't belong to any of the church members and don't belong to any, So there are residents that also park along the street.
Have you ever been to the church during a service?
I have not.
You have not? Really? I would suggest that that would be a good thing if you were trying to consult with them, and parking and kind of flow is a problem.
Absolutely.
Because going to a church on a day there's not a service there, it's like going to a college during spring break or summer. It's a totally different deal.
I understand, sir. I was just making the point that there are residents along the avenue that do use the street to park also.
But I don't understand her concerns were when the members of this congregation are there and parking at other places too. And you could see what it looks like. So continue.
That's all I have at this point. I do know that Ms. Schultz has been in contact and has submitted letters thanking Nardine for her help in the various issues that have arisen in the past, and that the church has been actively working with her. Hopefully, this final solution with the multi-use building can clean all of that up and make it all right.
Questions for the applicant? Anything else to add? Okay, we're going to close the public hearing. Discussion. It's a special exception.
It's not the first time we've had, this property involved in our cases, and some of the concerns continue to be the same. It does sound like that there are elements of this plan that are addressing some of those concerns, but it is troubling, to hear, and I can't remember exactly what the church agreed to last time with regard to the cul-de-sac, but I do remember us talking about the need to create some distinction between the two.
I would think that part of the conditions that were part of some of the previous approvals haven't been implemented yet because the project hasn't been implemented.
Yeah.
I mean, they were asking permission to build this building, and with that, you had to do these things also, and they haven't built that building. I'm not saying that's the case for all of it, but I know, and I remember when she was reading off the long list of things, that I know that's an issue. So, I mean, I forgot how many things are on this, but the conditional use, I feel like we have a choice, but I don't feel like we have a compelling reason not to grant that
Okay, so what about the sidewalk requirement?
We've had other cases where we did not require the sidewalk, find that it was triggered where there was a destruction by fire. I remember one case specifically that we did that.
Well, and we've had other churches that had, and nonprofits that had topography reasons that we granted the variance without paying. I mean, it's worthy of the
Okay,
variance.
sure.
The nonprofit.
So that being
and the
said,
topography.
does anyone have a motion?
Were those the three issues?
The height.
Height,
Oh, the height.
because of the gym being higher this time.
Use height and setback.
Oh, there's a setback also.
But the reason for the setback is so they can move parking to the rear.
Right. I was just trying to make a list. I mean, I guess all that could be rolled into a motion that someone else could make. See what I did there? So I guess the question is, are there any conditions we want to put on, if
I think we put every condition that we've ever put on this order. I mean, I feel that way. I think those can.
I get that notion. I'm not opposed to it. I'm not sure that all of the conditions, I don't know if we can say a blanket thing like that, because I don't know that all the conditions technically still apply or are appropriate. But I like where you're going with that. So man, it's been a long day.
But we can go through.
All right, yeah, why don't I make a motion that we grant the conditional use? I don't think we have any reason not to do that. I think that stands alone no matter what they want to do. There's no compelling reason not to. So I'll move that we grant the conditional use permit for case 2018176.
Okay, motion's been made. Is there a second?
Second.
Motion's been made, properly seconded. Any discussion? Seeing none, all those in favor of the motion signify by saying aye. Aye. Opposed? Passes unanimously. Next section.
Is it
one piece of clarity? It's a special exception permit rather than a conditional use permit. So I just wanted to make sure that's in the record. That's okay. That's fine.
Correct your motion to include a special exception. No, just correct it.
I should have said special exemption.
Okay, and is that acceptable to you, Mr. Taylor?
It has been a long day.
Okay, yep.
Do conditions need to be placed with that motion?
No, I would prefer not to. I would prefer to place it on the construction.
If we were going to put conditions that needed to go on that motion or not.
Okay.
Well, I don't know what he's getting ready to say next.
Okay. Well, before that, all those in favor of the fixed motion signify by saying aye. Aye. Opposed? Okay, now talk about the rest.
I feel like any conditions we're going to put, we should put with the construction project because it's not unusual for churches to do this multiple times to have false starts. So now the question is, what conditions do we want to put? And the opposition had a lovely list. I don't know if I thought I saw the list similar to hers in this package.
Here it is.
Where it starts down at the bottom.
That's page 1 is what on that opposed letter.
Please bear with us.
Yeah, this one.
I can try to wing this, but is it this one?
Well, the other thing too, there are those two cases that we've heard, and I don't know that the child care case is relevant because they're not asking for that.
Right,
but,
exactly.
But that is something that for those.
Well, if they're in violation of those, that's something for.
I say for the. No, I don't think they. Yeah, but right. I don't think they're.
Right, we don't need to include them.
Yeah, if they did that, they have to abide by the conditions, but if they don't, I mean.
Do we want to address the sidewalk as a separate piece as well?
I think the sidewalk is something that you can clear, and I think the variance for the height is, and maybe the setback is.
Well, I think we got to do this. I'm sorry, I'm talking over you. Let's put the conditions with the height and setback.
Yeah.
And let's handle the sidewalk separately.
I think you can take care of the sidewalk, but then the height and the setback, worst case is we go back to that case and see what we passed and pass those two things first thing next week. But that way you have a clear list of what it was that we passed. I don't know that we have.
Now, Michael, are you listening to this?
It's riveting.
So what's the board's thoughts on doing the rest of this next week?
No, Pat, well,
let's do the sidewalk.
Okay, do the
David,
sidewalk.
why don't you do the sidewalk? No, you're doing a good job.
Motion on the sidewalk.
All right, I move that we grant the variance on the sidewalk, and that the appellant does not have to build the sidewalk due to topographic issues, and that the in lieu fee also is not required.
Okay, motion's been made. Is there a second? Motion's been made, properly second. All those in favor signify by saying aye. Aye. Opposed? Passed unanimously. So what are we going to do for the rest?
Do we defer or leave it open?
John Michael, what's the best way?
I was going to say, why don't we do it as a motion, put everything in there we want, grant it subject to if John Michael finds there needs to be another condition that we had previously ordered, that can be added. And then
Okay.
when it's done.
Okay, yep.
There can
Okay.
be a review.
So that's good. Did you hear that, David? Or you could do it.
Just said it.
But do we have a list? Is there a list?
We sort of have a list.
Yeah, the list. Well, which list? I mean, we have to be
Can we
very
take a stab at
specific
this?
about it.
And so we're gonna make the motion, and we're gonna vote on it, and then if there's discrepancy in our list, if we've double dipped or left something out, we're going to reopen it next meeting if we need to.
Yes.
Is that how we're handling
Yes,
it?
exactly.
Yeah, or is it
Yeah, we
easier
could
just to say defer the vote on this till the first time? It's so that somebody can look up the previous case and see what the conditions were. Okay.
So
How about, yes, let's do that.
defer?
Or defer, leave it open, whatever.
Okay, we'll defer the rest to next week. That's the motion. Is there a second?
The defer the vote. So
The
we
vote.
don't have, not
The
hearing,
vote.
so
The
just
vote. The vote. Okay. That's the motion. Is there a second?
Well, I don't want Ms. Schultz to have to come back here next week. I want her to understand that, we heard what she was saying and that we are going to require these to be enforced, so.
Okay.
Just as long as.
Well, and
That's all I'm saying. If we,
well, I would say I'll see if this makes sense. I'll move to defer the vote on the height, the variance in height, so that we may add the conditions that were placed on this property in the previous motion, and out of respect for the comments from the opposition. And that way, you'll know, Ms. Schultz, that's going to be the motion. It will be to give them a height variance with the conditions that were there the last time we did it, so that we're consistent there.
Okay. So we will take that up next. So is that a motion?
Yes.
Okay. Is there a second?
Second.
Okay. All those in favor of the motion signify by saying aye.
Aye.
Opposed? Passes. John Michael, let's take a short break.
May I get one thing on the record? Just, you all are familiar with the conditions that have been imposed by this board previously. You are not?
Not. That was
Okay.
the first we heard of it.
Okay, because my
apologize.
question to you would be, are you agreeable to those conditions? But you may need to return next week to answer that question.
We can return. Okay. So
Take a brief break for the benefit of the board and reconvene with our next case thereafter.
I'm just going to give them a copy of this.
Thank you, Chairman and Board.
Resume their seats. I will point out that case 2018-177 comes from Council District Number 17 and involves the property at 413 Houston Street, just off the 4th Avenue corridor. The appellant is Kristen Newton, and Tusk Brothers, the owners of the property at this street address, have made a request for a variance from sidewalk requirements and from wall or fence height requirements in the CS Commercial Services Zoning District. You have input from the district council member on this topic. You have the full packet, of course, that includes this site plan and many other items as well, demonstrating the proposed layout of the would-be construction relative to Houston Street. The current condition of the property shown here from my recent site visit on a beautiful Nashville day, Chamber of Commerce kind of day, Mr. Chairman. The existing welding shop has been there for what I would roughly estimate to be 1 million years. The view of Houston up and down the street, 4-foot sidewalk clearly in place, has been for a very long time, and you see the small retaining wall that's in place in front of the welding shop as well. Is there anyone here in opposition to case number 177? Seeing none, Mr. Chairman, I'll remind you it's a variance on the sidewalk requirement. This is a no-build request. Planning Commission has made that recommendation with regard to the sidewalk component. Then we'll let the appellants more capably explain their request with regard to the wall/fence height variance as well. Toward that end, we'll invite the appellants to introduce themselves by name and address, and with no opposition, use 5 minutes to make the desired presentation once we get our fourth board member back in.
And then is there still a wall fence height variance too?
Yes. That's the second part.
Okay.
Okay, and John, sorry.
Hey, you're here.
Sorry. Okay. So you could begin, actually.
Okay.
Yes.
Kristen Newton with Manuel Zeitlin Architects, 516 Hagen Street, Suite 100.
Okay.
And I'm representing the Tusk Brothers. They're the owners, Brian and Jamie.
So what are you trying to do here, and why do you not want to follow the sidewalk requirements in the district and the wall and fence height requirements?
Well, due to the hardship of the actual shape and slope of the site, the sidewalk improvements would be wouldn't be feasible just because they would extend into the property setback and into the existing building. So it would actually mean the removal of the building to do the sidewalk improvement.
So what about the wall fence height issue?
So again, with the slope of this site along the sidewalk, the public right-of-way, to access the building is several feet above, the finished floor is several feet above the sidewalk. And so to access the building, we're going to need to build a deck, and that deck would require a 42-inch guardrail. And so what we're asking is to extend that guardrail down below the deck to conceal the underside of the deck so that trash and things like that won't get collected, and that is being considered a fence.
Okay, so planning has made a recommendation to do the 5-foot wide sidewalk, no grass strip. I mean, that's the conditions, but to basically pay into the in lieu fund.
And so what we were also asking is with the in lieu fee is that because the sidewalk improvements aren't possible, even if the client wanted to do it, we're asking if we can waive the in lieu fee because of that.
You understand how our sidewalk bill works. Basically, the council put that in there knowing that there would be people that would not build sidewalks or could not build, but they would pay into the in lieu fund anyway. So what's your response to that?
Well, we're also asking that just the site is very small and irregular shaped, and that's actually the longest side of the site. It's about 78 feet, and it's a 0.09 acre property. So it just seems disproportional to the actual site for the fee that would be required.
Okay.
Is there a sidewalk across the street?
No, no, there is. There is. Oh, there is. I'm sorry. Yes, sorry.
And I guess the question on the fence, it says you want 8 feet. Does that include the railing, or is that just if I'm walking down the street? Because I know it seems like now on that little section, but the fence will come down, but it really goes all the way down the corner, right? The deck goes all the way to the corner, and so you're not asking for a variance or anything, so you're entitled to put a deck there. But then you just want to not look underneath the deck or have people crawling under the deck and all that kind of stuff. How tall will that deck be from the ground?
Well, since the site slopes that would be at the highest point. It'd be about seven and a half, depending.
So there'll be a point where I'm walking down the sidewalk and there's 7 feet next to me of wall fence.
Right. What we're going to do is we're going to actually treat that with planters. So we're going to set the deck face back at least 18 inches along part of it, and then even about 3 or 4 feet in other areas, so that there'd be step planters up to that height.
Okay.
But it would occur in certain areas.
Okay. So not right against the sidewalk. How far? I guess so. 18, at least 80. That the deck will be at least 18 inches off the sidewalk, and in some cases a little bit more. Okay.
Okay. So Councilman Colby Sledge, councilperson from 17th District, has sent us an email, and his position on this request is support. As the corner of the building sits right next to an existing sidewalk, this is an old welding shop being saved and converted into a bar. So he supports your case here. So you're really going to save this old building?
Yes, we are.
How old is this building?
I think records are back to 1950s, but it could be older than that.
Okay. Other questions of the applicant? It's like a lot of work's going to have to be done on that building, unless this is going to attract the hipsters that are already in Wedgwood, Houston. Put a bar sign on it and they'll show up. Do you have anything else to add about this case?
No, just that we do love the area and are excited about preserving part of the history. Definitely looking forward to making some improvements to it as well.
Okay. We're going to close the public hearing and discussion. So, interesting little area. Obviously, I think they talked about the wall and the fence, and once again, we have a council person who voted for the sidewalk bill, asking for someone to be let out of the sidewalk bill. So, there you go.
Yeah, the fence height is, again, is always when I look at it, it's like, well, what's going on until the case is made and I hear it, and it seems like it's one of those things that it is a fence, but it really is also an enclosure of a deck, which I think is an aesthetic choice, but also a safety choice, because I think it keeps people from being underneath the deck and that type of thing. So I don't have an issue with the height of the fence, and actually really applaud the applicant for restoring the old building and doing what they're doing.
Keeping a little bit of Wedgwood, Houston there before most people, well, there's some old buildings still.
No, I think that's
the smaller buildings usually go, though.
And, I don't have as strong opinion about the sidewalk, although I think that the fact that there's a sidewalk there is.
Okay, would you like to make a motion?
No, I don't want to make a motion on the sidewalk. I'll let y'all are the sidewalk folks. But do you have an issue with the sidewalk?
Councilperson doesn't, so I'll defer to the councilperson.
Then you get accused of not doing your job, which is very discouraging because the council members.
5 hours later, not doing my job.
Council members pass the law and then say, "Oh, we didn't really mean it."
Yes. Well, for this case, for this property, they didn't mean it. Everybody else, most everyone else, maybe. So no, I'm fine with that. I'll make a motion. I make a motion that we approve the variances from the sidewalk requirements and not having to pay into the in lieu fund, and also the variance of wall fence height in the CS district for the renovations of the existing building. And the hardship is the narrowness of the lot and the existing sidewalk that's already there in front of them, and the small little retaining wall. So,
I'll second, if you wouldn't mind, an amendment that, it looks like it's in good shape, but that the condition is that the existing sidewalk be repaired to be in what would.
Up to the rest of the standards
it
of
does
the.
appear to be in good shape.
Yeah,
so.
that they make sure that the sidewalk, as they're constructing, does not get in any worse shape. Okay, I'll accept that. Motion's been made and properly seconded. Any discussion? Seeing none, all those in favor of the motion signify by saying aye. Aye. Opposed? Passes unanimously. Yes, have fun. John Michael.
Mr. Chairman, the next case is 2018-178. This is a short-term rental case involving the property at 1717 Villa Place. Kristen Dabbs is the appellant and owner of the property. The appeal comes to you based upon a denial of the short-term rental permit after the originally issued permit had expired. Ms. Dabbs is present. Is there anyone here in opposition to case number 178? Seeing none, the appellant will have 5 minutes to make the desired presentation after the board hears from Mr. Osborne.
Okay, Mr. Osborne, how'd you hear about it? How many times was it rented, and any other information we need to know?
Well, this one was brought to our attention by Host Compliance, but it did obtain a permit back in January of 2016, which it did renew again in late 2016. So it looks like it just expired in January of this year.
Okay.
So a notice was sent on February 9th, 2018. It looks like the last review is submitted on February 11th. It looks like the Airbnb account is still active.
Still active, like listings active?
The calendar has available dates on it.
So if the calendar has available dates, you could technically rent?
You can try.
Right, okay.
Yep. So some dates are blocked out, some dates are available.
Okay, we'll ask the applicant about that. Any questions for Mr. Osborne? Okay, so is it still on Airbnb or what?
Not to my knowledge. As soon as I found out, which, I'll tell you my story, I took everything down.
So you have duly gotten a permit and you didn't send the City of Metro $50.
We did not get the letter, and I didn't know when to reapply. So we had someone that was helping us. She was assisting us, and she handled it the year before. And when she left, she didn't tell me when it was. And in my mind, it was in March. So I was prepared to do that in March, but I didn't know. And the letter that was sent to the wrong address.
Why was it sent to the wrong address?
It was sent to my father-in-law's old office address because he and I bought the house together, which we assumed everything was coming to our address at the time. So
this is your home?
Yes. So we're at 177 Villa. Sorry, I wrote it out, but then we got sidetracked by.
Would you speak closer to the speaker? I can't hear you.
I'm sorry. I didn't realize I wasn't. Sorry. I wrote everything out just so I wouldn't leave anything out. Do you mind if I read it real quick? Because we got sidetracked by the Airbnb thing.
Fine.
Yes, my husband and I have been doing Airbnb VRBO, mainly VRBO, for over 2 years. We have had great experience all around. It's been wonderful supplemental income for our family. Our guests have all had wonderful things to say, and our neighbors are very cooperative. We've never had one complaint. We've paid all of our fees and taxes on time and been in good standing. I'm here today because our permit expired and we were unaware of it. We had a girl, like I said, that was working for us, that was taking care of it, and she's gone. And I was ready to go renew in March, and I got a letter that was sent February 9th, but did not come to me until March 9th. Because it was sent to the wrong address. As soon as I got it, I came in the next day to renew the permit, only to find that it had been over the 30 days expired. So as soon as I found out, I came back. I took down all of the listings. We canceled probably 15 at least guests that were coming, refunded a lot of money that pretty much depleted our bank account. So we have cooperated in every way with this.
So you all live in this house?
Yes, this is our house.
But you rent it out for $650 a night?
Yes, sir.
So how does that work? Do you stay in the house while you're renting it out for $650 a night?
Well, I was actually unaware that we were supposed to stay in the house.
Well, I'm asking. So when someone pays you $650 a night, where do you all go?
We go to our family's house in Memphis, Tennessee, and sometimes we have friends.
Um,
It's a good location, and it's a good
reason to.
Yes, obviously. Nashville is booming right now. Okay, so any questions for the applicant? And I will read from the same council person that we heard from the last case, Colby Sledge. Kristen Dabbs, appellant, and it says, my position, approve. Appellant has reached out and ceased renting during the appeal process. I have no complaints on file for this property. So, any other things to add?
No, sir.
Okay. Any other questions for the applicant? So, Mr. Osborne said it was still sort of up. Are you?
I'm completely unaware of that. I have taken it down. I hid it. I made it unavailable. The only thing I could think of was in order to issue a refund, I had to go make it live again to issue that refund, but I made sure to hide it again. We don't use Airbnb hardly ever. I don't believe we had any guests booked on Airbnb, so it was all VRBO. But I am unaware of that.
Very good. So we're going to close the public hearing. Discussion, board members.
I'm okay with having a minimal
motion.
Someone that had a
make a motion.
Had a legitimate permit, so I will move that the zoning administrator didn't err. The applicant operated prior, and the applicant is eligible to reapply or to whatever, I guess it's a reapply at this point. And I'll just say tomorrow, they're eligible now, or 2 months, what are you saying, 2 months?
Oh, no, tomorrow's fine.
That they're this practically 2 months served already, so I'll say eligible tomorrow.
Okay, motion's been made. Is there a second?
I'll second.
Motion's been made and properly second. Any discussion? Seeing none, all those in favor of the motion signify by saying aye. Aye. Opposed? Passes unanimously. Good luck. John Michael.
Number 179 is the next one to be presented to the board. Night Train Coach is the appellant, and Little Creek General Partnership, owner of the property, located at 7454 Old Hickory Boulevard in Council District Number 3 to the northwest of our current location, Mr. Chairman. The request is for a variance from sidewalk requirements in the CS zoning district to construct a non-residential building. The site plan submitted here gives you an indication of the proposed layout from the face of the property at the assessor's website. Is there anyone here in opposition to case number 179? Seeing none, the appellants will have 5 minutes to make the desired presentation to the board. Please just introduce yourselves by names and address.
Name's Rob Cochran, Design Build Partners, 1121 Glendale Lane.
Matthew Friedman, representing Night Train 600 12th Avenue South, Nashville, Tennessee.
Okay, so get us started. Why are we here?
See, we are appealing a sidewalk mandate for the night train coaches.
So you're a bus company. What do you all do? So in that picture, there's a bunch of buses there. So
yes, sir. So we are headquartered and operate out of this facility just north of Nashville in Whites Creek, Tennessee. This particular exit of Old Hickory Boulevard is a main exit off 24 where many bus companies are headquartered, and there's really not much foot traffic.
So who rents your buses? Just these are?
Our particular operation is mostly entertainers.
Okay.
Travel the country, bands, pretty much anyone who tours all over the country. So.
Bit of trivia for you. Nashville is responsible for the tour bus industry because the Grand Ole Opry required people to be here on Saturday night. They didn't pay very much back then, so people had to travel to other cities, and so they took buses, and starting in the 40s. So we were kind of led that industry, and glad that you're still in it. So what's the closest sidewalk to this site?
I looked every direction for a mile and didn't see anything, so I respectfully suggest it's at least a mile and almost certainly more.
Okay. And why do you not wish to pay into the in lieu fund?
Well, having heard the discussion earlier, it seems like there's a tough sell for that. We sit on a state highway. If the in lieu fund, and so first off, we sit on a state highway. TDOT actually owns a little chunk of the land that I won't say bisect, but interrupts the frontage on Night Train's property. So as far as determining the in lieu fund, I'd be interested to hear a reaction to that. What I'd respectfully request is, or observe, is that if the sidewalk fund is intended to go to communities in and around, in this case, the Night Train site, we are miles from them, and it seems, I don't know if this is a point for city council or not, but it seems a little egregious to ask these guys to pay into a fund that might be used in Bellevue and Whites Creek region would not receive much benefit.
Question?
The chart that just was shown, and it didn't look, how much street frontage do they have?
So the particular property, you can see the road at the top of the screen there. There's really not much between the building and the street right there. Towards closer to our current entrance, it will be a shared entrance. That's where the TDOT easement sets back there.
Yeah.
So between the building and the street, there's really not much room for a sidewalk to begin with. That's one reason we're asking to.
Yeah, and I was just saying, I mean,
it's somewhat of a trick. There is 233.82 linear feet at its longest distance. I believe I'm reading this correct. Then the property line takes a sharp 55-foot turn. Then again another.
I guess on this, I guess what I'm seeing is on this drawing, I don't see your property touching Old Hickory. You said it's like you got to. I mean, am I looking at?
Yeah. So the one that's highlighted is actually the incorrect property. It's the small one. It's kind of an L shape to the left of the CS.
Okay.
So you see where the building is currently. It's directly above that. That's where we're planning to build a new building.
Okay.
Small lot there, rectangle shape.
But you own the frontage from that to the street except the TDOT right away or whatever?
Correct, yes.
Okay.
It's an awkward pace, and
so we're planning to combine the two properties here as well. So the driveway for both the new shop and the current shop will be shared, and we'll be able to use the existing entrance. We won't have to build a new one.
Okay, so any other questions for the applicant? Anything else to add?
I mean, just mainly noting as well that right on either side of Old Hickory Boulevard, there's really not much foot traffic. There's currently a storm ditch, really, that drops off the road and makes this very difficult to even build in the future.
Okay. We're going to close public hearing. Discussion. We have planning's recommendation in front of us, of course, but as we heard, this is a very rural area and even industrial in this little section.
Did I understand that their frontage is 233.82 linear feet at $175 a pop?
Yep.
I mean, a foot.
That's the bill passed by council. Thoughts on the sidewalk variance?
Over $40,000.
said when the council passed this, saying knew well and good what would happen, and this is one of those cases.
Well, again, if we don't, if we make them pay, or if we give them the option of paying the in lieu fee and they determine they can build the sidewalk cheaper, it's pretty amazing how many people have decided to build the sidewalk after all. There's been a lot of cases where contractors have come in and said, we can't build that sidewalk. Well, then pay the in lieu fee. I'll build the sidewalk, which I think is kind of what council was going for.
Have a motion?
Go ahead, David.
No, I don't. I tend to. I don't know that I'd get votes on my motion.
You don't know if they will?
I don't know if I'd get any votes on mine. So y'all.
Well, make a motion.
No, I don't.
Make a motion.
I mean,
We got 4 of us.
It's going to be unanimous no matter what.
yeah. I mean. I guess the question is pay or no pay, and I just don't have a sense of what y'all are.
Make a motion and find out.
I don't know. I don't really know which way you want to
Make a motion and find out.
I don't have a motion. Have at it.
I'll move that we grant the variance for the sidewalk with the condition that the applicant pay the in lieu fee.
Second.
Okay, motion's been made and properly seconded. Any discussion? Seeing none, all those in favor of the motion signify by saying aye. Aye. Opposed? Passes unanimously. John Michael.
Mr. Chairman, the next case for the board's consideration is 2018 number 181 involving the property at 448 Atlas Drive over in Council District number 26. Justin Crandall is the appellant on behalf of DBV Properties, LLC, the owner of that property. The request is for variances from the sidewalk requirements and also a variance from tree density requirements in the IR zoning district for construction of addition to the existing use of the property. The request specifically with regard to sidewalk is for no build, no pay. Planning's recommendation is already in your case file. The urban forester is, and amazingly has been present for the duration of this meeting with regard to the tree density requirement variance. Is the appellant present? Great, come forward. Is there anyone here in opposition to case number 181? Is there anyone else in the audience who knows where 448 Atlas Drive is? Seeing no one, will allow them to make the presentation to the board. You have 5 minutes to do so. Just please introduce yourselves by name and address.
Do we hear from our urban forester first? Yes, hear from our urban forester.
Sure, how y'all doing?
Good, good.
It's a late night. The Pred's starting in 30 minutes. I hope you know this.
We better get out of
Okay,
here.
so tell us about
I can address the tree density.
the tree ordinance, and why is it triggered in this?
They are, I believe they're going over 25% expansion,
Okay.
which triggers the tree density requirement, which.
So where on that lot would you plant a bunch of trees?
Well, that's the problem. They would have to either dig up asphalt and plant trees somewhere on that parcel, or pay into the tree bank, which, like the sidewalk in lieu of, it's not an attractive option, but it's an option nonetheless.
It was
So there
either
was a tree
dig or pay into the tree fund.
That is correct.
So how many trees would they be required for that?
Well, I
site?
think the site is 2 acres or so, and so they would be looking at 28 tree density units minus the building footprint. So best guesstimate would be approximately 35, 36 trees. The tree bank amount would be $725 a unit, so 725 times 14, whatever that would be.
So is
It's
the
not an
property-
attractive option.
So is the property, is it all paved?
It looks like it's pretty much paved wall to wall.
Yeah, to the edges of the property, but we'll ask the applicant. Anything we need to ask? Our
Unless
urban forester?
the expansion drops below 25%, and then the tree density requirement would go away.
So, for example, the tree, could they just tear up a little bit of this and plant all the trees in one spot, or is it, there's rules about?
Tree would have to have 90 square feet, but
And are you
they could go anywhere on that property.
As long as it has 90 square feet.
Well, let me make sure.
comfortable with them not paying to the tree density fund? Is that what?
They're urban forester here.
I think that, this is an opportunity to regain some tree canopy.
Okay. So you
Somewhere,
think they should
somewhere
pay?
in the city. So
Okay.
one or the other, I think.
Okay.
Let me ask you to be clear. You said it would be 35 to 36 trees, but at 725 times 14.
Times a unit. That's a tree density unit.
Oh, okay. I didn't understand what a
So,
tree density
now
is.
a 2-inch tree counts for 1/2 of a unit.
Oh, okay. Thank you.
And those
never heard
numbers
that.
are not ironclad, so.
Okay, so we've been educated about
Oh, yes.
tree density today. So any questions
Well,
for
how
our
far
urban
off-
forester?
How far off are we? You said if the addition got below the 25%?
If it went less than 25% of the footprint and or 50% of the value,
It's an and/or.
either one.
And how
you know.
close are they?
I do not know.
You're no help. Sorry, Steve.
Maybe they can answer that.
Okay, please state your name, address.
My name is
why-
Grant Town. I'm with Crowder Construction, LLC. I live in Lewisburg, Tennessee, 37091. I'm here to represent Team Construction, and we are asking for a variance on the sidewalk and the trees due to this as a commercial industrial park, not a residential neighborhood. And there is a tree line behind the property that's about 40 feet wide and the length of.
So you understand that the laws apply to this too, for tree density and tree bank and the sidewalk bank? Doesn't matter.
This has been here for 60 years, okay? And it's an industrial commercial park. There is no residential people walking around these streets, and everything there is paved from one end of the road to the other. This is an old aerial view. I mean, I have updated photos of it, and it's just slam packed with nothing but parking lots.
And I'm Mason Mingus. I live in Spring Hill, but my father owns the company, and so I'm here to represent him. But just an idea of what we do, we're a construction company, and so we bring equipment and heavy trucks in and out of this place on a daily basis. We wouldn't even be able to get around our parking lot with trees.
That's why the tree bank's there.
So, yeah, I understand that, but again, we dig ditches for a living, so it's kind of tough to pay that much, and then the sidewalk ordeal, so which we're getting to.
Okay. Questions for the applicant?
Well, the forester said maybe they could answer the question for us, is what's the percentage of the expansion? Does it, in fact, trigger either the tree or the sidewalk?
Well, I'm assuming since it's on the agenda, John Michael, it triggers both,
Okay.
right?
I was assuming that, but I wanted to make sure.
A 48 by 48 expansion of this property.
I mean,
I don't, well, we can wait till the public meeting's closed.
Do you all have anything else to add?
Yeah, well, are we addressing the sidewalk ordinance too?
Sure, absolutely.
Okay, because, which he can go into depth on what it'll take to put a sidewalk in. And this is obviously an industrial park, as he stated, and there's not a sidewalk in sight.
No, same
So-
thing. We have this
Yep,
sidewalk bank.
As we get into the sidewalk bank and the tree bank, that'll total up to be about $80,000 or $90,000, because I think it's a 300 or 400 foot road frontage, which is outrageous, obviously, as you all know. So we're just hoping for some leniency on that. We would absolutely give up the right of way, I believe, if someone in the future wanted to come in and use that to put in the sidewalk. We would forfeit that frontage, but I think it's absolutely outrageous. In my opinion, I think in most people's opinion, after hearing everybody talk, to ask everybody to pay this or to put in sidewalks, because it is a drainage ditch. and he can tell you what that would entail to build a sidewalk. But it's extensive.
Those are our laws. So, John Michael, did you find out anything? Okay. So, we're assuming it's all required. So, questions for the applicant?
I mean, we have a hardship case with a retaining wall and everything else across the front of this property.
The hardship, what is the hardship about?
Well, because you don't have the room to put a sidewalk.
That's why we have a sidewalk bank.
Well, you don't have a room to put it. I mean, why would we have to pay a sidewalk fee for an industrial park when this is a residential?
John Michael, why do we have to do that?
Because the law says so. I'm sorry to be glib about it, but I mean, we could go into the details of 493 is passed by the Metro Council, took effect July 1 of 2017. Every development in the city of Nashville, regardless of zoning designation, is subject to being reviewed by the sidewalk ordinance. And if the sidewalk ordinance deems a property appropriate for the trigger, it's not some judgment call we're making down at codes or they're making down at Public Works. We don't get a lot of flexibility on any aspect of that. If the law says so, then you build. If you do not build and you do have the option to pay, then you may pay. If you don't have the option to pay, you can appeal to the board and try to get permission to pay or otherwise get a variance out of it. But again, short answer, because the law says so.
And how many people in the Metro Council voted against that bill?
My recollection, that was unanimous vote, Mr. Chairman.
It was. Okay. Questions of the applicant? Anything else to add?
Yeah, are you going to improve your part of the front of this so we can do our job?
They don't know any of this. For Metro.
Okay. Well, I mean, the law states if you present a hardship case and you have a retaining wall you have to put in and everything else, that you can get a variance on this. So that's what I am here for, is to appeal this variance, because the law states that if you have to put in a retaining wall and do extensive work to the property, that you can have this variance taken care of.
John Michael, is that the law?
If that's not the case, then why would you have it on the list of hardship cases to appeal the case with?
John Michael, is that something
the references to the conditions whereby a variance can be granted under the zoning code, Title 17. In order to demonstrate a hardship, you can refer to things like topography, conditions of the lot, old trees that are trying to be saved, existing other conditions of the actual physical property. So yes, this is potentially one such thing. It's not an automatic stamp, or we would have stamped it already. The board has the ability to determine whether or not that is in fact a hardship that gives rise to a variance.
And then of course, even under hardship situations, we could still require to pay into the fund, which we have done. So, any other questions for the applicant? Anything else to add? We're going to close the public hearing discussion. Here's another sidewalk case and also a tree canopy case in a very industrial area with doesn't have hardly any sidewalks in the area.
If I might just give the board just some thoughts. 1720-125 speaks to your authority as it relates to the BZA and specifically grants you some authority as it relates to the sidewalk. And it says the provisions of section 1720-120 may be varied or interpretations appealed in conformance with Chapter 1740, Administration and Procedures, which is what Mr. Michael was just referring to. And then it goes on to say that the Board of Zoning Appeals may require a contribution to the pedestrian network consistent with subsection 1720-120D, which goes into all those typical contributions to the pedestrian benefit zone. It also may require alternative sidewalk design or other mitigation for loss of public improvement as a condition for or to a variance. And I point that out because not every code section that you vary gives you separate authority to impose a fee, but this one does. So just to the extent that the board
pay into the fund,
right, is interested in knowing where that comes from, I wanted to make sure that you were aware.
Okay, so
but we don't have the authority to change the fee.
Correct.
The ordinance,
because it's pursuant to how it's already set up in the sidewalk law.
So we on this one it's a pay or no pay, and if they pay, it's a fixed amount. But we can't say
pay a lesser amount.
Pay a lesser amount.
Correct.
And that's our.
We have
We have given variance before for a portion of a property.
But we deemed that the sidewalk on one portion was fine and acceptable and the other needed
Right,
to
but
be.
or there was
There's
a drainage
nothing
issue
here.
or something like
And
that.
there's a
So, yeah,
new
we granted the
trees.
variance for the part that
Yeah,
had.
I mean, for
the-
example, if there was a little space where they could put some trees, you could say, okay, plant some trees here and then the rest to the bank, but that's
Right.
not the case. So,
Oh, well, I think that these are examples where, you know, you start getting into a fee or a tax or whatever you want to call it, that is going to, you know, may start to keep people from improving their property, and that yet, I don't know if that's our problem today or not. You know, there is a topographical hardship, I think, for a variance, but whether they pay for the sidewalk with the retaining wall and whether or not that is enough to keep them from paying or not, I don't know, but you know, it's a very substantive amount.
so once again, the planning commission's recommendation is to pay into the in lieu funds.
That, yeah.
Does anyone have a motion?
Gosh, this is hard. I don't see any recommendation from planning about the tree.
I think that was all encompassing when they just talk about paying in lieu funds that contribute. The planning said the applicant shall contribute in lieu of construction for property frontage. And they don't seem to address the tree issue here, but.
Planning doesn't address trees, that's straight zoning.
Okay.
Planning
We
doesn't have a
heard from the urban forester who suggested the in lieu fund.
What if they put trees where the sidewalk should go?
It's all paved, you know that.
Well, there's grass right there.
That's not enough for whatever he said it was needed for square footage.
I'm still not clear. Are we, Mr. Herbert, are we still not addressing the tree requirement?
Yes, it's an appeal before you. I'm just saying that the planning department doesn't opine on the trees. That's our urban forester only.
Planning doesn't get into
So
trees.
and I think this is the first tree density case where we've been asked to deny. I mean, you know, there are other alternative plans and, you know, existing hedges and whatnot that have allowed for variances, but I don't think we've ever been asked to deny a tree density variance request. And I think if we just deny it, then they either put in the trees or pay, right? So, I mean, we don't have to say you have to pay into the fund. We just deny the variance, right? So, and I'm okay with that based on the recommendation of the urban forester. And like I said, you know, it's that coupled with sidewalks that I'm having a tough time with. And so, I mean, I don't mind taking it
one by one
and making a motion to deny the tree density variance.
Okay, so the motion's been made. Is there a second?
I'll second.
Motion's been made, properly seconded. Any discussion? Seeing none, all those in favor signify by saying aye. Aye. Opposed? Passes unanimously. Second.
And I will put a motion out there and see if it goes anywhere. My guess is, you know, I'm not going to guess anything, but I will move that we grant the sidewalk variance and not pay into the fund, provided that the applicant give the a variant or the right of way for a future potential sidewalk, should the city ever choose to put a sidewalk in.
I will second it.
Okay, motion's been made and properly seconded. Any discussion? Seeing none, all those in favor signify by saying aye. Opposed?
Fails.
Okay. No need to, well, Do you want to have another motion?
We let it sit and let's see if two more people want to chime in on it in the next 30 days.
Okay.
In the absence of different motion, the second matter regarding the sidewalk gets no affirmative vote of 4 either way. Therefore, the matter will stay open on the docket to the May 17 docket, at which time our 2 other board members have the opportunity to review the file and place a vote. There'll be no new hearing on it. You don't have to come say anything. However, the board will take up the vote on May the 17th. The next case to be presented to the board is...
Question.
How can I help you?
Question.
Yeah.
Can we come make our case to these other 2 people?
There is no hearing to be made. If you just made it, they will watch a video of this. They will hear every word you said and read every document that's been submitted.
Okay.
The next case to be presented to the board is 2018-184. That case involves the property at 1206 Norvell Avenue in Council District Number 7. Bill DeGuire and Sons, the appellants, on behalf of Jonathan Hamill, the owner of the property, located at that address, as seen here on the zoning map in the Madison community, not far south of Briley Parkway. The aerial of the property shows the house. Although this is somewhat dated, you can see just to the, I guess, lower portion of this photograph, the accessory structure that's in question with this particular appeal. The request is for a variance from side setback requirements in this residential district for the accessory structure. The requirements are 3 feet at the side, 10 to the rear. The appellant will do a good job, I'm sure, explaining exactly what they're seeking with regard to the site plan shown here, closer to the side setback. From my recent site visit, a view of the house from the front, the view across the street, and of course the view up and down Norvell Avenue at this location. Is there anyone here in opposition to case number 184? Seeing none, the appellant will have 5 minutes to make the desired presentation. Just introduce yourself by name and address.
Bill DeGuire, 110 Ridge Drive, Hendersonville, Tennessee. We had an existing garage. Of course, we had a demolition permit. The new structure, we tore the old structure down. I moved the new structure a foot to the inside of the property because there was no survey, no survey lines or anything like that. I went by the existing building, moved it a foot in. Couldn't move it any further because you can see on the plat shows on the other side of it is sewer lines and a manhole. So I felt like I moved it over as far as I could. I had a surveyor come out there, and I stayed out there the whole time. He went from one end of the neighborhood to the other trying to find pins to try to get as accurate of a survey as he could. And what he came back with was that everything that the inspectors were measuring off of was not the setback. The foundation was inspected, passed. The electrical, we buried an electrical line to that garage back there, and all that's been okay. The final inspection came out, everything was fine, framing. The inside is just framing only. It's no drywall or anything, since it's just a garage. Everything was great, except for the setback.
So your hardship is a sewer line and
Correct. There's a sewer line coming from that house. It's probably 16 inches away from the other side of the building. Then there's a manhole that's probably 2 feet from the back corner, and the house on the right side, the big barn-looking thing back there behind that house, there's a sewer line that goes to that, in that manhole. And then there's an exit for the manhole going to the property behind.
Okay.
What, and your neighbor that has the big barn, are they okay? They're okay with they?
Oh yeah, I mean the fence has been there forever.
Oh, I see.
You know, and it's according to what section of the fence you want to measure off of, because it's not too straight. But they're fine with it because they actually have a foot more, but they're not using the space anyway. And if
they
indeed
have a big barn in their yard.
I actually took a picture of the back of it, but I mean,
so
in actuality, if the existing garage that was there would have actually been sitting on that person's property before we tore it down.
Okay.
So is there any questions for the applicant? Anything else to add? Thank you. We're going to close the public hearing.
I'll move we approve the variance, the side setback variance request based on the hardship of the sewer line and manhole.
Okay. Motion's been made, properly seconded. Any discussion? Seeing none, all those in favor of the variance signify by saying aye. Aye.
Aye.
Opposed? Passes unanimously. John Michael.
Thanks.
Our last case.
Is it our last case?
No, we got one more.
We have two?
Well, one's going to be booted.
We got two more.
Mr. Berry, please come forward. Yes, you're next. I have no idea. But Mr. Berry is going to. So John Michael, is this our last case or not?
As long as we can confirm that the previously healed case, and forgive me, I got to be able to call it the right way, Ken Wade, the appellant for 157, did not show up. The board had previously announced that would be deferred to June 21st, 2018 docket, based upon having not showed up today. So yes, with that, Mr. Chairman, this is the last case of the day. It's case number 194. Mr. Berry, of course, is the appellant for the owner of this property, RB Rivergate LLC. The subject property shows us the address 2125 Gallatin Pike. The highlighted parcel in solid pink there is the property in question. If that zoning map looks like a mess, it's because the zoning of this property is a mess. The property at question involves OR 20 zoning, SCR zoning, an old commercial planned unit development overlay from the 70s, a residential planned unit development from the 70s, and a number of other things. It's probably all Mr. Berry's fault, frankly. The aerial photograph shows that this is a well-developed commercial establishment in kind of the Rivergate area, right along Gallatin Pike. Sorry, again, 2125 Gallatin Pike is the address shown here. As Mr. Berry and his clients would probably be able to explain, the individual units along here are not 2125A, B, C, D, but in fact individually numbered places of business. The site plan shown here gives you a little bit of a layout and the suite number. And again, we're calling them suite numbers here, but that's how you'll find the individual businesses. Case in point, there is a 2125 lower right-hand corner. That's the actual suite, not the street address. It's my understanding this is not the finance business in question, but in fact a restaurant. Another finance business there in Suite 2119 nearby as well. The views up and down Gallatin Pike from these photographs, from the out parcel there on this subject property. That's a pretty good overview. So as you know, this is an item A case where the appellants have challenged the zoning administrator and zoning staff's interpretation of law pertaining first to land use classifications and secondly, distance requirements for certain financial businesses in this SCR, OR20, PUD overlay zoning districts. Before handing it over to, I guess, Mr. Herbert for any introductory comments as a zoning administrator, we will note that we've spent the time working on this, have communicated capably with Mr. Berry to kind of identify what the questions are. The planned unit developments will be definitely part of the consideration for our staff going forward because, as you know, Mr. Chairman, the planning department and only the planning department makes interpretations of applications of law under planned unit developments just as they do with specific plan zoning and downtown code zoning. Additionally, though, at its most basic, this is a request to overturn the staff's determination as to which line item this particular business would fit into in the land use table. As you know, we have many instances where there's nothing that exactly speaks to a land use that is contemplated, and therefore it falls to the zoning administrator to use his best judgment and make the determination as to which category it should fit into under our good, but admittedly imperfectly filled out land use table. Then secondly, if in fact it is the land use that was identified by staff as the closest description, there is a distance requirement in place for businesses that fit into that category that they must be at least X number of feet apart. There is a question that this would not in fact meet that distance requirement if in fact that is the land use identified. So if you'll forgive me for what must seem like an over-explanation here at nearly 7 o'clock, I thought it was imperative to point out that it is in fact two separate questions, both part of the item A appeal, somewhat tied together and perhaps entirely overshot by the question of the planned unit development that has to be interpreted by codes, or rather by planning. So with that, we'll hear from the zoning administrator, then from Mr. Berry and his clients.
So what I would suggest here, this is complicated, and Mr. Berry and I have talked, and I think the best way for you all to understand what's going on here is for Mr. Berry to lay out what his position is, and then I'll turn around and respond to it. I just think, wouldn't you agree that that's the best way for this board to understand what's going on?
I do think we ought to state our appeal first, and the decision that was
And I agree with
appealed
that.
from, and then we do have an issue that may have to be decided later by the zoning administrator.
But Mr. Berry, please state your name and address for the
I will.
record.
My name is Douglas Berry. I'm an attorney here in Nashville with Miller and Martin Law Firm. Our address is 401 Commerce Street, Nashville. Seated to my right is Mr. Thomas Morandi, who is a representative of RD Management, LLC, which is the owner of the Marketplace at Rivergate, which is a built-out, established shopping center up on Gallatin Road. And to my far right is Mr. Joe Cherry with First Franklin Financial Services, who would testify about the nature of the financial services that his firm, as a potential tenant for this space, provides, and why they would not be subject to the district restriction that the zoning staff determination they made. This matter arose in December of 2017 when a tenant, First Franklin Financial Services, met with Tom Corcoran of the zoning staff and were denied a certificate of use and occupancy for a space in this shopping center because there was an existing tenant, Mariner Financial Services, which also is a consumer loan company. And Mr. Corcoran's determination was made based upon the, I think, 2015 ordinance of Metropolitan Nashville, which regulated the distance that an quote alternative financial services business could be from another alternative financial services business. And that distance is a quarter of a mile, although it's stated as 1,320 feet in the ordinance. Our position is twofold. First of all is that the definition of alternative financial services under the ordinance is an establishment that provides, quote, a variety of financial services, including but not limited to cash advance, title loans, check cashing, pawn shops, and flex loans. And that's one of the requirements for being an alternative financial services establishment. The other is that you not be a federally insured conventional bank, which our client is, which this tenant is not. We have attached to our appeal an Exhibit 2 is a letter from First Franklin Financial Services signed by their general counsel. He's based in Georgia, and that's why we brought Mr. Cherry here to talk about Tennessee experience. But First Franklin is simply not an alternative financial services establishment as defined in the zoning ordinance. It is some of you are as old as I am will remember Associates Financial Services in my life was sort of the leading company. It's a consumer finance company. Eventually became bought out by Citigroup and is now called One Main. But these are conventional consumer finance companies that make installment loans and money loans for consumer items, and also some mortgage lending. And so Mr. Cherry will testify and will confirm that. And I want you to ask him any questions you have about his business. But most importantly, neither First Franklin Financial or Mariner Finance is an alternative financial service as defined in the Metro's ordinance. They're not in those lines. They do not currently provide cash advance, title loans, check cashing services, pawn shop loans, payday loans, so-called flex loans. They're not in those lines of business and don't plan to get into those lines of business. It's a separately regulated sector of the financial services industry. They are what's called an industrial loan and thrift company, which has been regulated in Tennessee since the late 70s. And each of those types of businesses are separately regulated by the Department of Financial Institutions at the state level, check cashing businesses. And they've all sprung up. It's a relatively new phenomenon, probably 20 years old. First Franklin Financial has been in business since 1941. So they are not in that, simply not in that business. So that is, I think, our first and most essential argument on this is that this ordinance does not regulate this type of financial services business. Second, and this feels like a loophole, but I included in our brief mostly to preserve the argument, but the prohibition, and even if they were an alternative financial services business, the prohibition is that one establishment is prohibited from locating less than 1,320 linear feet from the property line of another property upon which another alternative financial services establishment is located. Well, these are two properties owned by this is the same property. We might say, well, my goodness, the Metro Council created a loophole. Well, let me tell you something. My goodness, it's a zoning ordinance. This is what the Metro Council tells you what they intend to regulate by passing a zoning ordinance. If they intended to have a single owner be subject to that, they could have said so. And as you know, with zoning ordinance, all zoning ordinances are to be interpreted in cases of an ambiguity in favor of the free use of property by the property owner. But I mostly state that to preserve that argument, because I don't want you to think we're trying to sneak through a loophole. I mean, I think that it's valid, but the real point is this is simply not the sort of financial service that is being intended to be regulated by this 2015 ordinance. I think it's important if, one thing Mr. Herbert and I have discussed today, and let me say we discussed this today, our appeal was based on the call the zoning officer made as affirmed by Mr. Michael, and strictly related to this issue. And if you've read our appeal, you can see that. The question has arisen, evidently this is an old commercial pub out there. We understand, my client understands, that if we're asking that you grant relief and you reverse the decision of the zoning officer about the applicability.
We haven't heard from him yet.
Oh, I know. Let me finish if you don't mind, Mr.
Okay.
It reversed the decision that's been made. Now, if Mr. Herbert then has to say, if you're inclined to do that, then he may say, well, I need to examine the terms of the PUD approval, and if is the use a permitted use, if it's not subject to this distance restriction, is it a permitted use under the terms of that PUD? They want us out of here. They want to go to the press game. So that's our position, and that's why we want to make clear. It could be complicated, but I don't think your decision tonight is necessarily complicated by that. We're willing to defer to, or we understand that if you were to grant relief from this distance restriction, you say, look, one thing we know, it's not an alternative financial services business as the potential tenant as defined in this ordinance. And I want you to question Mr. Cherry about his business and the business and his familiarity with those businesses. Then we understand that it would not be immediate issuance of a certificate of use and occupancy until Mr. Herbert had determined that it was compliant with the PUD. So
I don't know why you guys waited so long to present this case today, but
I beg your pardon?
I don't know why you guys waited so long to present this case. I'm really tired.
Oh, well, we did beg Mr. Michael to be at the heel of this docket rather than the next week, so that was a bad comment.
So are you saying that not only is your client doesn't meet that definition?
Well, our potential tenant. My client is the owner of the shop.
I'm sorry, yes.
But
but actually neither of the financial institutions meet that
Neither
definition.
of them meet.
So in theory, we could find that we could agree with one or the other, and you're still in the clear because it says you can't have two of these.
That's true.
And you're saying this argument there's not only is there not one, there's not two.
Even if Mariner were an alternative financial establishment, we're not. I would say First Franklin Financial is not.
So I have a question for Mr. Cherry.
Go ahead. Yeah, please. Mr. Cherry is.
I looked at your website, and you talked about giving people loans for car repairs, medical bills, vacation. So how do you determine, what's your collateral? Is there any collateral? And how do you determine who gets these loans?
We base all of our credit decisions on a complete credit application. We verify credit through the credit bureau, and that they're worthy of that credit, and that they have the means and the ability to repay that loan.
There's no collateral?
There is some collateral.
What kind of
unsecured loans?
Like what?
We use personal property, which can be personal items such as TVs, four-wheelers, ATVs. We use cars as collateral if they want to pledge a car, if they want to finance a car.
Okay, so why isn't that similar to all these title loan places?
Because a title loan does not take an application. They don't qualify the individual. If you have a car title and walk in their door, you don't have to verify you have any money, any income. You don't have to verify what your credit is. They don't pull a credit bureau. They just make you a loan based on.
But it's based on the collateral, which is the title. That's a title company car loan, right?
I'm sorry.
That's based on the collateral, though, and you base your loan on the same car.
No, we don't base our loan on collateral. We base our loan on the customer.
But if I just walked in and I didn't have a car title or personal property, would you give me a loan?
Yeah, if your credit score was high enough. Yes.
Well, I probably, as you know, your institution, nothing against your institution, but you often deal with people that were turned down by traditional lenders.
Absolutely.
And you charge a higher interest rate too.
Yes, sir.
So if I had an 800 credit score, I'm not your customer. I could go to.
It could be because we have a product that fits higher credit score customers.
But I could go to a traditional bank or a traditional lending institution. So who is your customer?
Who's my customer?
Mm-hmm.
Anybody.
Well, okay.
We have probably 90% of my customer base, which I have over 20,000 customers in the state of Tennessee. 90% of those customers have bank loans.
But if I were to ask one of the traditional title loan companies that we see all over the place here in Nashville who their customer is, they could probably tell me, very specifically. It's like, oh, somebody, credit score, maybe not, maybe get a denied, they need some money quickly, they have a car title. So I'll ask you again.
A real open-end question in that.
Well, because I'm trying to determine what kind of financial institution you are compared to others. So that's a fair question.
Any customer is potentially, any person
I get that.
applying for credit is potentially my customer. We have customers that range from a 500 Beacon score to an 800 Beacon score.
But a majority of your customers are who?
The majority of them would be about a 620 average blue-collar worker that goes to work every day and works in a factory, and he needs money for vacations, for medical bills, for various and sundry items such as that. Most people anymore don't really want to go to the banks and jump through all the hoops they have.
Well, they do if the loan is not as a higher interest rate.
So would you say, is this a fair statement that the difference between what I'm hearing you say and a payday loan or title loan company is that in a title loan company, your credit is dependent upon your collateral, and in your business, the collateral might adjust the terms of the product that you're offering, but isn't dependent upon the collateral.
Okay, so let's hear from Mr. Herbert. Mr. Herbert, why don't you agree with Mr. Berry over here with this definition of a financial institution?
So the question here is, as the zoning administrator, how do I classify this use? And so the way I look at this, I've got two choices under the zoning code. My first choice is alternative financial services. My second choice is financial institution. I just don't think there's any other zoning classification that under the zoning code as we have it that could possibly address this situation. I think it has to be one of those two. So now, as the zoning administrator, I have to decide which one to put it into. So I have to find which classification most closely correlates to what it is that they actually do. And what I've got from them is some very lengthy explanation as to what they are not. I have a lot of explanation as to why they are not alternative financial services. What I don't have is any explanation as to what they are. So I'm being told what they say they are not, but I've not been given an answer as to what they contend they are. So what is the correct classification? In my mind, I think that we have, again, two choices. Alternative financial services, which they have clearly said that they are not. The other one is financial institution. So for the purposes of the record here, and I hate to do this to you, but I'm going to have to read these definitions in.
Well, I was going to ask you to anyway.
Yeah. So if you don't mind, let me read them.
Mr. Herbert, and I don't know what point we would have to make an objection to preserve it, but most respectfully, and I have no objection, you read what you have to. Most respectfully, those issues are not before this board tonight. All we're asking is that you make that negative decision, that this is not alternative financial services. As we have said, it was brought to my attention at 12:30 this afternoon that there needed to be a decision made about, okay, if you're not that, what are you? And I have some arguments I could make about that it's either general office or it's retail services or something, but I just want to say for the record that that issue is not something that it was part of the decision that we are appealing or part of our appeal. So if we're fine with Mr. Herbert if this board is inclined to say you're not alternative financial service as defined. That's all we're asking. Then what are you to make his decision as he will in his wisdom and review? Then that may also be a reviewable decision, but I don't think that's before you tonight, and we would object to that being considered tonight.
And
thank you, Mr. Herbert.
And after I was interrupted there in the middle of and lost my train of thought, I have to decide what classification to put this into. And I've been told that it's not alternative financial services. If it's not that, then what is it? My only other viable option is financial institution. So let me read these into the record if you don't mind. Alternative financial services means any building, room, space, or portion thereof where an establishment provides a variety of financial services, including but not limited to cash advance, title loans, check cashing, pawn shops, and flex loans, and such establishment is not a state or federally chartered bank, savings and loan association or credit union, a mortgage company, or other financial institution whose services are insured by an agency of the United States government. So there's my definition of alternative financial services that the applicant is saying they are not. Now, here's my other choice. Financial institution. Financial institution means any building, room, space, or portion thereof where an establishment provides a variety of financial services and is a state or federally chartered bank, savings and loan association, or credit union, a mortgage company, or other financial institution whose services are insured by an agency of the United States government, but excluding alternative financial services. So those are my choices. The only indication that I have gotten for what they are is in a letter that was written to me by Mr. Mark J. Scarpitti. And I'm going to read what Mr. Scarpitti wrote to me. It says, while neither company is a bank, credit union, loan association, or federally insured, one FFC and Mariner are consumer finance companies offering traditional installment loans and purchase money sales finance products. Okay, so that's the only indication of what they say that they are. However, they admit that they are not a bank. They also admit that they are not federally insured. So because of that, I don't see that I can classify them as under the definition of financial institution. That leaves me with only one, and that's alternative financial services. And again, to meet the definition under alternative financial services, they are under that definition, you are not a state or federally chartered bank, savings and loan association or credit union, a mortgage company, or any other financial institution whose services are insured by an agency of the United States government. So they've said that they are not federally insured. They've said that they are not a bank. That leaves me one choice: alternative financial services.
And the reason that even though they may say, well, I don't have, it's not a true title loan, or I don't cash checks and I'm not a pawn shop, but the language of this says you're, and I'm putting words in your mouth, but I'm trying to understand. You're basically saying, well, you do financial transactions that may use title as collateral or whatnot. But you're doing financial transactions and you're not insured, therefore you are alternative financial. I mean, it's not just that they're not, I mean, it sounds like that the case is not is more than just, hey, I have to put them somewhere, but it's, no, I think this, you are this. You're doing, you know, this is, you're doing these things that, including but not limited to, a variety of, you are offering a variety of financial services and you're not insured. So you are an alternative financial.
That is correct.
Okay. Because,
and it also comes down to our loss gives two financial categories. Since this is not a bank and savings and loan mortgage company or whatever, and insured by the United States government, you thought that the second category was closer to the first category for this institution.
That is correct. And again, I've been told repeatedly what they are not, but they've not offered to me what they are. And the only indication that I have is from the letter from Mr. Scarpitti, and it says that they are consumer finance companies offering traditional installment loans and purchase money sales finance products. I don't really know what that means, but I do know that they're not federally insured. They admit that, and they admit they're not.
Mr. Barrett, so why is he wrong? Why is he wrong?
First of all, let me repeat. The decision that was made was purely based on you are subject to this alternative financial services status.
But Mr. Berry, you understand this is an item A appeal, and so we are here to determine whether he was right or he was wrong. And so I asked you,
I'm trying to respond.
Why is he wrong?
It's wrong because alternative financial services is a restrictive regulation. It says you must be both a establishment that provides these financial services, which we don't provide. If it's testified that we do not provide, that First Financial, our potential tenant, does not provide. So the question then becomes: is a state-regulated industrial loan and thrift company like First Franklin Financial, like Mariner, like what's the other one? First One
Main Financial.
One Main, formerly, are they now illegal non-conforming uses in Metro? It'll be news to them that they are now considered check cashing services. It will be big news, but they don't provide those services.
Mr. Berry, the first part talks about insured by an agency of the United States government. Are you all insured by that?
We don't claim to be, but there's a two-part test.
Okay, so I'll add, what's his,
Mr. Chairman, it's a two-part test.
His question is, then what are you?
Well, I think that at this point you've got a zoning, the Metro Council, in contravention, just understand, the reason we didn't brief this to you is this was raised to me at 12:30 today.
I understand that, but we wanted to hear this today, and we're hearing it today.
Listen carefully. First of all, this board does not regulate interest rates, credit scores, whose customers you have. That's not something that's subject to zoning regulation.
No, but I'm asking questions so I could figure out which category you fall into.
So
Mr. Herbert says you fall in one, and I'm asking you why he's wrong.
Given this restrictive regulation, is Metro empowered to declare illegal and non-conforming a financial institution that's regulated by the state of Tennessee, industrial?
But Mr. Mayor, you know we are not here to decide whether Metro is. We're here to decide whether he's right or wrong.
I don't make these decisions. If I don't make these objections, and Mr. Herbert and I have a good working relationship, and I realize you have a long docket and a hard day, but we've been sitting out there for 6 hours, and my client had to cancel a flight to New York, so we're inconvenienced too. So why? Excuse me, I lost my train of thought. I would not have interrupted and inconvenience Mr. Herbert for anything. And the reason I made that objection is the courts tell me if I don't make objections that they can be waived. So that's why we do that. Not to be rude, not to make him lose his train of thought. But I'm telling you, Mr. Chairman, there are other possibilities. One is just simply retail services. Another is general office.
Retail service? You're not retail services.
Well, I haven't got the definition. But if the council, by creating this restrictive category, has suddenly ignored a whole segment that's neither federally regulated, federally insured, but it's also not these sorts of urban blight generating.
That's why we have a zoning administrator, because he gets to interpret the law, and he interpreted it one way, and you're here to tell us why he is wrong, and that's what I'm asking you to say why he made a mistake.
My plea to you is to rule on my appeal, and if you rule in our favor, let Mr. Herbert make a determination that it is nevertheless a permitted use.
But I will ask you again, why is the zoning administrator wrong in this case?
I think I've told you. There's not.
You're just saying the code, the law doesn't have a category for you, but I'm asking you why he made the wrong decision.
First Franklin Financial Services business does not, nor Mariners, meets the definition of an alternative financial services, which is a prerequisite to applying the distance restriction. The second one is that the distance restriction only applies to businesses located on 2 different properties.
Okay, so Mr. Berry, he has 2 categories.
Okay.
Which category should your client be in?
I think our client would, per force, have to be if it's not an alternative financial service, it would have to be what's the other, financial institution?
Are you insured by the United States government?
No, we're not. We're not insured by the United States.
So how would you be in that category?
I say we, the tenant.
Well, how would you be in that category?
I think it would have to be then considered, either the ordinance is conceivably unconstitutional, but.
Are you a federally chartered bank, savings and loan, credit union?
No, we're not.
Okay.
I would say we're general, I would say we are some sort of general services. I don't have the other zoning categories at present, but I'm asking purely, asking that you make a decision tonight based on the appeal we have made and not on the...
We will make a decision what's on our agenda, and it's whether there's an item A case and whether the zoning administrator erred or not. That's what we are here for. Mr. Taylor.
You do provide financial services, correct?
Yes. Our potential tenant does provide financial services.
And so, I mean, I'm grateful for my Murfreesboro 7th grade English teacher that taught us how to diagram sentences, but right now, because the way I'm looking at this sentence is, and I'm going to just tell you before we get into discussion so you can respond, but I look at the sentence and it says basically, any, building, room, whatever, that provides a variety of financial services, and the establishment is not a state, federally chartered bank, mortgage company, et cetera, where it's insured, is the alternative financial services. The part of the sentence that says including but not limited to has including but not limited to, and it gives some examples. That's a description of the variety of financial services, but to me, it's important as an example, but it's not something that it reads to me as if these 2 categories are meant to imply if you provide financial services, you're one or the other. You're either insured or you're not insured. If you're not insured by an agency of the U.S. government, you're an alternative financial services. If you are, and you are a bank, a credit union, a mortgage company, or it says or any other financial institution, if you're insured by an agency of the U.S. government, then you're a financial, whatever the other category was. I can't remember. So, I mean, that's what why is that interpretation wrong?
I respectfully disagree with you about that. I think that we read the definition as being a two-part. There are 2 requirements to be an alternative financial services. We don't meet. I say we. Our tenant does not meet Part B because it's not federally insured. So let's look at: is it subject to this restrictive zoning provision because its business is as defined in part of the first part 1, the first part of the test, which talks about the sort of services you provide. There is a principle of statutory construction called, my Latin is so good, ius gem generis, which means when you use words in a series, cash advance, title loans, check cashing, pawn shops, and flex loans, a variety, when you talk about including but not limited to, and you use words in a series, then the other similar, if you're talking about what does it mean not limited to, what else could be considered, what other sorts of services, it's open-ended that you want to you must consider in construing that statute other things of the like, same type of thing. And of course, unless you mean all financial services of any kind, then you're limited to things that are like cash advance, title loans, pawn loans, and that type of thing, which Mr. Cherry has testified they get a full financial statement, just like, sure, their lenders are borrowers are higher risk than your average commercial bank, but they don't limit their business to payday loans where we're going to charge you a horrendous interest, and if you'll pay us back on your payday, you know how it works. So I think it's the zoning, the council has created an ambiguity, and given the principle that the property owner is entitled, or is in light of an ambiguity, should be entitled to the free use of their property, not completely free of zoning, but allowed to use their property, then you look to other general definitions in the statute. I mean, it does fall generally, if you don't mind, most respectfully, within the definition of retail service. It does fall generally within an office use for zoning purposes. Remember, zoning is, you're regulating external effects. You're regulating traffic, dust, noise, et cetera, et cetera. What goes on in that office, as long as it's legal, which it is, it's regulated by the state, that's not really the province of zoning regulation. Okay, I'm through, but I just want you to understand that I'm a little fired up about this because I don't want to lose these arguments, and I think they're important for us to preserve these arguments.
All right. No,
any questions for the applicant?
And then, do we have the appeal is for use classification and distance requirements? Is there another argument that we need to hear?
The distance. Tell us about the distance, Mr. Herbert.
The reason that it's structured that way on the docket, Mr. Taylor, is because it's an if-then. If, in fact, the board determines, yes, the zoning administrator was correct in assigning that use, then there is the secondary question as to whether or not the distance requirement comes into play, and if the staff, zoning administrator, in conjunction with the staff, determined incorrectly on that question as well.
All right, so we need to vote on the first one.
You say the zoning staff got it wrong on the first one, the second question is moot. If you say the zoning staff got it right on the first one, then you need to determine next whether they got it right on the second one.
Okay.
Anything else needs to be talked before deliberation? Okay, we're going to close the public hearing. Discussion.
I made my point, and I'd ask for you all to tell me if I'm wrong, but the way I read it and the way it was written or described by the zoning administrator is that, it's a variety of financial services and the establishment is not insured.
Right, and that's a big, and obviously that's a whole different class of institutions insured by the federal government, which all those things were put in place after the stock market crash and the Great Depression to preserve people's individual accounts, and that's credit unions, savings and loans, chartered banks.
So, I read it in the way that and I know that there are all kinds of new products that are introduced, and some of the products that they talk about have been around for a while, but I just don't see where the zoning administrator erred.
Yeah, I think, Counselor has a kind of beef with the Metro Council and the laws because there's only two categories, and I understand that, but basically that's what the zoning administrator had to deal with because our city has given two categories, and the category that most fits this institution, I don't think there is any ambiguity because this is not an institution that is insured by the United States government. It is not a federally chartered bank, savings and loan, credit union, mortgage company. And so I think it falls into the second category.
Yeah, I would say the way I read the sentence, they testified that they provide financial services and they're not insured, and I think
and their collateral sounds like collateral that often some of these title companies use. They admitted that they use car titles for collateral. They admitted they use items that, like equipment and vehicles that some pawn shops would possibly use too.
So I will move that the zoning administrator did not err in the land use classification.
Okay.
Want to add to it, then if that's the case, then it is too close and the distance.
Well, we haven't heard that. We haven't heard that argument
No,
yet.
I think that's just fine now. So that's the motion. Is there a second? Motion's been made and properly seconded. Any discussion? Seeing none. All those in favor signify by saying aye. Aye. Opposed? Passes 4-0. John Michael, is there any other business in front of the Board of Zoning Appeals?
Is it also the board's ruling that despite the fact that these businesses will both be on the same piece of property, that the statute apply, that the ordinance applies?
We have to determine.
Ultimately, the question before the board, phrased more appropriately as a board vote, would be a motion on whether or not the zoning administrator erred by determining that two such alternative financial services businesses shall not be approved on the same piece of property. Of course, you've heard Mr. Berry's arguments that it is on the same piece of property, not on separate pieces of property, and that therefore, in their opinion, it should be approved.
We haven't heard from you, have we, on that?
No, but I think that now that we've switched issues, I think that it would be fair to give Mr. Berry the alternative to make that argument, if you want to, Mr. Berry, to make that
Let's hear
argument.
from
We're focusing on this.
Let's hear from Mr. Berry about the distance
Very
argument.
quickly, I mean, just on the distance thing, it's simply that the plain language of the ordinance prohibits an alternative financial services establishment only from locating, quote, less than 1,320 linear feet from the property line of another property upon which another alternative financial services establishment is located. The ordinance does not prohibit a second financial services business, alternative financial services business, being located on the same property as another, which is the case here. I mean, the ordinance says what it says. It says two different property owners. Maybe the intention was to prevent the proliferation of these cash advance places where different owners would create an urban blight sort of situation with these sort of payday lenders. I don't know.
Okay, Mr. Herbert, the property argument here.
So, honestly, I don't disagree with what Mr. Berry is saying here. I will say this. I do not think that it was the Metropolitan Council's legislative body's intent to allow two alternative financial services within a quarter mile of each other, 1,320 feet. I do not think that was ever the intent. I think the intent was to establish that distance between these types of businesses. Now, it does say from the property line of another such establishment. This is a strip center type of situation. It's all on one parcel. It's all on one property. I'm not, everything that Mr. Berry just said, I'm not disagreeing with there. The language says what it says. I don't think that was the intent of council, but this is the same property, and that's what this ordinance says.
I think there's a grammatical argument that can be made for what you just said, but I think there's a logical fallacy in it that in other words, verbally you can make the argument, but mathematically you can't. And when one item cannot be a distance from itself, right? So if one institution has to be a certain distance from another institution, however you define that institution, whether it be the property, the building, the door, from the other building, property, or door, if it's one in the same, it cannot be a distance from itself. So therefore, that would leave you no guidance as to where it can be. So I don't accept the argument.
Okay. Any other?
You're agreeing with the zoning administrator.
His initial
initial decision, not the. I mean, the comment that said, "Hey, I understand the language."
I believe that. I think yes, I think they have to be on separate properties. I do not think that it even in plain text, I don't think it is allowing for two institutions on one piece of property. And I'm sure someone that wears a robe can make that decision, regardless of what we decide today.
But they had they had the opportunity to say limited to one per property and not
Or a simple distance without talking about property lines. They could have just said within 500 feet of each other, 1,000 feet of each other, whether it's same parcel or not.
I mean, maybe somebody, and again, what we're starting to do is start to speculate on what people meant, and I think that can kind of get you in trouble because it may have meant that they wanted it to be further because they thought, well, if I've got a big piece of property, it's got to be from the property line, and so that makes it even further apart. That may be what they meant, but what they said is what they
So on
said,
this issue, the zoning administrator does not disagree with Mr. Berry. Is that correct?
I don't disagree with what Mr. Berry is saying. The ordinance says what it says. I think I would be remiss in saying I do not think that this was ever the legislative intent. I think that the Metro Council established a quarter-mile distance requirement for a reason, but I cannot dispute anything that Mr. Berry is saying. That the language says what it says.
Okay.
So is it possible to have two financial institutions, as we're talking about, could they be in the same building?
Different ownership?
Ownership in the same lease space?
I mean, I see
Could it be two desks in one room?
I mean, I see this as almost the same issue. I mean, we've got multiple tenant spaces within a single parcel.
Clearly, I think the Metro Council passed this law to prevent concentration of these institutions, but as you mentioned, it talks about property lines, not just straight distance.
Well, and that may be, that may be a good case, moving forward. And today we just decide, do we, based on the zoning administrator's interpretation of the rule and ruling, as well as the admission that there are issues with the rule, what do we do? And
so, question for John Michael: do we have to rule on this part of we ruled on the first part and overturned, or we upheld the zoning administrator?
This is the second part of the appeal. To your question, do you have to rule on it? Eventually, yes. Even if you can't secure 4 votes in the same direction tonight, then it would be at a later date. But yes, the board needs to vote on that appeal.
Okay, that being said, does anyone have a motion?
I'll move that the zoning administrator did not err in his interpretation of the code in this matter.
Okay, motion's been made. Is there a second?
Second it.
Motion's been made and properly seconded. Any discussion?
he said did not err. Right.
Okay, any more discussion? Seeing none, all those in favor signify by saying aye. Aye. Opposed? 4-0, upholding the ruling of the zoning administrator.
That concludes our BZA meeting. Our next meeting will take place on May the 17th at the campus of the Fulton Complex in the Metro Office Building Development Services Center conference room.
Okay.
This has been a service of the Metro Nashville Network. If you would like to see this presentation again, or for more information about this and other programs, visit nashville.gov.